in the court now where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption's grip tight as a vice. In this endless trial we pay the price.
Heyo, and welcome to day 163. It is today the Max Schard show. Thank you. Thank you, Nutty Brunette. Been waiting for you. Yeah. Should have started earlier. Things got in the way. And now I'm here. A little late because something weird happened with the trial streams from Law and Crime, and it's a weird cut out in the beginning, but I found one that I'm not sure what happened, but I found on Fox 5 Atlanta that has it. So yeah, I'm not going to bore you with well, I hope I'm not going to bore you, so I'm just going to go right into it. Let's see here. There it is. I hope. Full screen. Dun dun dun. Closed captions. All right. Before this, they talked about the charges and what's going to be read, and I will get to that in due time. And on the start of the day, they brought up what happened yesterday with stuff. No, GG, Mr. Jingles did not have me tied up in the basement. Oh. Let's see here. There. All right. Now we are ready to go. The continuing. Yeah, one thing. I remind you all that Miss Vivorito is the final witness for the state. She's there to tie everything together in a nice little package, hand it over to the jury. So far, from yesterday, we know she can lie. We know she was the last person handling the missing jewelry. After that, it disappeared. And yeah, it's not looking that good. But remember, she is so important to this case. The Atlanta Police Department created a new position only for her. Let's see how that worked out.
Are both those mics Verita?
Good morning.
Are both those mics being used?
This one is.
Oh, it's fixed.
Yeah.
Okay. All right. Thank you. So, Investigator Viverito, where we left off yesterday, we were talking about a post that was captured by you that showed Quamarvius Nichols with some writing on the picture, correct?
Correct.
Okay. We are going to get back to that later.
Sure.
Okay. So we're going to switch to another topic right now. But it is about the post from March 2022 that you collected.
Okay.
Okay. The reality is in March 2022, you observed and collected some posts that you felt were relevant
Sure.
and that you felt were derogatory or mocking both the Christian McMiller and Darius Ford situation.
I'd have to see which posts were.
Well, we're going to get to individual
Okay.
posts, but some of the posts were derogatory and mocking Christian McMiller and Darius Ford.
Correct.
And then you also pulled posts that you thought were derogatory or referencing or mocking Shamel Drinks' dad. Is that
Correct.
correct? Okay. And let's be clear. As an investigator, you are not saying just because someone posts something derogatory or mocking or referencing the death of another individual, that means that they committed that crime. You are not saying that, are you?
That is correct.
Okay. And I just want to talk to you about a couple of these posts. I'm going to bring them up to you, okay? These are all this is a bundle of the posts that you collected that are in evidence, correct?
Sure.
All right, may I approach?
Yes.
For instance, you observed some posts that were made following the Christian McMiller Darius Ford double homicide
Correct.
on March 10th going into March 11th. And these posts were in the days following.
Correct.
Okay. Ms. Knight, could you do me a favor and publish what's been admitted as 457 VV? Okay. Investigator Viverito, this is a post posted by one ABG _ Big Nick, correct?
Correct.
And you know this person from the picture and also from his name on Instagram to be Nicholas Johnson.
Correct.
Okay. And in this post, when was this post collected by you?
That was collected ribbon around 8:20 on March 11th.
March 11th. Okay. So this is the morning after Christian McMiller and Darius Ford were gunned down.
The evening, 8:20 p.m.
Oh, I'm sorry. Okay. The evening after,
Correct.
about 20 hours after, 21 hours or 19 hours after.
Somewhere around there.
Okay. And this post includes a says slime and chalk.
Correct.
Okay. And you viewed this as a clear reference to Darius Ford and Christian McMiller being murdered in reference to a chalk outline of a body on the street.
Correct. Coupled with my knowledge and interactions with Mr. Johnson in the past, yes.
Right. I think you testified that Mr. Johnson, in your opinion, he's associated with Atlanta Blood Gang.
He's documented as a member, and he's also a fixture at 12 Atlanta daily.
Okay. So you saw this post, posted the next day, referencing the death, mocking slime and chalk. Mr. Johnson has not been charged for the murders of Christian McMiller and Darius Ford, correct?
Correct.
And the reason he hasn't been charged is because posting something like this, while it is insensitive, while it may be wrong, it doesn't mean that he killed Christian McMiller and Darius Ford, does it?
Correct. There's other things we would look at, like if he was in the vicinity of the murder on camera, coupled with a post that's not great, that would be something we take into consideration, but that didn't happen.
And Investigator Viverito, I knew you were going to be dying to say that, and we are going to talk about all the surveillance videos and all the sensitive, while maybe
I'm sorry, I want to hear that again.
thing like this, while it is insensitive, while it may be wrong, it doesn't mean that he killed Christian McMiller and Darius Ford, does it?
Correct. There's other things we would look at, like if he was in the vicinity of the murder on camera, coupled with a post that's not great, that would be something we take into consideration, but that didn't happen.
And Investigator Viverito, I knew you were going to be dying to say that, and we are going to talk about all the surveillance videos and all of the situation involving Mr. Drinks when I get to it, okay? But I'm asking you specifically about posts. Posts that is not a confession to killing Darius Ford or Christian McMiller, is it?
Absolutely not. But as an investigator, you need to look at things as a whole to piece things together, leading you towards suspects.
Okay, and that's why you collected this.
Correct.
Okay. Ms. Knight, I'm going to ask you to publish 462 VV.
I'm going to play this in normal time because this is too good to have sped up. Yeah, she is desperate to get a
462
narrative
VV
in
is
here.
2 posts that showed up on this page labeled Joey_Hurst24, correct?
Correct.
All right, and on the left is Christian McMiller,
Correct.
and on the right is Darius Ford.
Correct.
And they're fairly self-explanatory. They're mocking the death of Mr. McMiller and Mr. Ford, correct?
Correct.
All right, and this was posted when?
I'd have to see the file name.
Okay, so you're not, and that's fine. Was it posted after the death of Christian McMiller and Darius Ford?
Yes.
Now, I understand your belief is that this is a trolling page or a fake page. Is that correct?
It's a page. Yes, it's a page that we had not seen surface really or be vocal until this point.
Now, and certainly when you see a page like this, there are certain investigative things that you could do to try to determine who is behind this page, correct?
Correct.
You could subpoena Instagram, you could check IP addresses to see who set up the page, etc.
You could.
Okay. You or anyone else that you know of did no such thing to try to determine who Joey Hurst was, the
No.
government name. Okay. And the reason you didn't, and I'm not trying to beat you up, the reason you didn't go through those steps, if you thought this was a confession, and you thought this meant that Joey Hurst killed Mr. McMiller and Mr. Ford, you certainly would have gone through those steps to uncover who it is behind this post, if you thought that was the killer.
If I thought that was, but the investigation led us to other suspects.
Okay. The bottom line is you did not view these posts as signifying that whoever was behind this account was the killer of Mr. McMiller and Mr. Ford. You didn't view it that way.
Correct. The individuals that were making posts who we deemed as suspects, they were further investigated, whether it be cell phone extractions or social media.
Okay. 456 VD. Please, Ms. Lynn. Thank you.
She doesn't even realize that he is leading her down a trap. She is so bang on her narrative that nothing else matters. And he's just locking her into that. So when it will become, because we all seen the video. We all seen it. It does not depict what Bad Santa Cowboy Cop claimed it was.
Okay. And this post was collected on March 11th, 2022 at 11:30 p.m., correct?
Correct.
Okay, so again, about a day after Mr. McMiller and Mr. Ford were killed.
Correct.
Okay, and you testified on direct about what you thought new op pack just came in. It's kind of like we're smoking on our ops.
Correct.
Okay. Certainly not kind, not nice, not sympathetic, and it's showing approval for what happened, correct?
Correct.
Okay. And this page is another one that you didn't know the government name of the person behind it.
Correct.
Okay, and you didn't go through any investigative steps, or anyone else that you know of go through any investigative steps to determine the person behind it.
Correct.
Okay, and the reason again is because this post, you didn't take it as a confession. You didn't take this post as saying, I'm the person who did it.
Correct.
Okay, cool. Finally, we're going to talk about Kelvin Watts.
Okay,
Okay, Kelvin Watts has not been arrested for the Christian McMiller or Darius Ford murder, has he?
he has not.
Okay. And this has all happened 2 years ago at this
Correct.
point. Okay. Really 2.5 years ago, more than 2.5 years ago. Mr. Watts made several posts regarding the death of Darius Ford and Christian McMiller.
Correct.
Okay. Ms. Knight, could you please publish 473 VV for me? Okay. In 473 VV, that's posted by Shell Kell Nutlight, correct?
Correct.
And you know that that'd be Kelvin Watts.
Correct.
And this was posted shortly after the death of Christian McMiller and Darius Ford.
Correct.
Okay, and this actually depicts Mr. Donovan Thomas.
Correct.
And underneath Mr. Thomas's left eye are 2 shells.
Correct.
Okay, and as an investigator, you're aware of like prison tattoos or eye teardrops under an eye, correct?
Yes, that's what I spoke about on direct.
Okay, right. And you took this as kind of a play on the teardrops under the eyes of 2 shells indicating 2 bodies, Darius Ford and Christian McMiller.
Correct. The first time we started seeing the 2 shells under the eye was after the death of Christian Ford and Darius McMiller, I think in days following.
Okay, Ms. Knight, could you please publish 461 VV? And here's another picture of Shell Kell or Kelvin Watts that posted shortly after the death of Christian McMiller and Darius Ford, correct?
Correct.
Okay, and these are, you got to look a little close, but I see the big shell off of his hair, but then there's 2 little shells under his left eye.
Correct.
Okay, and again, that's a post that you interpreted to be a reference to the death of Christian McMiller and Darius Ford.
Correct.
Okay. Ms. Knight, if you could publish 454 VV, please. Okay, in this post, again, shortly after the death of Christian McMiller and Darius Ford, correct?
This was in the hours after they were killed, yes.
And this is on Kelvin Watts' page.
Yes.
And again, we see the 2 shells.
Correct.
Okay, and that had significance to you because there was 2 dead bodies.
Correct.
Okay, thank you. And 460 VV, please, Ms. Knight. Okay, again, here, this was posted shortly after the death of Christian McMiller and Darius Ford.
Correct.
And we have 2 shells, right?
Correct.
And we have a smiley face, except the lips are zip tied or zipped up, I guess,
Correct.
and a black heart.
Correct.
Okay, and this was on Mr. Kelvin Watts' page.
Correct.
All right. Also, and Ms. Knight, thank you. Also, you're aware that Shell Kell or Kelvin Watts has made a song that references Christian McMiller and Darius Ford, correct?
He may have.
You never heard Mafia Story by Shell Kell and Third World?
I haven't, but it would not surprise me if he did.
I heard my ops died like some thoughts, referring to 2 snakes dying with their eyes wide open and their tongues out. Crime scene nasty in a fast car, died in empty traffic.
That sounds about on brand for Kelvin Watts.
Okay, and that was a reference to the Kia Stinger, the fast cars Kia Stinger that Mr. McMiller and Mr. Ford were in.
That sounds about right.
Were Mr. McMiller and Mr. Ford riding in a Kia Stinger?
They were in a gray and color Kia Stinger.
Okay, and were they in fact shot on the highway?
Yes, they were on the highway.
Okay. Mr. Watts, despite these 4 posts that you collected and this song, has not been charged with the murder of Christian McMiller or Darius Ford, has he?
No, he has not, but that's also an open investigation that's not assigned to me. So
Since when has that mattered to you? You weren't assigned the Donovan Thomas murder either, and yet on direct examination, you were singing like a canary in a mine.
So, but the answer is he has
He
not
has
been
not.
charged. And it's just 2 years, 8 months later.
it's still an open active investigation.
Right, and you've had these, you collected these postings that Mr. Watts made way back in March of 2022.
Correct, but so investigations, just the social media posts aren't enough to arrive at probable cause. You need him maybe on video at the crime scene, before that murder, things of that nature. So if social media was enough for probable cause.
Have you looked for it, Miss Burrito? Or you just don't care because it's not a trial yet, so you haven't really bothered?
A lot of people probably would have gone to jail for this, but we don't do that.
Right, because there were a lot of people posting on social media.
Correct.
A lot of people posting horrible things on social media.
But unfortunately, nobody was on camera at the scene or there. Or there was no Niven.
Investigative Viverito, I know that you have come with an agenda today, and I know that you want to talk about the security cameras, and we will absolutely talk about the security cameras. I promise you.
Commentary. And, well,
I'm
there's commentary going on both sides. Answer the question that's asked.
okay. I want to.
Did Miss Viverito just cough at the judge? Yeah, that will get you favors. Did you just against the judge? Yeah. Oh, you're in for a good time.
Clean up some. We're going to shift off of social media, and we're going to get to the wiretaps.
Mhm.
Okay, I want to clear up some issues, or not issues. I want to talk about the wiretaps and what we talked about Friday and yesterday. You had a wiretap. I understand you had one on Mr. Sumlin's phone. I'm not going to be talking about Mr. Sumlin's phone. I'm talking about Demekion Garlington. Okay?
Okay.
All right. Do you have the number for the total number of calls recorded or listened to during that wiretap?
I don't know off the top of my head.
Okay. Was it in the thousands? Is that fair?
Probably in the thousands, yes.
Okay. Do you know how many total calls Mr. Stillwell was a party to?
I couldn't give you a number, but it would probably be not as many as others because he went into custody, I think, within 6 days of the wire going up.
Fair enough. And just so we're clear, when you apply for a wiretap, you send something to the phone company, correct?
Correct.
And the phone company is told not to inform anyone about the wiretap, certainly not to inform the subscriber.
Correct.
So no one, to your knowledge, no one told Mr. Garlington that he's being recorded,
Correct.
okay, because that would defeat the purpose of the wiretap, right?
Correct.
And to your knowledge, no one told anyone else that there was a wiretap on Mr. Garlington's phone.
Correct.
Okay. Now, the state referred to the calls that were played for the jury yesterday as a sampling. What was played to the jury wasn't exactly a random sampling of the calls, was it?
No, all of the calls were turned over, and it's my understanding that they had to be narrowed down.
Right. The state, in preparation of your testimony, they gave you a CD or some sort of flash drive with a number of calls that they chose and asked you to review them, correct? So you could speak intelligently about them.
Yes,
Okay. So it wasn't a random sampling, it was calls that the state chose to focus on.
it's my understanding that the prosecution and defense decided on what could and would be played. So it wasn't just random, let me pick 20 calls out of a bag. It was calls that were relevant to the
Right.
case.
Yeah, right. I'm just saying it just wasn't some random sample.
Correct.
It was focused.
Correct.
Okay. And so let's talk about some of the calls. We're going to talk about specific calls in a minute, but if you go back to what was played yesterday on that wiretap of Mr. Garlington's phone, there were calls, repeated calls about keeping Miles Farley, who's a small man, right? He is a small gentleman, physically small.
Small, yes.
Okay. Talk about keeping Miles Farley from being violated or attacked at the Rice Street Jail, right? We heard several calls about Miles Farley and keeping him safe.
Correct.
Okay. We heard call, and do you have the call logs in front of you or anything?
I do not.
Okay. When you were testifying yesterday, what were you using to keep track of what calls which?
I didn't have anything in front of me.
Okay. Well, we heard call 2532 from April 3rd, 2534 from April 3rd, 2628 from April 4th, 3501 from April 13th, and 3697 from April 14th, all about Miles Farley and being in jail. Do you remember those 5 calls?
I do.
Okay. Was Shannon Stillwell a party to any of those calls?
He was not.
Okay. We also heard a call 3683 from April 14th about, and you could probably tell me who the people were. It was Demekion Garlington and someone about flying a drone into the jail, it seemed.
Correct.
Okay. Was Shannon Stillwell a party to that call?
He was not.
Okay. Then we also heard about,
Hey, Gigi. Says, oh, did she just lie again? Oh, well, yes, she did. Again, she has this weird mental disorder happening within the Atlanta Police Department. It's cross amnesia or cross lionitis, which means you either don't remember or you lie about it, but only in cross examination.
Demekion Garlington going on and on about running into someone named Blizzy at some hotel in Cobb County.
Correct.
Okay. To your understanding, was Shannon Stillwell present for any of those events in Cobb County?
No, I believe he was in custody.
He
at
was
the
in
time.
custody. So he wasn't involved with any of those things that Demekion was talking about, running into Blizzy in Cobb County.
Correct.
And then we also heard a call between, I believe, Demekion Garlington and Antonio Sumlin. And it sounded, and this was call 3171 and 3172 from April 9th, about seeing someone wearing some jewelry, and they were asking if you have a slider car with paper tags. It sounded like they were trying to come up with a way to commit a crime, a robbery, right?
Correct.
Okay. Was Shannon a party to that call?
No.
Okay. And Shannon was in jail at that time, correct?
Correct.
Okay, so he was not involved in that situation at all either, correct? All right, cool. All right. I'm going to talk to you about specific calls that have already been played. March 14th, 2022 at 9:59 p.m. It's call 335, okay? It's a call where you testified, I believe, and correct me if I'm wrong, it was a call between Demekion Garlington and a gentleman named DeMarco Boyer.
That is correct.
Okay, and that's at 9:59 p.m.
Correct.
Do you know how many 9:59 and how many seconds? Are you aware of that?
I would have to look at the log for the seconds.
Okay. And in that call, Garlington instructs Boyer to switch to video.
Correct.
Okay.
Yes,
Now-
it's liabilities. Thank you, Starfish and Coffee. She's clearly suffers
Based
from
on your
liabilities.
investigation, you said Boyer was at the gas station,
Correct.
and you also said, well, you were about to say, and then I cut you off. Boyer, your investigation has concluded that Boyer was in Mr. Nichols' car.
Correct.
Okay, so, and you're basing that on your investigation. You're also basing on the fact that Miles Farley in that video, when he goes back to the car, gets into the back seat at the BP.
That and there are calls from the wire that
Okay,
say that he's in the car. Yes.
fair. So this call at 9:59 between Garlington and Boyer, your investigation is Garlington, this is your investigation, is Garlington is in Mr. Stillwell's rented white Audi,
Correct.
and Mr. Boyer, who's not charged in
Correct.
this case, is a passenger in Mr. Nichols' Ford Fusion.
Correct.
Okay, white Ford Fusion.
Correct.
Okay. Your investigation based on the the time on the surveillance video from the FedEx surveillance is that the shooting happened around 10:01 p.m., correct?
I don't know if it's based on the time on the FedEx video.
Okay, well, what's your understanding of when the shooting occurred? If you know.
I don't know how they arrived at 10:02, but I know that's when both cars pull off shortly thereafter. Within probably a minute or two, the cars pull off from the gas station.
Okay. Now, what I want to know is, it's a matter of timing. The 9:59 and however many seconds that this call is made where eventually Garlington tells Boyer to go to video. That 9:59 and however many seconds is based on the clock used during your wiretap. That's where we get that time, right?
Correct.
Okay, so that's based on the wiretap time. Okay. So, and then of course, after they hang up, then do you know if there was a subsequent video or FaceTime call?
I believe you could see the data transmission come through
Okay, and do you know how long that call was or when exactly when it took place?
immediately after, but I would have to look at the log.
Okay. And my question is, we have three different sets of time here. We have the wiretap time,
Correct.
we have the FedEx video time,
Correct.
and we have a BP video time.
Correct.
Okay. Are any of those, to your knowledge, are any of those three separate surveillance systems synced up?
They're not. So typically what you would have to do is go back and sync them because I know the wiretap is a constant. I know that's an accurate time.
Okay, so you know, and that's fine. So you know the wiretap is an accurate time, but we don't know if the FedEx is an accurate time or the BP is an accurate time.
I have to look at the timestamps on both.
Okay, so I guess what I'm getting at is we can't just go by the BP time and go to 9:59 and however many seconds and say, oh, that's when that call was placed.
I went off of the wiretap data.
Right, exactly.
Correct.
Right, and that's what you were in charge of the wiretap. You went, but I'm going to go back to my question, and that makes complete sense to me that you went off the wiretap time. But we cannot go back to the BP and look at the BP at 9:59 and however many seconds and say that's when this call was made, because those two timing systems between the wiretap and the surveillance might not be synced up.
Correct. I'm not sure if they were or they weren't, but typically that's something I double check.
Okay. And the same thing for the FedEx. We can't look at the FedEx time and just go to 9:59 and however many seconds and say, oh, this is the exact time when that call was between Mr. Garlington and Mr. Boyer, between those two cars was made. We can't do that, can we?
Correct. I go with what I know to be constant.
Gotcha. So all you're saying is 9:59 on the wiretap.
Correct.
Awesome. Okay. Mr. Atkins or Miss Knight, and I should ask you, could you please publish what you played yesterday at call 350? I'm going to ask the questions first. Thank you. So, yeah, I'm going to give you a couple minutes. All right, I'm going to talk really slow because I got to give Mr. Atkins a couple minutes. Okay. So we listened to another call at 2:01 a.m. between. Do you know who that call was between?
I'd have to hear it.
Okay, well, I'm gonna cut to the chase. You said in court that you heard someone say, "Riding by the scene."
I don't know if I said that verbatim, but they're riding back through, I think is the direct quote.
And you said the scene.
They may have been riding back through the scene.
Okay, well, do you now know what call I'm talking about?
I know which call you're referring to, yes.
All right, and if you and do you know who the speakers were?
Well, if it's from the wiretap, one would have been in Garlington.
Right.
And then I believe the other one may have been Boyer. I have to hear the call. I don't want to misspeak on it.
Okay, and people were fussing with each other. Someone was fussing with someone about not having a ride to get back to where they needed to go. Is essentially the gist of the call, correct?
Correct.
All right. Now, if you could play, if you could publish
Let's see what was really said
whatever,
on that call. No? Let's see what really was said, and if she, Miss Burrito, was telling the truth on the stand.
yes, if you could just publish, and I'm going to stop after about 40 seconds.
Bro, who that was? Nah, the nigga Ray got it, not Dan shit got
Okay,
it.
could you pause it?
Oh, for real?
All right, now, Miss Investigator Riverito, do you know who the speakers are?
I believe it's Boyer, but I need to hear a little bit more. That was kind of muffled.
That's fair. All right.
Yeah, this is the wrong call. They got the
Miss-
wrong one first.
If you could.
Yeah, RP, the YP Ray. Yeah, I don't even know him. That who got his chain snatched? That who changed Lil J5 to Jason? Oh, for real? Yeah, the YP Ray nigga. Oh, I ain't even know that. Yeah, that little PLK nigga. Oh yeah, I had Lil J5 with me last night. That's probably what it was. Yeah, okay. Yeah, that who changed it. Oh damn! What I say? Yeah. Buddy came and followed me. I followed his ass back. Hey, talking about what's fuck wrong with him? What you talking about? I'm trying to get the other care data address right quick and care address. He testing the young crew. Somebody he finna send a bit. For real? Somebody he gonna send a bit somewhere late where the spot at.
Okay.
Yeah. He told LJ you got liquor last.
20 seconds. And my notes might be wrong, but I don't think they are. Yeah, 20 seconds. Could you tell me when you hear anything about the scene?
Go
Oh,
ahead.
for real? Yeah, the YP Ray nigga. Oh, I ain't even know that. Yeah, that little PLK nigga. Oh, yeah, I had Lil J5 with me last night. That's probably what it was. Yeah, okay. Yeah, that was
Oh, no, I'm sorry. Yep, okay, I'm sorry. You're going by the different number. 201. Right, it's the call 350. All right, here we go. This is the one I meant to pull up for you, Investigator Viverito.
Yo. All right, man. There's all kinds of shit, man. I just jump in the other car, bro. Y'all niggas don't be getting dropped off and they ain't got no motherfucking ride to go back home to. That don't make sense. Yeah. The fuck you getting dropped off for a nigga ride with a nigga who wrote you? Yeah. That's stupid as fuck. So, you need to be on the gun or something. What's on with? We right here down here. Yeah, what? Ride past trying to see.
Okay, stop. Did you not just hear him say riding past through the city?
He said riding past trying to see.
Okay, but Miss Burrito, neither of those are what you testified to. Is it? Neither of those are what you claimed just a minute or so ago. Isn't that weird? That on the stand, you change your mind.
Well, where's the scene?
I said,
You said scene before, now you're saying trying to see, and I'm saying city.
you may have misunderstood what I was saying. Or you got to understand when these calls come in, when you click on the call, it will also provide a map of where they are, and the next call may show where they traveled to after that. It's my understanding that he traveled back towards that area.
Okay, so towards the area, you mean the city? It's in the city,
They never
right?
left the city.
Okay. Investigator Viverito, you previously testified that he said going to the scene, and now you're saying to this jury that he didn't say scene, he said see. Is that correct?
I don't know if I said he said, I don't believe I said he said he's riding through the scene. He may have rode back. I believe he was traveling back towards the scene.
And I know you're an expert, but
Oh, at this point, Mr. Schard is using this completely as shade. We all know you're an expert, but
if the jury listens to this and hears city, is that okay with you?
But that's not what's said. So I would clarify for them.
I understand that you want to tell everyone what's said here, but you've already given two different stories. You said scene, and then you said
What's your
see.
objection? Argumentative. Overruled.
It's
oh, Miss Burrito, when you scoff at the judge, Miss Burrito, Judge Whitaker is already really annoyed with the prosecution. Now, this shouldn't affect her rulings. Shouldn't. And then on top of her being really, really annoyed with the prosecution, you scoff at her. Yeah, that's when you get overruled on these objections. Let's go back.
Everyone what's said here, but you've already given two different stories. You said scene, and then you said
What's your
see.
objection? Argumentative. Overruled.
it's
Can we just go by what we hear?
he,
Is that okay?
sure.
Thank you. Okay, call 416, and I don't need this published. Thank y'all. It's from the early morning hours of March 16th, 2022. Okay, there was actually two calls that were played. Do you recall?
Correct.
Okay, one is Mr. Garlington and someone that you say is my client, and the person's whispering. I'm not even going to dispute it. Okay,
Okay.
we'll just say it's my client.
Okay.
Whispering about hiding in the crawl space.
Correct.
Okay, and then the second call is Mr. Garlington and my client talking about what just happened.
Correct.
And of course, what just happened was the house was shot up, and then a bunch of police officers showed up, and No one was arrested.
Correct.
Right. Okay. So, and that was the same day, of course, that you spoke to Shannon Stillwell. You put him in the back of the police car, or someone put him in the back of the police car, and you spoke to him, and he told you he was, in fact, driving the white Audi.
Correct.
All right. So, that call, let's just review some things that were discussed by Mr. Garlington and Mr. Stillwell. They talked about their amazement about not being hit by any of the bullets that were fired into 2830 Waters Road, correct?
Correct.
They talked about their amazement that the police let them go from that location.
Correct.
They talked about how they hid from the police.
Correct.
Mr. Stillwell talked about being placed in the police car.
Correct.
Mr. Stillwell said that he denied knowing Mac Main when asked and said he was from Thomasville.
Correct.
Okay. That was misleading, right?
Correct.
Because he does, in fact, know Mac Main.
He does.
All right. And Mac Main, just so we're clear, is Christian McMillan.
He is.
Yeah. And he talks about getting out of there as soon as possible. Like speeding away because he couldn't believe that y'all, the police, let him go.
He does, but he says prior to leaving, he collected his FN and his rifle or stick out of, and he left.
I'm going to get there. Okay. And they talked about seeing you too, right?
They did.
All right. So let's talk about, I know he, in that call, and clearly I'm getting there, he talked about sneaking his FN away from the scene, right?
Correct.
And about sneaking his stick out of one of the cars. I think the gray car.
Correct.
All right. Okay. Now, the FN, you've testified, you know that an FN 57 is registered in Miss Taisha Alexander's name, correct?
Yes.
Okay, and that gun was located at Meadowlark Drive on March 17, 2022,
Correct.
correct? The next day after this call.
Correct.
All right. Does that FN shoot .40 caliber bullets?
Does not.
That could not have been the murder weapon for Shamel Drinks,
No.
could it? Okay. He talks about taking a stick from a car on the scene, right?
Correct.
And you know the stick to be an AK-47 type assault rifle, correct?
Could be an AK-47. It could be an AR-15. It could be, it's a rifle.
Typically shoot 7.62 caliber bullets.
Correct.
Okay, not 40 caliber.
Nope.
Okay, so you would know that that stick that he talks about taking from the scene once you guys let him go is, in fact, not the weapon used to shoot Mr. Drinks.
Correct.
All right. And in this call, where, again, you don't have any reason to believe Mr. Stillwell knew he was being recorded,
Correct.
or Mr. Garlington knew he was being recorded. In this call, he never talks about taking any other guns from the scene.
Correct.
Okay. Okay. Call 2119 is another call that was played. It's from April 1st, 2022 at 12:29 a.m. It was a call between Demekion Garlington, who's on the wiretap, and Shannon Stillwell, who's in jail at this point, correct?
Correct.
Okay. And Demekion is on his normal phone, and you testified that Shannon Stillwell, when you're in the jail, you said there's wall phones, right?
Correct.
Okay, and that's, the jury has heard those recordings where they talk about Securus and this phone will be recorded, and they are in fact recorded.
Correct.
Okay. Mr. Stillwell was not on a recorded line.
Correct.
He was on a cell phone from the jail.
Correct.
Okay, so he, in common sense, he doesn't know that Demekion Garlington is being wiretapped. the cell phone he's using from the jail is being recorded.
Correct.
It's fair to say that they believe that they're having a private communication that is not being recorded.
Correct.
All right. Mr. Atkins, could you do me a favor? This call 2119, and I'm talking about at 12:29 a.m. Could you play on April 1st, 12:29 a.m.? I'm just adding. Okay, yes. You know how to make consult with it?
Yes.
And we're just going to cue that call up, okay? And I'm going to ask you some questions about it.
Sure.
And if you could cue it up to 2 minutes and 40 seconds. $240.
I don't tell them for, bro. I'm like, shit, what the hell they locked up for? Like, they just saying about it. I'm like, bro, they good. I'm just like, they gonna assume some shit like that anyway. Yeah. They gonna assume that, like, oh, like, y'all ain't did nothing to him, so.
That's what I keep telling goddamn Lil. I keep telling him like, just chill. Like I know,
Yeah, cause they
this
saying
ain't
he panicked.
nothing. Yeah, I'm like, this ain't nothing, bro. Like they just doing that cut. They seen it as a goddamn gas station. Like just chill. You see what I'm saying?
Yeah. Yeah, man. That's what I'm telling. I keep telling him all the time. Shit. I'm like, listen, bro. Just like you, like, bro. I'm telling him, probably in the cab. Listen, bro. No. Just tell him before you don't want to talk, bro. Like,
Not one word.
yeah.
Go down or what they try to portray or what they say, man. Don't say shit.
Yeah. I ain't know that though. So I didn't.
And you can keep that up because I'm going to ask you to play another part. But thank you, Mr. Atkins. So on that call, again, neither party has reason to believe they're being recorded. That's Demekion Garlington and Shannon Stilwell.
Correct.
And they talk about they going to assume shit.
Correct.
Mr. Garlington says, y'all didn't do nothing.
Correct.
And then Ms. Silva says, they just saying it because they seen us at the gas station.
Correct.
Okay. Mr. Atkins, if you could please play 11:20 at 11:28.
Yeah, man. What the hell Trim and you still in the yo?
Yeah. Okay, what is that?
You know what I'm
Yeah, see.
Who? Yo folk.
Yeah. Okay,
Mr.
what is that for them?
Yeah, what we are seen with Miss Viverito and with Mr. Bad Santa Cowboy Cop and Mr. Velasquez and most of the cops, with a few exceptions, in this trial is liabilities and cross amnesia and it's apparently very common in the Atlanta Police Department that if they think they can get away with it, they will lie on the stand. And if they can't, they will develop cross amnesia during cross examinations. And I assume it is because they are very, very used to lawyers that defense attorneys that are taking a paycheck. They are there to cut a deal and stuff like that. They are not used to being questioned. So when they do, they don't know how to handle it. So they either develop cross amnesia or liabilities. And
We're
that
gonna come back to that one because I want to get the timing right.
Okay.
What's that?
Okay.
Okay, and that is, okay, and we're gonna come back to that call. But let's talk about Mr. Stillwell's phone that was collected,
Sure.
okay? Do you know, you're able to view, so you collect the phones, Detective Leon Packer, he dumps the phones, and then you're able to view the phones, what the contents of the phones through a program called, what's it called, XRZ, is that correct?
XRY.
XRY, okay. And you get just a whole bunch of information that's in whoever's phone. Pictures.
The contents of the phone are organized by category.
Right, and we're talking about pictures, text, emails, instant message, call logs, location, data, internet searches,
Correct.
notes.
Correct.
Okay. And if you don't know, that's fine, but do you know how many texts or calls total were in this phone?
I don't know off the top of my head, but it would be listed on the extraction, on the front page of the extraction. When you open it up digitally, it'll give you what you're going to see initially is it's everything by category. So it'll say 20,000 texts, 100 calls, things of that nature.
Okay. Ms. Knight, if you would please display 227 VV82. Oh, Ms. Knight. VV8.
And hello for you who just joined, because I saw a little spike in viewers. We are recapping what happened up until the feed was cut off. I already know that it will be cut off. I will then go to Miss Sylvia's stream to catch the final minute and a half. After that, they go to lunch. Now, I contacted Kathy Russon on Law and Crime. They had a camera issue. They, at least about half an hour ago, they were rushing there with new equipment to set up. So somehow, some way, we will get to the rest of the day. Hopefully. And as somebody in the chat said earlier, see who on the prosecution's bench just leaned over and stretched towards the cable. I'm just kidding. There's no such things. And yes, I do not have midstream ads. I don't believe in it. For me, it's a bit annoying, so I don't use it. To you either. All I ask in return is thumbs up and subscribe if you haven't yet. And now, Replay Crew. will get an ad every 20 minutes, half hour, or something like that. But that is for replay crew and nobody else. Okay. And hey, speaking on ads, here's Mr. Jingles. I don't know how that is related. Oh, hello, Mr. Jingles. This is Mr. Jingles. He is, as you know, our fearless leader of the Mr. Jingles Viking Thug gang. Yeah. We are with we are not a criminal enterprise, of course, and you are joining not by bashing, not by applying. You're joined automatically by being here. We have a sister organization in the Cat Not Williams Slime Crew or Slat Crew over at her channel. And none of us are responsible for each other's words or actions. So we are not an unindicted co-conspirator. Oh. Oh, yeah. Yes. Oh. Are you trying to get in my lap? That's a bad idea. No. Up again. All right. Back to the trial. And yes, as Gigi so kindly says, tips are appreciated, but never mandatory. So if you are so inclined, you have the option of Super Chat, gifted memberships, or via PayPal. Never mandated. I will be here anyways, but it's appreciated.
EVA 2. 227. A. Okay, this is one of the text messages or one of the text conversations that was introduced on Friday, I believe. Correct?
Correct.
Okay, and this is from Mr. Stillwell's phone.
Correct.
All right, and in his phone, Mr. Stillwell's talking to, is that D, do you know that number to be Demekion Garlington?
I believe so, yes.
Okay. Because there's a couple of D's in this case, but you believe this to be Demekion Garlington?
He did change his number right before the wiretap, so I believe that's the number before.
Okay. And if you could zoom out a little bit, Ms. Hilton. Oh, Mr. Atkins, so we can see the whole conversation. Thank you. Thank you, Mr. Atkins. So in this conversation, to add context, Mr. Stillwell is indicating that one of his two phones is at Big House.
Correct.
Okay. Do you take that to be Darius Ford's house? And again, let's be clear, this conversation occurred December 24th, 2021.
Okay.
Okay, so we're talking about 3.5 months before any of this involving Christian McMiller's death or Darius Ford's death or Shamel Drink's death occurs.
Correct.
Okay. Do you take that to be Big's phone? Is there another Big? Do you not know?
There is another big.
Okay. So, but in any event, Mr. Stillwell is saying he left his phone at someone else's house.
Correct.
Okay. And then D says, finna take it in where you at, indicating that he's taking Mr. Stillwell's phone, right?
I don't take that as taking the phone, like finna take it in, like I'm finna go to sleep or go home.
Fair enough.
Like take it in for the night.
Fair enough. Could you go down, Mr. Atkins? Okay, and this is the part that the state introduced. Okay. He says, if Polka asks, tell her I'm op hunting. Okay, he did not say I'm op hunting.
Correct.
He said, if Polka asks, tell her I'm out hunting.
Correct.
Okay. And Polka, you know to be who?
Taisha Alexander.
And that is Mr. Stillwell's girlfriend at the time.
I guess, yes, I don't know. Yes, at
Something
the time,
like- something like
sometimes, yes.
And you also know from your review of the calls that Mr. Stillwell was having some issues with fidelity.
Yes.
Okay. So he's just saying, if Polka asks, tell her I'm out hunting.
Correct.
All right, thank you, Mr. Atkins. Mr. Atkins, can we go back to that call? I think I finally got my stuff together here. Okay, remember that call that we were just talking about with, and just to review, it's Garlington and Mr. Stillwell, and they were talking about people were going to assume things,
Hi, Dave.
and they're just saying it because they saw us at the gas station.
Correct.
Okay, I want to play, Mr. Atkins, if you could start playing it. I guess we could start at 11:28. Yeah, 11:45. Yeah, that's fine.
Yo, folk.
Yeah. I was there with him yesterday.
Yeah.
Yeah, he got out of town now. So he's gonna get ready to come back. I was just gonna lie with his ass.
Yeah. You ain't talked all night. That whole night crazy, bro.
Yeah, I just talked to her today. I talked to her today.
Man, that be
I
crazy.
was telling her, I'm like, he on the cell phone, like, he probably be over there, like, what not? She's like, what? You ain't think you gonna tell on me? I'm like, man, hell nah.
Shit crazy. I don't even be texting that back no more.
I should be texting on, like, on the tablet and shit.
Yeah, I don't even be responding to that. That's crazy.
Yeah.
Hey, look, I'm finna get bro back his phone, right? I'm gonna get up with you though.
I do that, man. I got you.
Love you. All right.
I love you too.
All right.
All right, well, okay. Let me just ask you this, and we're going to get it together, and we're going to get it played. Do you remember on that call, that same call, that unrecorded call? I mean, that these two gentlemen thought that they were talking to themselves without being recorded. Do you remember Mr. Stillwell saying, when they test for gunpowder, it's going to come back clean?
I do.
Okay, and that's on this call.
Correct.
All right. And he does not say the car has been cleaned.
Correct.
He's saying, don't worry about it because when they test for gunpowder, it's going to come back clean.
Correct.
Okay.
One thing when it comes to cleaning, it leaves marks. If the lab personnel says, well, we couldn't find any gunshot residue, but we found the stench of bleach, or it was clear it's been cleaned. But no, nothing of the sort from the lab techs. Because if it's cleaned, it has no traces of anything else. Like just average use. You would see slightly different, it's less dusty. It would be apparent that it has been cleaned. No such thing from the lab techs. Just no traces of gunshot residue.
That was on the private call between Mr. Stillwell and Mr. Garlington that they had no reason to believe was being recorded.
Correct.
Okay, I'm going to go back to the phone. You made note of 227 VVB11, and we don't need to display it, but it was basically something in Mr. Stillwell's notes that said, pop my shit. I really got options. Poor little ops. They be dropping.
Correct.
Okay, and that was in March 15th, 2022 at 12:52 a.m. The phone says that that's when it was entered.
It might seem either modified or entered, yes.
Okay, and that was, and we're going to get to it, but you're aware that Mr. Stillwell's grandmother, Betty Jackson, texted him about the shooting, about seeing it on the news that night? Well, it's going to be in evidence. I'm asking if she's aware. You're aware of that?
I was aware that Miss Alexander notified him about a shooting in Mechanicsville. I don't know if Miss Jackson did.
Okay, it was hours. This would have been hours after Miss Alexander alerted him as well. Correct.
Okay.
Correct.
I'd have to see it. I'm not.
Okay. All right. Well, we'll get to it. But this was at 12:52 a.m.
Okay.
Right.
I haven't seen it, so I just.
Okay, and we've already discussed ops,
Correct.
dropping ops. Those are common themes, common topics of drill music, correct?
Correct.
Okay. And at the time, your investigation, at the time that he entered this note into his phone, he was in fact at the studio, correct? At 12:52 a.m. on March 15th.
After leaving the gas station, they went to a studio. I did not have location data on Mr. Stillwell to say, but I believe they should have still been at the studio.
Still been at the studio creating music when he entered that note.
Creating music, hanging out. Like, yeah, that's what they do. Hang out at the
Okay.
studio.
All right, cool. And then you talked about search words, a search that you noted about a Windsor Street shooting, right? That was in Mr. Stillwell's phone.
So he didn't, and I clarified that on direct. He
Right.
didn't search Windsor Street. He searched Fox 5
Okay.
and then
Well-
clicked on, and then within Fox 5, then searched the Fox 5 website.
I appreciate that. So on 3/17 at
Yeah, but the prosecution in their argument is that we found searches for that specific crime. And now Miss Burrito is there on the stand saying, well, he went on Fox 5 and then clicked a link. How about that? You could have saved everybody a lot of time by actually saying that from the beginning, prosecution. Because you knew that information was about to come through this witness. But no, you had to elicit false information from other people.
2 in the morning, Mr. Stillwell clicked on the Fox 5 website to this article.
Correct.
Okay, didn't search, your testimony, he didn't search words like Windsor Street or anything, but he clicked on the article and that's what shows up in the phone.
I'd have to see the screen. I believe he searched Fox 5, traveled to the Fox, like say I open my phone and I want to go to whatever web,
believe?
Amazon. I search Amazon, click on Amazon, and then on Amazon, I would then search. That's what happened. So
Who the frick does searches via Amazon? Or is she just describing how you search for a certain term, for example, at Amazon, and then click on the link? Oh, God.
searched for Fox 5, went to Fox 5, then went on Fox 5, I believe searched Windsor Street shooting, and then clicked on the article, is what it looks like.
Okay, and Miss Knight, could you just display 227 VV88 so everyone knows what we're talking about? Okay, so this is what you're talking about, right? The search.
Correct.
Okay, that's and this is 3:17 at 2:31 and 56 seconds in the morning, correct?
Correct.
No, that's
Yeah. That how she described those the search, simply not true. You had the actual expert. Well, sort of. You had a person testifying on the stand about how that could have happened. It is, and there are different versions. My interpretation of what actually happened is that on the front page of Mr. Stilwell's web browser on the phone, he has local news. Many of us have that on our phone. All of a sudden, it says on that, oh, shooting at this and that street. He clicked that link, and it ended up there. But the phone registered it as a search.
I want to show you some documents, investigator.
Sure.
Okay, now I see here from Thugger Daily that when the feed cut out, now this feed, luckily Miss Sylvia had the rest of the things on her, so we will go to that one so we can watch it. But Mr. Schard concluded his cross-examination right maybe a couple of minutes after all the feeds cut out, and so then it's redirect however they can redirect, hopefully this recross as well, because Miss Ivorito has already lied on the stand, obvious lies. How can they make that not happen? And then you still have recross. So yeah, today we will finish off the state's case in chief. I don't know what happens next. Doug Weinstein said he won't bring on a case in chief. I don't know if Max will.
Approach, Honor.
Yes.
So we might be
Investigator,
running
I know
towards
you're familiar
closing arguments later this week.
57A, DS57A, DS57C, and DS58. Could you look at these and tell me if you recognize?
Sure.
Yeah, I know. Daily quick bites. Hey, Santa Laws. Yeah. Starting December 1st, this channel will have a slight transformation. What you now know as Nick, that's me, will be Santa Laws. But we're still a couple of weeks away from that.
Okay, these are excerpts from Mr. Jackson's phone.
Right, and those are, and are those excerpts from, are those conversations from the data that was downloaded from Mr. Jackson's phone?
Sure, the first one is the one that I spoke about that I had seen of Miss Alexander informing him about the shooting.
It's not admitted, yes.
Oh, sorry. Yeah.
Are those accurate representations of the data that was in Mr. Stillwell's phone?
Yes.
Okay, Your Honor, at this point, I would move to admit DS57A, DS57C, and DS58 into evidence.
Oh, let's see if I still have this or. Oh, yeah. Do you want to know my honest opinion about Miss Vivorito? As Santa Laws, this is my honest opinion. She is a ho ho ho, says Santa Laws. Oh, I'm having way too much fun with this.
A,
Christine.
C, and E. Say that again, please, if you don't mind.
And there is no DS57B. It's DS57A, DS57C, and DS58.
Oh, okay. Don't know where the E came from. Okay. Those are admitted.
Mr.
Okay. Daily Quick Bite says to Dave, with Hilton, don't think so. Max and Doug aren't going to rest without putting on some sort of defense, and Hilton is going to take forever in rebuttal. I think this is the strategy from the defense is with this last witness, get as many lies from her as possible, which they have. Then the previous witness, bad Santa cowboy cop, who didn't even notice the third car in the video. And Doug Weinstein have already stated on an interview last week that he probably will not put up a case in chief. We haven't heard from Max Schard yet if he will put up a defense case in chief. Because if they don't, the state can't rebut. There's nothing to rebut if they don't put up a case in chief. But I would expect something from Max Schard. Some kind of actual gang expert. Even though that opens up for the state's gang experts to return. But then again, it will give Max and Doug the chance of recross on cross-examining them again. Gigi says, did you all notice the third car at the gas station? Yeah. We all noticed that very probable, the third car seen on the end of that video who sped up, when is the probable shooter, in my opinion. We all saw the videos.
Mr. Kokomo, could you please, permission to publish, Your
Come
Honor.
here.
Mr. Kokomo, could you please publish 57A first? So in this, in DS 57A investigator, this is a conversation between Taisha Alexander, also known as Polka, correct?
Correct.
And Mr. Stillwell.
Correct.
Okay. At 3:14:22, at 11:01 p.m., Miss Alexander reaches out to or texts Mr. Stillwell and says, "You okay? Somebody just got killed in the Ville. Ugh." Or ugh. Atlanta, too much right now, right?
Correct.
All right. And then they respond to each other with kisses. Mr. Stillwell asks who got killed, correct?
Correct.
And then Miss Alexander eventually says, "I don't know yet." But before that, she sends some sort of screen message, correct?
Correct.
Okay. And that's at this, the message is sent at 11:19:47 p.m., correct?
Correct.
All right. And Mr. Kokomo, if you could publish 57C. And this is the screenshot that, or the picture that Miss Alexander sent to Mr. Stillwell at 11:19 p.m., correct?
Correct.
And it's a photo, and is that Windsor Street?
I believe so.
And it's captioned, "Somebody just got killed in Mechanicsville."
Correct.
And it's posted by someone named Ori Billions.
Correct.
And whenever Ms. Alexander sent this picture or downloaded it, it already had 2,000 views, correct?
Correct.
All right. So by that night, just based on what we see in this phone, by that night at 11 o'clock or 11:15 or 19, the word had spread about a shooting, correct?
Correct.
In Mechanicsville,
Correct.
where someone was killed.
Correct.
Okay. And this was not a secret. It was being spread throughout social media.
Correct.
Mr. Kokomo, if you could post DS50.
Oh. Look at so picture somebody just got killed in Mechanicsville. Oh God. Shaking my effing head. And then Micaiah, that's crazy because somebody got killed in the same spot last night. Wait a minute. Where who was that the day before? The same spot. Who was killed at the same spot? That would be interesting. Is it a local gang just driving around shooting people? We don't know because they never investigated if those killings were connected. Why didn't they? Because Shannon Stillwell provably couldn't have been at the shooting the day before.
This is a conversation, and I'm sorry, it's marked 58A, so Your Honor, if we could just amend that to make 58A.
Sure.
Thank you. So looking at DS 58A, this is a conversation between Mr. Stillwell and Boss Lady, correct?
Correct.
And you know Boss Lady to be Betty Jackson, correct?
Correct.
His grandmother.
Correct.
His grandmother who raised him.
Correct.
At 11,
Oh,
Mr. Thank you. At 11:19 p.m., Shannon texts his grandmother, "I love you."
Correct.
Boss Lady or Betty Jackson responds, "Mama love you so much, heart, heart, kiss, 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 because you're my sweet thing."
Correct.
And Mr. Stillwell says, "Yeah." I don't know if I'm pronouncing that right, but yeah, right?
Sure.
And then Miss Jackson gives a thumbs up, right? And then at 11:26:57, Miss Jackson says to Mr. Stillwell, or texts Mr. Stillwell, "Hope you are not near Windsor Street shooting on the news," right?
Right.
And then she says, "Answer me, please."
Correct.
And eventually at 11:41, 15 minutes later, Mr. Stillwell responds, "I'm at the studio, Mom."
Correct.
Okay. So, at 11:26, according to this conversation, not only did Miss Alexander alert Mr. Stillwell about the shooting on Windsor Street, but Miss Jackson says there's a shooting on Windsor Street, right?
Correct.
And it's on the news.
Correct.
Was this information about the shooting on the news at that point?
I know that the article that Miss Alexander had, that's a female, I don't know her real name, in Atlanta, that wasn't like an ATL scoop or a news thing. And then I don't know how Miss Jackson saw it, so I'm not sure if you got word of mouth from Miss Alexander, word about it.
The question was really simple. Was this on the news? The answer is really simple. Yes, it was. The answer is real. She actually already answered the question with he went to Fox 5, clicked on a link, and there was the news. So yes, the news was already out. Oh, and thank you, Nutty Brunette, for gifting a membership. Ayo. First off today, bringing new members today. 1. Oh, thank you so much, Nutty Brunette. That is so nice of you.
I don't
Maybe
know.
she saw it on the news. Maybe
I don't know when the news coverage began.
Okay. The bottom line is, by 11:26 that night, 2 different people had informed Mr. Stillwell about a shooting, a death, Windsor Street,
Correct.
and the word had spread throughout. It wasn't just Mr. Stillwell that was being informed. The word had spread throughout the Atlanta community that quickly.
Correct.
All right. And basically, the phone indicates on March 17th, 2 days later, Mr. Stillwell clicked on a news article about that shooting.
We sought out the news article and then clicked on it.
Okay.
Yeah.
He sought out and clicked on it.
Correct.
All right. Cool. All right. Right when you started testifying, you remember when you were going through a timeline, and I think it was from 2019 to 2020, different events that had occurred?
I do.
And we heard a lot of names, Tanquarius Mender, right?
Correct.
And you said he's a member of the Rolling Crips.
As well as YSL, yes.
Okay, and we heard about Stephen Harris,
Correct.
and he's a Crip. And we heard about,
No, I'm sorry, Stephen Harris is a member of YSL.
okay, he's a member of YSL. We heard about Marcus Sims.
Correct.
He's a Crip.
Yes.
Okay, we heard about Wayne Alford. And we heard about a bunch of other names in this
Correct.
timeline that you were going through. Well, first of all, let me just ask you this. When you were asked about all these events, you were referring to some sort of, you were refreshing your recollection with a sheet that was in front of you.
Correct.
Okay, that was highlighted, color-coded.
Correct.
Okay, did you create that sheet?
Mr. Abadi had created the sheet as a timeline.
Okay, so when you were testifying about those events, you were refreshing your recollection. You were being asked questions by the prosecutors, right?
Correct.
And then you didn't have any reports of your own with you, did you, about any of these events?
No, I didn't. I was at the GBI at that time and they were APD cases, so they wouldn't be my reports.
So you didn't investigate any of these events?
So the way it would work is gangs typically doesn't take an aggravated assault or a homicide or things of that nature.
Again, Miss Vivorito, this is a really simple question. You weren't refreshed by your own stuff. You were refreshed by a timeline thing that Mr. Abadi put together. That's not refreshing your recollection about what you independently worked with. Jesus Christ.
We will work with those units and provide them information and assist with their investigations. So the reports, I will help with the cases, but they would fall with those investigators.
Did you have any reports with you when you were of your reports with you when you were discussing those?
No,
But you were refreshing your recollection off of a sheet of paper that was prepared by the prosecutor.
well, this is something we had discussed, that there's numerous incidents, so we needed a timeline to keep them correct.
That's not refreshed. That is memorizing. You got a piece of paper with a timeline from the prosecution that they wanted you to testify about. That's not refreshed. That's not independent recollection. That's memorized.
All right, well, let me just ask you this. In all those things, 2019, 2020, that you discussed, all those events, Shannon Stillwell wasn't charged with any of those events, was he?
He was not.
Okay, cool. You remember when you talked about how I was asking you about your reports and you said you write them in search warrant applications?
Correct.
All right, I want to talk to you about that. You did a search warrant application for the house of Jeffrey Williams on 355 Allison Drive, correct?
Correct.
Not moving any evidence. I'm going to ask you some questions about that affidavit. Would having your affidavit that you wrote
Sure.
up there with you, would that be helpful?
Sure.
May I approach?
You may.
Okay. These affidavits that you fill out to take to a judge to try to get a search warrant, they're under oath?
Yes.
Okay. A judge relies on them, relies on the accuracy of them, correct?
Correct.
Relies on them to be complete.
Correct.
The intent of an affidavit is not to mislead a judge, is it?
No,
Okay. And you wouldn't mislead a judge, would you?
I would not.
Okay. And you filled out this affidavit on May 9th, 2022, correct?
Following the presentation to the grand jury, yes.
Right, May 9th, 2022?
Correct.
And that was also in the wake of these various attacks on Lucci, on Rayshawn Bennett in the jail,
Correct.
okay? In fact, you were interested, you had that one with Jaden Myrick, with Mr. Eppinger and Mr. Sumlin, and Mr. Eppinger was trying to get Mr. Sumlin to talk to someone to get payment, right? And you suspected that person to be Jeffrey Williams.
Suspected, and that was confirmed by Mr. Sumlin.
Okay, so you suspected that to be Jeffrey Williams.
Right, and was confirmed by Mr. Sumlin, yes.
Okay, again.
Yes,
just
I
please,
suspected,
just
yes.
questions I asked, okay? So you saw a search warrant for Jeffrey Williams' home for evidence on these matters, correct?
No,
Okay. You saw the search warrant for Jeffrey Williams' home.
for his body, for his cellular devices, and for gang evidence.
Okay. So in Mr. Williams' home.
Correct.
In your affidavit is what's used to develop PC or probable cause for the judge to rely on, right?
Correct.
And in your affidavit, I think it's in the 4th page. You reference a post that you saw on the internet about Jeffrey Williams posting YFN, and this is already in evidence. YFN, if ain't like what you do for your mother and kids, I would have been killed you, right?
Correct.
That's referenced in your affidavit.
Which page is not on 4?
Well, mine's not numbered, but I'm just gonna go by. Right, it's on the 5th page, I'm sorry. If we count, and again, they're not numbered, but I'm just going by the 5th page that I have.
So
And it would be the first, it would have been the 2nd full paragraph. So there's 1 sentence and then 2 paragraphs down.
1, 2, 3, 4, 5.
You can look at my, may I approach?
Yes. Okay, that's different than what I have.
You reference seeing on XXL, this magazine, you reference seeing this post that Mr. Williams supposedly made, correct?
Correct.
Okay, and that made your affidavit because you thought that was important to show Mr. Williams and his veiled threats to Mr. Bennett, correct?
Correct.
Okay, cool. Can I have that back? I'm just gonna need it.
Sure.
I'll bring it back to you. Now, you also, 2 pages after that, whatever page you have it, I have in the beginning, it says details 4.
I'm gonna have to see the page because these pages are out. Whatever I have is not the same as yours.
You can-
Okay. No, I see that one. Okay. I got you.
All right. Also in your affidavit, you include a text thread between Mr. Wooney Lee and Mr. Williams, correct?
Correct.
And as part of this text thread, you draw the judge's attention to a specific line, correct?
I included that amongst other things in the affidavit. Yes.
Well, there's one particular line that you put in a bigger font and you also circled it, or it's circled, correct? On these,
It's circled. Yes.
okay. And you circled it to draw attention to it, correct?
To what I was referring to. Yes.
Yes. And the line that you circled to draw attention to was YSL rule the world, kid, 24M on an N head, correct?
Correct.
Okay. And you wanted to highlight that passage said by Mr. Williams in the text thread, correct?
Correct.
You wanted to highlight that for the judge.
Amongst other posts. Yes.
What was he referring to? Why did you feel it important to highlight 24M on an N's head to the judge?
Well, he's referring to YSL ruling the world
Yeah.
as an organization, and it could be a play on words or a play on things that have happened, saying 24M on a racial expletive head.
Okay, 24M.
She's lying here. Now we all know what the 24N is about. The issue here is, does she know what 24N is actually the meaning of it, but she's lying about it to get a search warrant.
On a racial expletive head. It sounds like Mr. Williams had money on someone's head.
It could be taken that way, yes?
It could be taken that way, and you highlighted it and circled it for the judge, correct?
Correct?
Okay. And you believe that too. You wouldn't have misled the judge about what was being discussed, would you? You believe that to be a threat, didn't you?
I didn't say it was a threat. It's saying that he's willing to, that's how they talk. They'll talk about, they have the ability to put money on people's heads.
Okay. Mr. Kokomo, could you please publish Jeffrey Williams 3 and 4? Is that right? Okay. Could you please publish Jeffrey Williams 3? Oh, before you do that, in this thread that you highlighted in your affidavit to the judge, this thread between Wooney Lee and Mr. Williams took place on February 7th, 2021?
Correct.
Laugh always happen. They already established he was talking about the 24 million jewel on Lil Uzi's head. Yeah. Lil Uzi had a $24 million diamond implanted in his forehead. We know that. The defense knows that. The prosecution knows that. And the jury has been told that. But what did Miss Vivorito tell the judge? And did she know at the time what was referenced? I say she absolutely knew. Absolutely. She knew exactly what the 24N on a guy's head meant. It was a $24 million jewel that's Lil Uzi had implanted in his forehead. But in the affidavit, she was talking about ruling the world. I actually have it here. Hold on. I have that part here. Hold on while I bring it up. Here it is. Let's see if I can make it bigger. Well, of course not. She says here, in a conversation thread from February 4th, 2021 to February 7th, 2021, Jeffrey William brags that YSL rules the world and has $24 million. Jeffrey William then tells YSL members to pay him directly, and he pays for everything already for members. This shows Williams' leadership role within the enterprise, directing the actions of YSL members and obtaining profits from the enterprise. This is her affidavit, from her affidavit. We know this is a complete fabrication. Complete fabrication. It is, for us, it is very obvious, but the jury needs to know it as well. And thanks to good representation from the defense, they now have been told this. They have been shown the diamond in the forehead. But Miss Vivorito can't help herself. She really can't. She sticks to it. She doubles down, even though she knows it is false. This is what makes her a liar on the stand under oath. And that is why nobody, nowhere in any investigation she has ever been a part of should trust her word for it. Should trust her word at all. Because here she is, with all the facts in front of her, still lying. Yeah. Good point here. Good point here from Heather Mosher. He is proving to the jury how far she will go to lie under oath. And she will go everywhere, anywhere, with anyone.
You just started over, Mr. Kokomo, with volume.
Oh, sorry. Crap. Wrong button.
They put 24M on the front of your head. Y'all young hoe get in line. Flying rule the world. Believe it. Y'all niggas got this motherfucker spending 24 million on their heads. They put 24M on the front of your head. Y'all young hoe get in line.
Okay, and could you please publish Jeffrey Williams 3A?
No music in that clip. No, I know. Yeah.
You see,
That is Young Thug reacting to Lil Uzi forehead bleeding after getting a $24 million diamond implant. She knew this. She's been aware of it, and she still lies about it under oath on the stand.
what's displayed is Jeffrey Williams 3A.
I do.
Okay, and it's a reaction, Jeffrey Williams reacting after Lil Uzi Vert put a $24 million diamond into his head.
Correct.
Okay. Did you know about Lil Uzi Vert and the $24 million diamond and that reference when you filled out this affidavit?
I did not, but I would still stand by what I put in the affidavit.
Okay.
She didn't at the point of her affidavit. I don't trust her. And even with the facts in front of her, she still can't stop lying. She is mentally incapable of not lying on the stand under oath. She is so invested in this garbage that she is presented as evidence, that she is prepared to this day to lie under oath about it.
Okay, so you're telling me right now, on a sworn statement to a judge with knowledge, that Lil Uzi Vert just got a $24 million diamond put into his head the days before Mr. Williams typed that, you would still put that quote, YSL ruled the world, 24 million on an end head in that affidavit?
Objection. Vague, compounded, maybe mischaracterization of what the witness just said.
Overruled.
I did not have knowledge of Lil Uzi Vert getting a diamond in his head.
Okay, so all right, so let me ask that last question again. Instead of saying I would do it again, if you had knowledge that Lil Uzi Vert just got $24 million diamond in his head and that Mr. Williams was referring to that, would you still have put that in the affidavit
Yes.
to mislead the judge?
Not misleading. May I explain?
Yes.
Okay. What I'm saying is this social media direct message is different than what you see on here. Lil Uzi Vert, I don't remember, is a member of YSL. So I think it might be a new, like a term they're going to coin, like wipe his nose, things of that nature. So 24 on somebody's head might be a new thing that they're going to go with. He's saying YSL rules the world. As the leader, he can make that assertion.
You're doing a lot of explaining. Did you do any of that explaining in your sworn affidavit to the judge?
The sworn affidavit reads, Jeffrey Williams brags that YSL rules the world and has $24 million.
Okay. And clearly, when you put highlighted and circled 24M on a N's head, you're sending a message to that judge, are you not? Let's be real.
I'm referring to my words that I wrote say, Jeffrey Williams brags that YSL rules the world and has $24 million.
All right, and just so we're clear, as we sit here today, as someone, a law enforcement officer even with knowledge of this, you would still put that in front of the judge.
There are different interpretations to everything as we've seen throughout this whole trial.
I agree. Can we make our determinations, or are you going to make the determinations for us?
Objection, arguments is sustained.
Do you think maybe you misinterpreted what was said by Mr. Williams? Is that a possibility?
I think it differs from what was presented on the internet and between direct messages, as we've seen.
So your answer is no. Your interpretation is perfect, pristine.
My interpretation was YSL rules the world, and they have $24 million. That's what I wrote in my words in the affidavit.
She can't stop herself. Faced with facts, she still tells the jury, ignore facts. Ignore it. Listen to my words, that vomit-stricken pus garbage that exits my mouth. That is what you should believe, not the facts right in front of you. Miss Viverito, how can you... well, we know she can live with herself because she's done this her entire career. Lying, embellishing, exaggerating. She's done it her entire career because it have worked all this time up until now. And she just admitted that she would, with all the facts, she would still put those words to the judge. Lying to a judge.
I didn't say Mr. Williams has $24 million on YF and Lucci's head. I didn't say that. I said YSL rules. He claims that YSL rules the world and has $24 million.
No, you didn't say it. You just put in a bigger font and circled it for the judge, right? Right?
It wasn't a bigger font. That's how the message reads. It's the same.
Okay, McMaster says Rwanda. Okay, let's listen to this piece again.
I kind of made a mischaracterization of what the witness just said.
Overruled.
I did not have knowledge of Lil Uzi Vert getting a diamond in his head.
Okay, so all right, so let me ask that last question again. Instead of saying I would do it again, if you had knowledge that Lil Uzi Vert just got $24 million diamond in his head and that Mr. Williams was referring to that, would you still have put that in the affidavit
Yes.
to mislead the judge?
Yeah, she answered. She answers it. Clear cut. Even with the knowledge of the $24 million diamond in Little Uzi's head, she would still represent to a judge that Mr. Williams has 24 millions. She would still actively misrepresent, actively lying to a judge to get a warrant.
I'm not misleading. May I explain?
Yes.
Okay. What I'm saying is this social media direct message is different than what you see on here. Lil Uzi Vert, I don't remember, is a member of YSL. So I think it might be a new, like a term they're going to coin, like wipe his nose, things of that nature. So 24 on somebody's head might be a new thing that they're going to go with. He's saying YSL rules the world. As the leader, he can make that assertion.
You're doing a lot of explaining. Did you do any of that explaining in your sworn affidavit to the judge?
The sworn affidavit reads, Jeffrey Williams brags that YSL rules the world and has $24 million.
Okay. And clearly, when you put highlighted and circled 24M on a N's head, you're sending a message to that judge, are you not? Let's be real.
I'm referring to my words that I wrote say, Jeffrey Williams brags that YSL rules the world and has $24 million.
All right, and just so we're clear, as we sit here today, as someone, a law enforcement officer, even with knowledge of this, you would still put that in front of the judge.
There are different interpretations to everything as we've seen throughout.
Now she backpedals. Whoopsie, whoopsie daisy. She's backpedaling. No, she answered that question clearly. Yeah. And as we've seen throughout the trial, yeah, she's been watching all of it. Now she's she had a Daubert hearing. As an expert, she can watch testimony. What she can't do is watch other coverage of this. She can't watch it. Well, she can watch it through Law and Crime because they don't have commentary. But she already admitted she is checking at least Twitter.
This whole trial.
I agree. Can we make our determinations, or are you going to make the determinations for us?
Objection arguments is sustained.
Do you think maybe you misinterpreted what was said by Mr. Williams? Is that a possibility?
I think it differs from what was presented on the internet and between direct messages, as we've seen.
So your answer is no. Your interpretation is perfect, pristine.
My interpretation was YSL rules the world, and they have $24 million. That's what I wrote in my words in the affidavit. I didn't say Mr. Williams has $24 million on YSL Lucci's head. I didn't say that. I said YSL rules. He claims that YSL rules the world and has $24 million.
No, you didn't say it. You just put in a bigger font and circled it for the judge, right? Right?
It wasn't a bigger font. That's how the message reads. It's the same font as the date and time, the same size as the date and time as the name, the Instagram handle.
In the circle?
It's circled, correct.
Let's talk about you, Ms. Knight. Could you pull up 227 VV A6B? Thank you, Ms. Knight.
I'm just hoping that the jury really takes everything here to heart, that they get the same interpretation as we get.
Yesterday, you indicated that, now this is from a video.
Correct.
With Mr. Nichols
Correct.
rolling a blunt.
Correct.
Okay. And then there's other individuals there, correct? Correct? There's other individuals in the room?
Correct.
Okay. And then it's on Mr. Stillwell's phone, so you're presuming that Mr. Stillwell was filming the video?
It was filmed from his device. So yes.
Right. Okay. So yesterday, you made a claim that a gun, well, what did you say? A gun is, I don't want to jumble your words. What are you claiming about the guns on this table?
A gun is what?
You identified or thought a gun was consistent with something?
It could be consistent with a Glock 27.
Could be consistent.
Correct.
Okay. And which gun is this?
The one towards the back right here.
Okay. Could be consistent with a Glock 27. All right. It could also, well, first of all, are you a firearms expert?
I'm not.
Okay. You're just someone who's owned a Glock before.
Several, yes.
Okay. And
Take what she just said in mind, if I remember correctly. She's owned several Glock.
before yesterday, had you ever made the claim that, oh, I reviewed this video and this appears to be a Glock 27?
That was my first time testifying yesterday, so where else would I make?
What about reports? Did you ever write a report and said, I reviewed this is very important. I reviewed this video that was in Mr. Stillwell's phone, and I believe that could be consistent with a Glock 27.
Well, while reviewing the evidence in preparation for trial, when I took a better look at this video and found it was probably 2 or 3 days before I testified. And that's when I first had to really research through and look at photos and kind of isolate what kind of gun that was.
So the answer is no, you didn't write a report.
No.
Okay. And certainly the first time saying it to me or anyone on this side was yesterday in court.
Correct.
Did she tell the prosecution that she could? That would be a Brady violation if she told the prosecution, hey, I did this, and they didn't turn it over. Brady.
You say it looks like it could be consistent, or it could be consistent with a Glock 27 based on the shape of the bottom of the grip. Is that
correct?
Okay. It could also be consistent with a Springfield firearm, correct?
I'm not familiar with the Springfield, but from how the magazine looks, also it could be consistent.
In order to exclude other guns, you need to compare with other guns. You can't just look at a Glock 27 and say, oh, it's consistent. First of all, consistent is, I hate that word in legal settings, because it could also be consistent with a broomstick. It could be consistent with a BB gun. If you only compare with those two things, or as blind as I don't know, Bad Santa Cowboy Cop. I hate that word. It means absolutely nothing. But it sounds like it means a lot.
With a Glock.
Okay, it could also be consistent with a 6 Sauer. Could also be consistent with a Smith & Wesson, correct?
I'm familiar with a Glock.
Right, because you're not a
First of all, L. Allen, thank you for your super chat. $5. Mods Appreciation Tuesday. Yes, everybody say thank you to my amazing mods. I mean, we have GD, we have... Who do we have here today, by the way? We have GD, Laugh Always Have Fun. Ghost is not here today. And the rest of them. Everybody say thank you to the mods for keeping us somewhat in check.
Or could also be consistent with a Smith & Wesson, correct?
I'm familiar with a Glock.
Right, because you're not a firearms expert. You're only familiar with these Glocks.
I never claimed to be Mr. Schard.
Okay, well, you start identifying guns in court, kind of making yourself an expert, but you're not an expert, are you?
I'm not.
Okay, and you don't even know, whatever this gun is, if Mr. Stillwell left with that gun or didn't leave with that gun. You don't know if anyone left with that gun. You don't know whose gun that is.
Correct, but we don't know that they didn't.
Okay.
We don't know that they didn't. That's not how you prove something. That's just that's middle school drama. And thank you to Brooklyn for gifting a membership, which brings us total to 2 gifted memberships today. 2 new members. Thank you so much. Thank you so much. And while we are at it, No Weapon Formed Against Me gifted another membership. Thank you so much. Bringing the total to 3 gifted memberships during this stream. Thank you so much. Thank you.
Let me ask you this about your Glock 27 that you say this looks consistent with. When you shoot your Glock 27, does it expel shell casings?
I don't own a Glock 27. When I was purchasing a subcompact Glock, I was going back and forth between the 20.
Wait a minute. Didn't she just testify that she owned... Well, no, she said, I owned Glocks. Indicating the Glock 27, and that's why she could identify it. And now all of a sudden, she never owned a Glock 27.
I don't own a Glock 27. When I was purchasing a subcompact Glock, I was going back and forth between the 27 and the 43. I prefer to shoot a 9mm, so I went with the 43.
So you don't even own a Glock 27?
I just said when I was researching the 2, handling the 2 with the gun dealer.
So now you don't own a Glock 27. You were researching it, which means you were handling the gun at the gun dealer. That's your experience with the Glock 27.
I never asserted that I owned one. I've seen one. I've handled one. I can recognize one.
So you've handled one at a gun dealer, and that's what you're basing the identification on.
I've recovered a good bit of guns in my career. I know what they look like.
All right, let me ask you this. Since you know about guns, at least through your career, Glock 27s, when you shoot them, do they expel shell casings?
Yes.
Okay, Glock 27s, when you shoot them, do they make a loud bang?
Yes.
When you shoot a Glock 27, does it create a muzzle flash?
It should. I mean, when you shoot it, like during the day, you wouldn't see it, or sometimes at night you can see it. But
okay, and when you shoot a Glock 27, does it emit gunshot residue?
If it's inside of a contained area, yes. It would.
Okay.
No, Miss Vivorito, it always ejects gunshot residue. the question isn't if it's traceable in a closed container. The question was, does it eject? You absolute buffoon! How can you speak and breathe with that pea brain?
All right. Remember on Friday, you talked about you get to the end of an investigation, something seems small is huge. And we're
Correct.
talking about the post. All right. Well, there's one thing, surveillance video. You would agree that starts huge and remains huge? Like
Every-
surveillance video is a pretty important part of the case.
Every investigation is different, but yes,
Okay. You've seen the BP video, correct?
I have.
And you've seen it, Detective Hogan showed it to you?
He did for the purpose of identifying the individuals, yes.
Right, okay. Have you seen the FedEx surveillance video?
I have.
Okay. I'd like to watch it with you. Is that okay?
Sure.
Mr. Kokomo, if you could keep it up.
What Miss Vivorito has is something that is called the Dunning-Kruger syndrome. It is when you believe that you are smart, when in reality you are not. So that makes you think, since you believe you are that smart, you only work with certains. You can't work with abstract. For instance, in this case, he was so certain it was Shannon Stillwell that she mentally blocked out any other possibilities that it could have happened in any other way. Because she's a moron. But she doesn't know she's a moron. She's too stupid to know she's a moron. That is why she works with certainties. Even though it's laughable, it's comically obvious to the world, she has no fucking clue what she's doing.
Okay, before you start, Mr. Kokomo, investigator, when did you first see the FedEx video?
It was after I met with Investigator Hogan in the afternoon of the 16th, so it would have been after that.
Okay. Well, are you aware that, and maybe this will help you answer this question, you're aware that Detective Hogan swore out warrants against my client without ever viewing the FedEx video?
I can't speak to what he did or did not do.
Okay.
Oh, but you will. Oh, but you will. You will speak about what he did and didn't do.
When did you most recently watch the FedEx video?
Probably maybe like a week ago,
Okay. How many times in total have you watched the FedEx video?
a few times.
A few times. When you say a few times, how many is it?
And I've watched it a year ago, or a couple years, like 2 years ago. I watched it.
Mr. Kokomo, if you could please publish.
Let's see what we all seen before, the FedEx video. Okay, here around a few minutes from now, this feed stops. So let's go to Miss Sylvia's. Everybody go subscribe to Miss Sylvia if you haven't done it yet. Without her, this part might have been lost forever. The final minutes of Mr. Schardt's cross-examination and the beginning of redirect. And hello, everybody from Megan Fox! We have a Megan Fox. Oh, hello, folks. And just so you know, we have for the past 2 hours been watching an absolute moron investigator trying to testify on the stand. Watch it with the knowledge that this person, Miss Vivorito, suffers from the Dunning-Kruger effect. She's too stupid to know she's a moron. And Max Schard here picks her apart on cross-examination. But thank you so much, Megan, for the raid. Thank you. That is so nice of you. That is so nice of you. I've been on Megan's stream a couple of times, and I need to have her here for a Friday panel show. She is so funny. We can talk about hair. So yeah, if you have the time, you can play it in 1.5 speed until you catch up. It is amazing what the absolute numbskull investigator Vivorito is. And folks, just so you know, you who just joined, how absolutely damaging this is. Miss Vivorito is the person who trains the other gang experts in. And I didn't know you could actually talk and breathe without a brain. But Miss Vivorito have proved me wrong. All right. Let's now see this footage of the alleged, of the ending of Mr. This is with It's No Bloody Scenes. It is the scene where the prosecution claims there are 3 cars involved. Well, 4. The victim's car, 2 of the defendant's cars, and 1 car that makes a U-turn. Let's see if that is correct. And thank you to Jon Schön for gifting 5 memberships. Thank you so much. Getting our total to 8 gifted memberships during this stream. That is so nice of you. Everybody say thank you to Jon Schön. Thank you so much. All right, let's go here.
Pictures that Miss Antoinette Green took of the white Audi after it was recovered when Mr. Stillwell was arrested.
I have.
Did you see any damage to the tint?
Oh,
Specifically the
I have to go
front
back a
driver
bit more.
passenger tint on that car.
I did. Correct.
You could see traffic lights.
A year ago, or a couple years, like 2 years ago, I watched it.
She claims
watched
she
it.
has seen this several times.
Mr. Kokomo, if you could please publish.
Yeah, my streams, for some odd reason, haven't been yeeted today. I have had a few words.
Okay. Go ahead, Mr. Kokomo.
And the reason why I am stream sniping is because Law and Crime screwed up and their equipment malfunctioned. Thanks to the infamous Sly, infamous Sylvia, she has, without her, this part of this trial would have been lost forever. The footage, at least. So thank you, infamous Sylvia.
Okay, Mr. Kokomo, if you could pause that video right now.
What you see up there are 3 cars stopping at a red light. This is what the prosecution claims is the red car with the victim and the 2 cars with the 2 defendants in, who they claim shoots and kills. They claim that because the medical examiner says, well, once the death was immediate, and he could not physically have taken his foot off the brake. So look at the car to the left and see if you see brake lights after these two cars leave. If you can see brake lights going off and on, because according to the medical examiner, he shouldn't have.
Thank you. Investigator Viverito. At this point in video, as we have it paused, you would agree that Mr. Drinks' red Versa is on the left, correct?
Correct.
Okay. You would agree that Mr. Stillwell's rented white Audi with tinted windows
Correct.
is in the middle. And you would agree that Mr. Nichols, actually Miss Lewis, Mr. Nichols' wife, that Ford Fusion is on the right, correct?
Either the right or staggered behind it, yes.
And according to your investigation, Mr. Drinks is alone in the car,
Yes.
okay? Mr. Stillwell is in the car with Mr. Garlington per your investigation.
Correct.
And Mr. In the car, the Ford Fusion, we have Mr. Nichols driving,
Correct.
Mr. Boyer,
Correct.
and Mr. Farley.
Correct.
And your theory is that while at this light, Mr. Stillwell shot Mr. Drinks, correct?
I'm not the homicide investigator, so I'm going along with the evidence that was presented to me by homicide. But yes, that's consistent with what Detective Hogan, his case.
Well, you know, he swore out a warrant for Shannon Stillwell for actually shooting Mr. Drinks.
That's consistent with what Detective Hogan had found.
In this,
And she keeps using the word consistent with. The word consistent is a bull crap word. Absolute bull crap word. Consistent with. Well, this mug has a hole in it. That is consistent with this drinking horn. That also has a hole in it. Otherwise, you can. That does not mean it is the same thing. But it's consistent with. See what I mean? It's a bullshit word.
this video, you could see
Of
headlights,
course, I have a
correct?
drinking
Correct.
horn.
You could see traffic lights,
You can see taillights and traffic lights, yes.
and you could see brake lights, correct?
Correct.
All right, awesome. Mr. Kokomo, could you just play the video? And I'm just going to ask you to look at the cars closely.
According to Detective Hogan, there's only those 3 cars up there involved, plus a car that makes a U-turn. Let's see if Detective Hogan was correct in his assumption. Well, you need a hole in at least one end to make it a drinking vessel. Now, what happened? Wait, that's a car that Detective Hogan never saw. Never investigated, ever. And when that car speeds up,
Pause, Mr.
the other 2 car
All right,
leaves.
so we're paused at 102:36 on this video. At this point, Mr. Stillwell in the white Audi is pulled off, correct?
Correct.
Okay, and Mr. Nichols and with Mr. Boyer and Mr. Farley have pulled off.
Correct.
Okay, while they were there at that light with Mr. Drinks, did you observe any muzzle flash on that video?
No, and with this quality of video, I would not expect to see it.
Okay.
Bullshit!
Just see.
You absolute liar. Miss Vivorito, you're such a... She doesn't even know she's a bad liar, but she can't help herself but lying.
Brake lights and traffic lights and headlights, but no muzzle flash. Okay, I got you.
A muzzle flash is much, much, much dimmer than a brake light. Like if you're
A muzzle flash is a sudden flash. No matter how grainy, it will stand out from the background. You absolute moron.
shooting at night, you're hard pressed to see your own muzzle flash.
Firearms expert again.
I'm telling you, my experience from shooting a firearm, we do take night firing courses.
So let me ask you this. Gunshot residue. You aware that the headliner from Mr. Stillwell's car, the Audi, was collected and tested for gunshot residue?
I am.
You ever talked to Alexander GBI analyst Alexander Coven about the results that he found?
I have not.
And you are aware that warrants were taken out certainly before any of those GSR results were in, correct?
Correct.
Talk about tint. You've been preparing with the state. You know that the state has said that Mr. Stillwell had tint applied to his windows of that white Audi upon renting it, correct?
Correct.
In violation of the rental agreement, I may add.
Correct.
Okay. And this tint was applied on Flat Shoals Road, according to the district attorneys, at about 6:30 p.m.
According to them, yes.
Okay. You were able to observe the white Audi on March 16th?
I did not walk. Wasn't that interested in it at that point, so I did not walk. It was very, very dark.
Have you seen the pictures that Miss Antoinette Green took of the white Audi after it was recovered when Mr. Stillwell was arrested?
I have.
Did you see any damage to the tint, specifically the front driver passenger tint on that car?
I did not.
This question is from, according to the state, Mr. Stillwell, one of the defendants, had tint put on his windows a day before this happened. Now, tint needs 24 to 48 hours to set. You can't roll down your windows or anything. Now, if Mr. Stillwell have fired from within that car, first of all, you had to roll down his window. That would have damaged the tint. Then fired from within, that would have resulted in gunshot residue. The GSR guy went up to the stand who tested the lining of the Audi. 0 gunshot residue in that car. Not even one particle of gunshot residue found in that car.
Mr. Kokomo, if you could rewind again. No, actually, you know what? I'm sorry. Keep it here. Keep it here. Just play. I'm sorry, Mr. Kokomo.
There comes the speeding
that
car.
Speed up behind Mr. Stillwell. Pause it, please. You saw
Yes.
that? Mr. Stillwell, you're aware that he, well, you've already stated this. He was victimized in the past. Someone shot through the rear windows, killing Tierra Jones.
Yes.
And now that car that sped up is next to Mr. Drinks, correct? Or approaching Mr. Drinks.
It's approaching, but it stopped short of Mr. Drinks.
Okay, Mr. Kokomo, if you could please.
She can't help herself. They paused because the car stopped at the moment there. Let's see if it stays there.
Play it. Okay. So now there's a pause. So now there's one car next to Mr. Drinks, correct?
It's still not next to him. You can see from that angle that it looks like the front of the car. I'm sorry. The front.
You liar! It's beside the car. You liar. She can't help herself. She's so invested in this. And with the Dunning-Kruger effect and her inabilities, she can't help herself. Now, remember, the medical examiner said once Mr. Drink's foot was on the brake, it wouldn't go off the brakes. You should not see a flash of the brakes going off and on. Let me go back a bit.
So now there's one car next to Mr. Drinks, correct?
It's still not next to him. You could see from that angle.
So now there's Kokomo, if you could, or approaching that car.
Going back. Now, look at the car on the left. According to the state, Mr. Stillwell has now shot and killed that man with the foot on the brakes. Let's see when he plays forward if the brakes goes off and on.
Okay. You saw that car speed up behind Mr. Stillwell? Pause it, please. You saw
Yes.
that? Mr. Stillwell, you're aware that he, well, you've already stated this, he was victimized in the past. Someone shot through the rear windows, killing Tierra Jones.
Yes.
And now that car that sped up is next to Mr. Drinks, correct? Or approaching Mr. Drinks.
It's approaching, but it stopped short of Mr. Drinks.
Okay, Mr. Kokomo, if you could please play it. Okay. So now there's a pause. So now there's one car next to Mr. Drinks, correct?
It's still not next to him. You could see from that angle that it looks like the front of the car. I'm sorry. The front of the car is like, from what I can see, looks like the front of the car. The front wheels are still towards the back of the vehicle. It is not like exact with the car.
Okay. Mr. Kokomo, if you could please play.
Did you just see the car on the left driving a tiny bit forward? Let's see it again.
Mr. Kokomo, if you could please play.
And the brakes light go off and on. Didn't you just see that? According to the state's theory, that didn't happen. According to the state's theory, Mr. Drinks is already dead and cannot move the car because his foot is planted on the brakes. We also saw the brake lights go off and then on again with that new car there. And now soon comes the car who does the U-turn.
Pause.
Yep, there's the car who does the U-turn. According to the state, that car made the U-turn while Shannon and the other defendant was there. Now we see with our own eyes, that car makes a U-turn as the second car is beside Mr. Drink's car. Mr. Drinks temporarily takes foot off the brake and then on again. And that car makes a U-turn. Isn't it more probable that the U-turn car sees something happening in front of him right then and there? And here's the thing, folks. Detective Hogan never even bothered to look for the U-turn car, the car that drove up after Mr. Stillwell, or the guy who was walking on the sidewalk. No efforts whatsoever, because they were all so sure it was Mr. Stillwell. So they never checked it. Not even as witnesses, they checked out.
See that car make a U-turn?
I do.
Okay. What car was next to Mr. Drinks when that car suddenly made a U-turn?
Judging by how the lights are, that car still appears to be back a little bit, but next to it.
All right, so now you're making three-dimensional evaluations, but we can't see a muzzle flash off this.
A muzzle-
interview.
Mr. Schard, I'm going to explain to you when you're, I don't know if you're mischaracterizing it. When you go to the range, example, to fire your weapons at night and there's a line of shooters, it's not bam, 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 lights everywhere. It's a very, very muted if it shows. So this
She's such a liar.
far away with this quality of video, I would not expect to see that.
Okay, well, let's talk about this car.
Sure.
This car makes a U-turn. Did you see, is there like a train that's crossing that would have let this person know, no, I need to find another route?
No,
Is there a officer saying, hey, turn around, you can't come this way?
no,
Is there an animal crossing the road that would have made this man do a U-turn?
no,
Who is this? Whose car is this that made the U-turn?
I don't know.
Okay, do you know if anyone ever tried to use these license plate readers to determine whose car that is so we could figure out, talk to them about why they made that sudden U-turn?
That would be part of Detective Hogan's investigation, but I do not.
Okay.
He didn't. And she knows it.
Hypothetically, could that car made a sudden U-turn at that exact moment because they heard a loud bang?
Chef, Your Honor, be speculation, although she's an expert, she's not an expert in.
I'm gonna allow it.
That would be, no, that would be problematic based on the video.
That would be problematic based on the video. So you're telling us that you know that this person did not make a turn due to a loud bang?
If you're going off the loud bang theory, may I explain?
Yes.
If Mr. Kokomo can hit play, or rewind it back and hit play for a second. You can see there's a gentleman or some person walking here. They do not break stride. They do not flinch. They do not stop. They do not jump back. They continue walking towards your loud bang.
Did you track that person down? Maybe they had headphones in, like I have. Maybe they were in on it. Maybe that person came into frame after jumping out of that car that is now beside Mr. Drinks. But no, they never checked any of this.
Near your gunfire.
Well, actually, they disappear into the bushes, don't they?
It's not a bush. It's a shadow. And I went out there.
There's not trees right there? I've been out there too, Mr.
Okay, I've been out there too, so they're like walking through, but they don't break stride. They don't jump. They don't run back. They don't run from the gunfire. So if it was gunfire enough to make a car stop, pull a U-turn in the middle of the road, that would certainly be, using your theory, make a person get taken aback a little bit and run away.
So who's that person?
I went out there and canvassed. That's an area where it's there's a large homeless population. It's very transient, and there's also a Greyhound bus station right there.
So you didn't talk to this person?
I did
You're
not.
saying that they didn't break stride and all that. You've never talked to that person. You've never identified that person.
Could not. I tried.
Okay, but again, I'm going to ask you, and if your answer is really no, then that's fine. You're telling the jury that you, as the determiner of facts, have determined that that person did not make a turn because of a loud bang.
Consistent with the person walking that would be outside of a vehicle that had no reaction at all. That's what that would lead me to believe. And I didn't charge this case, so I'm not the determiner of facts.
All right, let's talk about something else while we got this video. Mr. Kokomo, if you could just play. I want you to pause for a second, Mr. Kokomo. I want you to pay real close attention to Mr. Drinks' car.
Okay.
His brake lights.
Yeah. As John C. said, wasn't Max theory Santa's theory? Yeah. Bad Santa cop, Detective Hogan. His theory presented to court is that that car made a U-turn because that car saw and heard something in front of him. And here is the Dunning-Kruger effect in the shape of Miss Vivorito claiming, well, Mr. Hogan is a liar.
And you see the other car pull up a little bit more?
Correct.
And you see the brake light go once, on and off?
Correct.
Okay.
Which the medical examiner said was impossible.
You're aware that Mr. Drinks was shot twice.
Correct.
And you're aware that the fatal shot was to the neck.
Correct.
Specifically, it was through the basilar part of the occipital skull.
I don't know that. I know it was in his neck.
Okay. And as an investigator, as the investigators you sit here today, did you find the brake light going on and off significant?
I saw the light going on and off. Yes.
You don't find it significant?
I'm not a medical examiner, but
Okay. Cool. Have you
oh.
have you spoken to the medical examiner in this case, Miss Dr. Melissa Sims Stanley?
no, I'm not. I'm
Okay,
not the
and-
homicide investigator.
All right. Are you aware that Dr. Sims Stanley testified that upon being shot
Objection.
in that exact
Hang
spot,
on just a second.
Improper question with election foundation. And she can't listen to the testimony to know what the doctor would have testified to. And she said she had not spoken to.
Overruled.
that the loss of any control over your body parts would be instantaneous,
Okay.
okay? And that if shot in that exact spot, no one would have the ability to lift their foot on and off the brake.
Okay.
Have you spoken to Dr. Stanley about that?
I've already said I have not.
Okay. Did you know that she called that a medical impossibility?
Objection. That's improper with the lack of foundation. So this was the speculation.
Those two objections are overruled.
Objection. Facts not evidence of miscarriage of her testimony.
That objection is also overruled.
So how long had, and we can rewind it, Mr. Kokomo. I want to know how long after Mr. Stillwell in that white Audi had left Mr. Drinks, how much time passed between that moment and when Mr. Drinks' brake lights are going
A couple of
on
seconds.
and off? Well, we're gonna, Mr. Kokomo's gonna let us figure this out. Right now, that's Mr. Stillwell next to Mr. Drinks, correct?
Me, yes.
And Mr. Stillwell's leaving now at 1:02:26. And the brake lights have now gone off at 1:02:45. 19 seconds to be exact, correct?
Sure.
All right.
Yeah, and the medical examiner said he would not have had the medical ability to lift the foot off the brake. And 19 seconds later, he lifts his foot off the brake. Instantaneously. That gunshot through that part of the neck, loss of function. Foot on brake, stays foot on brake. 19 seconds later, he puts his foot off the brake and then on the brake again.
That car that was next to Mr. Drinks when the brake lights were going on and off is also the car that was next to Mr. Drinks when the car pulled a U-turn, correct?
I don't know if I would characterize it as on and off like multiple times, but that was the car that was a little bit further back from his car, yes.
Okay, and that's the same car that was next to Mr. Drinks at the time of the U-turn, correct?
Staggered behind Mr. Drinks, yes.
Okay. Have we identified that car?
You keep asking me about the homicide investigation. Unfortunately, with APD, we're not allowed to be in may I finish? I can't answer your.
You testified for a day and a half about different things as an expert, including the Drinks murder. And now all of a sudden, oh, I am not allowed to. Liar. You testified for a day and a half about things you were never involved with, but now all of a sudden it makes sense. And by the way, this is Miss Sylvia that you see there. She is not on my stream. I am stream sniping her stream because she's the only one who has this part of the testimony. Because Law and Crime and everybody else in that court feed went dark. So she is. So thank you, Miss Sylvia. Thank you for saving this for the world.
Questions about Detective Hogan's homicide in full.
So you don't know if anyone used LPR readers to determine the license plate of that car? That was
You
next to
would
Mr.
have
Mills.
to ask Detective Hogan.
Okay, and we don't know who the
And we did, and he didn't. And she knows it. I can bet money she knows this.
driver of that car is doing.
You would have to ask Detective Hogan.
Okay. Has the headliner from that car that was next to Mr. Drinks, when the brake lights were going on and off, when the other car was doing a U-turn, has that headliner ever been collected?
You would have to ask Detective Hogan.
What are the gunshot residue test results from that car?
You would have to ask Detective Hogan.
Okay, thank you. I have no further questions.
All right, it's a good time to.
That is the end of Detective of Mr. Schardt's cross-examination, because in this RICO, that murder is essential for the rest of the RICO case, because if they found Mr. Stilwell not guilty, then the statute of limitations, in my opinion, also for the rest of the crimes are gone for him.
Pause for lunch. So let's be back at 1:40, please.
Yeah, so Miss Vivorito, now we are going to skip ahead to redirect. But oh my God, this absolute moron. No, I don't think they had, no, they had nothing until they are back after lunch. I've spoken so much that we are way behind. So redirect coming up. And I'm going to play this, well, a bit faster. Now I will play about 5 minutes of this, then the rest of everybody else's stream are up. But let me... This is the link to Infamous Sylvia's stream.
Okay. Excellent. Thank you.
Normally I just skip through what the state has to ask, but I'm not sure if it will be Recross yet. Oh, there is Recross. Okay. Or is it? Oh, it's Recross from both Doug and... Okay, that's good to know. That's good to know. But I'm still, because I'm really interested in seeing how they can even
Ms. Hilton, you can,
remotely
go ahead with your redirect.
save this witness.
Mr. Weinstein.
Okay, we will wait for the sidebar.
Good afternoon. How are you?
Good afternoon, I'm well.
So I want to start with some questions that Mr. Weinstein asked you regarding the watch that was in Mr. Williams' home in the closet.
Correct.
Did you steal the watch?
I did not.
Did he steal the watch? No, she would. Let's put away the things that says she's law enforcement. She's the last person that handled that watch, provably the last person who handled that watch before it went missing. Let's say she was a gangbanger or something. Do you think that would hold up? Her saying, "Oh, I didn't." No. Did she do it? I don't care. I don't know and I don't care. All I know is she is provably the last one who handled the watch before it went missing.
Next, Mr. Weinstein asked you a few questions regarding whether or not Mr. Kendrick was inside of the home at the time that the search was taking place. Do you remember a line of questionings regarding where Mr. Kendrick was?
I do.
When the SWAT team made entry, did they clear out the house before you went inside of the home?
They did.
And was that after Mr. Kendrick was apprehended after fleeing the house?
Objection.
Sustained.
Were you made aware of where Mr. Kendrick was found, was apprehended?
Yes.
Where was that?
Outside of the home.
Outside of the home, where? To my understanding, he was a bit away. So outside the home. Well, I'm outside of that home. I'm at the other side of the world. I'm still outside of that home. It's a bullshit answer.
As a part of that investigation, did you ever recover a cell phone from Mr. Kendrick?
Yes.
And did you have that cell phone extracted in the same way that we talked about other cell phones being extracted?
Yes, a warrant was drafted and it was extracted by Kevin Leon Packer.
In that phone, did you find any information that was taken on May 9th, 2022?
Yes.
Okay. What did you find?
A text message, I believe, saying that I'm at Slime Spot, if I remember. I have to see the text message in front of me, but
So were there any pictures of his phone from that day?
I'd have to look at the dates on the photos. There are photos but from the home, but I don't know if it's that day.
Permission to approach?
You may.
I'm going to show you what's been marked as 534 VV and 534 VVA. Tell me if you recognize 534 VV and 534 VVA.
I do. These are photos from Mr. Kendrick's phone.
And do those pictures have a date on which they were captured on the phone?
May 9th, 2022.
And do they appear to be photos that were taken from Mr. Kendrick's phone after you reviewed it pursuant to the search warrant and the cell phone extraction?
Yes.
Your Honor, this time the state would like to admit 534 VV and 534 VVA into evidence.
Those are admitted.
No objections.
And we'll publish in a moment.
Hey, Patrick, welcome to the crew. Welcome to the Viking crew. Bringing us to 9 new members
And is
today.
this a picture that was found in Mr. Kendrick's phone?
It is.
Okay. And do you recognize anyone in the picture?
Martinez Arnold.
Right. And who is Martinez Arnold? Which individual is Martinez Arnold?
The white t-shirt and the black pants.
And
I'm
if
going
you can
to
just
show you something
on the TV
after
screen
they
the
are done
date
with this.
in which it says the picture was, he said it was modified.
May 9th, 2022.
Oh,
And
they
then did
actually
you also
said it. Yes, it was modified, which means he put it in the text message at that time. It actually doesn't say when he were there. Now, probably he was in the house. But we don't know because there's no metadata. They have the text. With the phone, they have the text with a photo attached to it as modified on that date. They do not present that photo, which should also be in the phone. They only present, they only present the text message with that file.
Said earlier that you saw a text message in the phone on that same date as well.
Yes.
Now, I want to transition to Mr. Schard's line of questioning. Mr. Schard spoke with you in detail about one of the search warrants you drafted. Do you remember that?
Yes.
And I'm going to show you when I'm going to mark as
Gigi asks, Nick, how can the state bring new evidence in a redirect? Since Mr. Weinstein brought it up, they can address it on redirect with possible evidence.
530 BV. And I'm going to go to, I believe it was page, unnumbered page 5. Excuse me, unnumbered page 7.
Mhm.
Looking at 530 BV, unnumbered page 7, is this the page that you and Mr. Schard were discussing with the YSL Rule the World Kid 24 mil on the N-word tab?
Yes,
And does that appear to look like a page of your search warrant affidavit that you drafted for this particular search warrant in this case?
it does.
You're right, this time the state would like to admit page 530 BV, unnumbered page 7.
Can I see clarification from the state?
Sure.
No objection.
All right, that's admitted. It's just that one page.
Just that one page, Your Honor.
Remember when she said that she didn't circle it? Or that it was in another font?
Permission to publish.
You may.
And I want
Let's pause it here. Here you have that page 7. Down here it is circled in another font than up here, which Miss Vivorito said she didn't do. So she lied. Again.
you first, is that page, the unnumbered page 7 of 530 BV?
It is.
All right. And are we able to zoom in? The portion that has the circle, how did you grab that information to put it inside of your warrant?
I believe it's a screen grab from Instagram records that were received.
A screen grab.
And as you screen grab, is that how you place it inside of the warrant?
It is.
Once we get it back up, I want you to read what is the paragraph right above the screen grab. Now, while we're waiting for that, Mr. Schard, do you recall him asking you a lot of questions about writing reports in this case?
I do.
Over the course of these 2 years, have you ever had opportunity to meet with Mr. Schard?
I have not.
Have you been available to meet with Mr. Schard if he had any questions about any information contained in the warrant or March 22 folders or anything that you may have done in relation to this case?
Absolutely haven't.
There's absolutely zero obligation for the defense to reach out to anyone. And here's the thing. For 2.5 years, the defense have asked the prosecution to give them every report. That is what they have done. That's the proper way to do it.
Now, are you able to see and read the paragraph before the screen grab?
Yes.
Can you please read it?
In a conversation thread from February 4th, 2021 to February 7th, 2021, Jeffrey Williams brags that YSL rules the world and has $24 million.
And now we know he's referencing a $24 million that the other guy had implanted. A $24 million diamond implanted in the forehead. Now, Miss Vivorito might not have said it was on his head. The prosecution have argued it, that this meant he was putting 24 million on somebody's head.
Jeffrey
But they
Williams
were
then
lying.
tells YSL members to pay him directly, and he pays for everything already for the members. This shows Williams' leadership role within the enterprise, directing the actions of YSL members and obtaining the profits from the enterprise.
And we also know, this is really interesting, through other testimony, not one investigator, not one cop, not one prosecutor have pulled Mr. Williams' records, his bank records. Nothing. They still assert to a judge that that is what he does. They never once pulled his bank records to show that is actually true. Never once.
At any point in there, did you say that he was given $24 million to try to kill Lucci?
I did not.
Did you infer that in anything that you wrote right there?
I did not.
And is
No,
that what
yeah,
you presented
no
to the
financial
judge
records
in
pulled
addition
from
to
Mr.
all the other
Williams.
pages of that affidavit?
It is.
And how many pages is that affidavit?
Several. They're not numbered, so it's multiple.
Now, do you remember? Let me take that down, thank you. Do you remember there being a line of questioning regarding Mr. Stillwell's song "Slap Talk" and the verse, was it "I just beat a murder rat, pay my lawyer 30 for that"?
Correct?
And are you aware of when Mr. Stillwell was initially arrested on murder warrants regarding Donovan Thomas Jr.?
And it was sometime in late 2015.
To your knowledge, did he ever receive a bond on that original murder warrant?
At some point, yes.
Okay, do you know when?
I want to say maybe the winter of 2016.
They're actually going to argue in front of the jury that is he got bond, that equals beating a murder rap. It's so insanely stupid.
To your knowledge, between 2016 winter and 2019, was there any indictment for the murder of Donovan Thomas?
No.
Between 2019 and 2022, was there an indictment for Donovan Thomas?
No.
When did this indictment?
This is not a flex. This is not a flex. He was charged, but never indicted until this scam, this money grab that is the YSL RICO trial. He's been out on bond for this since 2015 and never indicted. And yeah, Gigi, that song was written before Donovan Thomas murder.
For the Donovan Thomas murder occur?
May 9th, 2022.
This is so stupid.
And when did the Donovan Thomas murder occur?
I believe January 10th of 2015.
So if my math serves me correctly, it took about 7 years for there to be an indictment in Donovan Thomas murder.
Correct?
I'm going to now publish the video that Mr. Schard talked about on Direct, which is the full video of the screen grab regarding Quarmavius Nichols. Remember, do you know what we're referring to?
I do.
All right. And this is going to be for the record, Your Honor, and we're going to ask to admit 471 VVA into evidence, Your Honor.
All right, that's admitted.
No objection.
And permission to publish.
You may.
Oh, hell no. I can't play. Oh, crap. I didn't catch that.
Or two after the homicide of Mr. Drinks.
And on here where it says 18 hours, would this video have been posted, this particular video been posted 18 hours before you screen grabbed it?
Correct, whatever day, I'm not sure the day of the actual capture, but it would have been 18 hours before that.
And if it said 1 hour, would that video been posted 1 hour before the capture?
Correct.
Now, there was a line of questioning regarding Shell Kell and the 2 shells on his face. Do you remember that?
Correct.
The Christian McMillan Darius Ford case, is that still an open and pending investigation?
It is.
Are you the lead detective?
I am not.
Have you done additional investigation on that case?
I've assisted on that investigation.
And have you turned that information over to the lead detective?
I have.
Was
And
it
is it up to the
in,
lead detective to take out warrants or do whatever next steps?
was that your information? What is in the? Was it in the shape of finger paintings? Was it in the shape of anything? Did she write reports? Yeah, no, Chrisanne. Did she write reports? I assume when Cross examined with this, no, she talked to him. No reports. This broad, this so-called gang expert who trains other gang experts is incapable of, yeah, I have so many words.
In the investigation.
It is.
DeMarco Boyer, when did you confirm that Boyer, let me strike that. How did you confirm that Boyer was at the gas station? How were you able to confirm that information?
There was a call that precedes the call at 9:59 that let.
Wait a minute. Didn't you just say you weren't investigating this? And here we are again. Once the prosecution asks questions, perfect recollection.
We know that they were at the gas station.
And did you ever get phone records to confirm whether or not there was accuracy regarding that call?
I don't believe I obtained them, but I did see them and the results of them.
And to your knowledge, do you know when those phone records were obtained?
It would be months after a couple months after the indictment, I think. I didn't obtain them, so I'm not 100% sure.
Let me ask you, do you know if it was before or after the indictment?
After.
Mr. Schardt asked you some questions about tinted windows. Do you remember that?
Correct.
Right. Have you ever had any cars tinted, windows tinted?
I have.
And have you ever received instructions after the car has been tinted on what you should do about winding up and winding down the windows?
I have.
Have you always listened to that instruction?
I tried to, yes.
Has there been a time when, and let me ask you, what is the instruction generally?
Don't roll your windows down for 3 to 5 days.
You said you tried to. Have there been times where you have rolled it down before the 3 or 5 day period?
The next morning, getting out of my parking deck, I accidentally rolled down my window.
In your experience, did anything happen to the tint?
Did not.
So I want to go to State's Exhibit 437 VV and the call that's on March 15th, 2022 at about 2 o'clock a.m.
It's incredible in the worst possible form of that word. That Detective Viverito even has a job in law enforcement. Yeah, I agree with spiritual wars exposed. This detective need to be investigated. How easily she lies.
Yo. All right, man. There's all kinds of shit going on. I just jump in the other car, bro. Y'all niggas don't be getting dropped off. They ain't got no motherfucking ride to go back home to. They don't make sense. Yeah, yeah. It's supposed to be getting dropped off for a nigga ride with a nigga who groceries. Yeah. That's stupid as fuck. And you need to be on the gun or something. What the hell? What's up with you? We right here. We right here down here. Yeah, what? Ride past around the sea. I'm finna go get. I'm finna meet up with y'all. Nigga, go get a fill up. I get a fill up for my right. Yeah. Alright, I'm listening. Huh? I said, alright, I'm listening. What's going on? I said, I'm pulling out now. You back, son? You say, I was gonna jump in with y'all. Alright. That's what I'm saying. Call when you're done. Alright, I'm gonna get the fill up now. Alright.
Now I want to pull, are you familiar with the vault page of the actual wiretap information that you receive when you get the wiretap?
Yes, a typical, oh,
Sorry, the PDF pages.
yes.
And earlier, did we talk about yesterday that sometimes within the wiretap, there was mapping information?
If it's available, the wiretap will display a map of where the device is at that time.
We already know where Stillwell was. He told you.
And is this what the PDF page looks like when you get the wiretap information?
So when you export the wiretap data, this is the PDF form, how it's going to print out and be exported.
And does it have a link for the audio and a link for the map?
Correct.
And is the audio link, would that link us back to the audio that we just heard?
It will allow you to play the call associated with this record.
And then what does the map link do?
It will show you, if it's available, the map of where the device is located at the time of the call.
We click on the map. And if you can use the pointer. Looking at the map, are you able to see the area or the neighborhood that that it appears that the phone is in?
Yes,
What neighborhood is that?
Mechanicsville. All right here.
And where it has the pin drop, is that where the phone is supposed to be located on the map?
It should be within that radius. So it'll give you a radius and say within this many meters, and that judges how big the circle is going to be.
And on the radius, do you see Fulton Street Southwest?
I do.
And do you also see McDaniel Street?
I do.
Is the is I-Windsor and I-20 in this general vicinity of this area?
No, it will be right here.
I'm going to object to a general vicinity.
Sustained.
Within the map, are you able to see where the I-20 Windsor area is?
Right here.
Are you able to see, court's indulgence for a moment. Thank you. Now, do you recall Mr. Schard asking you about whether or not the phone call that was at 9:59, where the call says get on FaceTime, whether that was, where did you get that time information from?
Yes.
And where was it that you received that time from?
The wiretap itself.
I'm going to publish for you what's already been admitted as 397 VVD, which is the ankle monitor location information.
How do you know that timing is accurate? Because the guy from the company who handles those, he damn well didn't testify about that timing being correct. Well, this is a state witness, Liz Bird. She is Marissa Vivorito. Have worked for Atlanta Police Department, for the Georgia Bureau of Investigations, and for the District Attorney's Office. She trains the gang experts. She trains them. So whenever you hear a gang expert in this trial, which has been a lot of them, she trained them all. This chick who's on the stand, this absolute buffoon, is the one training the rest of them, which explains why they are utterly incompetent. Now let's see here. They are there. Just checking. Okay, we are roughly here. So we can get closed captions again. Thank you so much to Infamous Sylvia for saving, because for you who don't know, the court feed went black, went out. The final 5 minutes of Mr. Schardt's cross-examination and the first 10 minutes of redirect. Without Miss Sylvia and her camera in the courtroom, this would have been lost.
397 VVC.
Yeah, the ankle monitor had a dead battery. How could they get GPS positioning from it?
Do you see that same address located on 397 VVC?
I do.
Okay. And is that the BP gas station?
It is.
And is that the BP gas station located at Windsor and Fulton Street?
It is.
Is that the same BP gas station that you saw in surveillance video?
It is.
Is that the same BP gas station where the car?
What Miss Hilton is going to do shortly is trying to explain why we didn't see what we saw on that surveillance video.
That was rented by Shannon Stillwell and Demikion Garlington is inside of is at that gas station.
It is.
Is that the same gas station where the white Ford Fusion is in, that DeMarco Boyer is in at that same gas station?
It is.
And is it at 9:59 that call comes in that for them to get on FaceTime?
It is.
And in looking at the surveillance video, is that moments before or after the red car in which Mr. Drinks was in is pulling off from that gas station?
I'm going to object to speculation. I don't know how the video cameras link up.
I think that's an argument.
Do you want to rephrase the question?
Sure. On the surveillance video, do you see at approximately 9:59 from the BP surveillance video, that car, Mr. Drinks' car leaving the gas station?
I believe Mr. Drinks' car leaves the gas station and the other car shortly thereafter follow.
And what other cars also were there? What other cars? Did you check that? Did you check for that third car? No, you didn't. Neither did Mr. Hogan. Neither did the investigators or the DA's office. And her memory and knowledge, as her memory and knowledge are all of a sudden intact.
And then do they then go to, those cars go to the light that's on the FedEx surveillance video?
Yes, they stop at the light.
Now let's go to the FedEx surveillance video.
Sure.
All right. Now, what time is on the surveillance video on the bottom? How much into the video are we at?
1 hour, 1 minute, and 32 seconds.
All right. Mr. Bot, if you can press play, please. Is that the red car approaching the light?
It is.
Is that now the first white car, which is the white Audi, now approaching next to Mr. Drinks?
It is.
And is that the white Ford Fusion then approaching next to the white Audi?
It is.
All right. And are those cars just all at the light currently?
Yes.
And do we now see cars moving in the opposite direction?
Yes, oncoming traffic is starting to move.
And actually, Mr. Abadi, can we go back to when the cars first get to the light?
Why don't you want that third car speeding towards the intersection? Why don't you want that car?
I want you to tell me, I'm investigating people, what time does the red car first get to the light?
1 hour, 1 minute, and 36 seconds.
What time, and tell me what time the Audi gets to the light?
At the 45-second mark.
And what time does the Fusion get to the light?
52-second mark.
What time does oncoming traffic start?
This is a red
1
herring.
hour, 2 minutes, and 11 seconds.
Are they still at the light?
They are.
What time does this car that's behind pull up?
1 hour, 2 minutes, and 24 seconds.
Do you see the white Audi pull off?
I do.
What time was that?
You may have to roll it back for a
If
second.
you could pull back for a second.
You may have to go back more because it's already pulled off.
This is such a red herring.
You can go back to 102.11. We'll pause. Do you see the Audi pulling off?
Foot comes off the brake at about 1 minute, 1 hour, 2 minutes, and 21 seconds, and they pull off at 1 hour, 2 minutes, and 24 seconds, or 23 seconds.
And prior to the Audi pulling off, do you see the Fusion make any movement?
No.
Okay, let's go back. Can you go back to 102.15?
Watch the brake lights on the red car. The prosecution claims Shannon Stillwell shot from the Audi, and the medical examiner says it's medically impossible at that point in time with the bullet in the neck for the brake lights to go off. And still it does.
Oh, the Fusion starts creeping up.
And what time is that?
It's around like the 17 or 18 second mark.
And is the white Audi going into oncoming traffic?
Yes, it darts into incoming traffic, oncoming traffic.
And here comes the U-turn car. And right about here, he makes a sudden U-turn. Just as the brake lights went off and on again. That U-turn car, whoop. That off and on brake lights is, and I claim, is when Mr. Drinks was killed at that point in time. because we are watching this through grainy video. That car, the U-turn car, had clear vision in front of him what was going on. If they actually bothered to find that guy, that car, he might have gone up here and testified, I saw muzzle flashes from that car. But they never bothered. Never bothered. Because that would ruin their case against Shannon Stillwell.
The lane that Mr. Drink's car in, is that the left turn lane?
It is.
And look at, now it's off again. Now it's off again. What actually happened? And on again.
The car that pulled up behind, does that
And it's still red light when that third car just buzzes off.
car go left and turn left?
Yes.
What?
The car that pulled up behind, does that car go left?
No, it didn't. It drove straight forward. This is the gaslighting. This is pure gaslighting from the prosecution. Don't believe what we see with our own eyes. Listen to our words.
And turn left.
Yes.
And you said that you've been out to this area before.
I have.
Is the middle lane a turn lane?
No.
Is it only the left lane?
Yes.
He didn't turn left.
Now, if we can go back again to 10215. Now, investigator, I want you to focus on, remember the individual you saw walking in the video before?
Yes.
I want you to focus on that individual walking.
Okay.
And if you can show the jury when you first see the person walking.
Right there. Or is it not on my screen? It is. Oh, there it is.
Does he have
And
headphones?
you keep playing.
Is he deaf? We
You
don't
still
know.
see the person walking.
I do.
Are they still walking when the car makes a U-turn?
It is. They are.
This is gaslighting on a whole other level. This is the kind of gaslighting an abuser does. It's on that level of gaslighting. Don't believe your own eyes. Don't believe what you're actually seeing.
You still see them walking.
It's muffled, but yeah, they're still continuing towards the intersection on foot.
And is Mr. Drink's car still sitting in the left lane?
It is.
She didn't investigate this case, so why are we still at
Do you still
it?
see the individual walking?
You see, surfs him right here. It's very hard to see, but you see the movement right here.
And he's still walking towards the light?
Correct.
On Windsor Street, where the individual is walking, what is to the right of where he's walking?
I believe I remember correctly, some bushes or shrubbery, or and there may be a wall of some sort. I can't 100%.
Now, we're gonna have to go back again to about 1:02:11. Again, is that where all three cars, the Fusion, the Audi, and and Mr. Drink's car all at the light?
Correct.
Now let's focus our attention on the car that pulls up. What time does the car pull up?
At about the 27th, 28-second mark at 1 hour.
Will you, Miss Hilton, will you address the off and on brake lights? I guess you won't, because it goes against it, what you're trying to prove.
2 minutes, 27 or 28 seconds.
And I actually want to pause. Ms. Abadi, are you able to zoom in to that portion now?
Are they trying to
Okay, what you
claim
doing?
no muzzle flashes? after she just testified that you can't really see muzzle flashes in the dark? Hey, Vicky Hat. Yes, Mr. Jingles is back.
That we just been looking at.
It is.
All right. And now I'm going to focus on the white car that pulls up. Do you see the fusion pull for it first?
Correct.
Is that the Audi pulling off into traffic?
Correct.
Now, is the white car behind those cars?
It is.
And from here, can you tell if the car that pulls up is behind the car with Mr. Drinks
You'll see like a gap here. It's like the tires are back towards the back of the car.
in the turning lane?
It's in the middle lane.
Okay.
Oh, fuck you. Are you claiming they are in the same lane? No, that's the middle lane, the same. Yeah, oh, God. No, she's not claiming they are in the same lane. They are claiming they are not beside each other.
And do you see the car flash on and off and the car still behind Mr. Drink's car?
Yes.
Did you see? Brake here. That's a nice pause. Brake lights off, which again the medical examiner says impossible. Impossible. According to the medical examiner, Mr. Drinks is alive, just as that white car or light car really drives up beside it. And there, those few moments, breaks off, on, and stays on, is exactly when that car is exactly beside. Vroom, vroom, pew, pew, takes off.
Is that light red?
It is.
And does the light turn green when he goes to make the left turn?
It is.
Following road traffic
Correct.
or following the correct signals?
Correct.
And is the car still sitting there?
It is.
At any point in time in this video, do you see any muzzle flash?
No.
But was Mr. Drink still shot inside of that vehicle?
Yes.
Which make it equally probable, if we only went by that, it is equally probable that it's either of those cars. That's reasonable doubt right there. But now we know from the medical examiner, I'm repeating that into Kingdom Come. Once his foot stays on the brake, that is the point of impact of the shot in the neck, which is exactly when that car is right beside, stopping momentarily and then takes off. Probably waited for the green light.
Now, when the Audi that Mr. Stillwell takes off, does he go left as well?
Yes.
Right. I want to go back to 397 VVD.
Yeah. Yes, Heather Mosher. So that third car was the last one next to Drinks, and yet they didn't investigate that car. No. They never did. Nobody knows who was in that car. But what we do know is, in my opinion, my personal opinion, shows or whoever that person is the actual murderer of Mr. Drinks. Let's continue.
And I want to go all the way up to the top initially,
Okay.
this exhibit. Now, do you see the categories of the information that's contained within this exhibit?
I do.
Do you see column I?
Yes.
And what does column I say?
Speed.
All right. I want to go back to March 14, 2022. And I want to scroll to when we last looked at this document, 9:59, was he at the location at 464 Windsor Street?
He was.
Okay. And at 10 o'clock, was this at 464 Windsor Street?
He was.
That's the same BP gas station.
Correct.
All right. At 10:01, was the income out at 405 Cooper Street Southwest?
It was.
Right. And do you see that column I where it says 17 and 18?
Correct.
All right. And that's in miles per hour, right?
Correct.
When we go to 10:02, PJV2 plus VR, is that at 18 seconds?
18 miles.
18 miles per hour?
Yes.
And I want you to remember this PJV2 location, all right?
Okay.
The next location, 500 Northside Drive Southwest. How many miles per hour?
90.
And what time is that?
10:03.
Is that 2 minutes after the car is at the, or the ankle monitor at the PJV2 location?
A minute.
Excuse me, a minute after the PJV2 location,
Yes.
right? I want to show you 397 VVF.
Yes.
And they're on a break. Oh, wait a minute. What did I miss here?
At 10:01, was the income out at 405 Cooper Street Southwest?
It was.
Right. And do you see that column I where it says 17 and 18?
Correct.
All right, and that's in miles per hour, right?
Correct.
When we go to 10:02, PJV2 plus VR, is that at 18 seconds?
18 miles.
18 miles per hour?
Yes.
And I want you to remember this PJV2 location, all right?
Okay.
The next location, 500 Northside Drive Southwest. How many miles per hour?
90.
And what time is that?
10:03.
Is that 2 minutes after the car is at the, or the ankle monitor at the PJV2 location?
A minute.
Excuse me,
after.
a minute after the PJV2 location,
Yes.
right? I want to show you 397 VVF.
Yes.
Okay. Mr. Schard Probably just realized something. And this brings us to sidebar counter 348. So what did he find out? Let's skip ahead.
We were already,
Okay. So the jury is now out. Let's see what this is all about.
Your Honor, I don't know what the, Mr. Schard's going to tell you why he objected. I'd already asked the witness the question about the 90 miles per hour. So that question was done. My next question, I asked her to read the location of PJV2. That's it, what was on the spreadsheet. Then that is when Mr. Schard objected. So that is the objection that's on the floor. At this point.
Oh, you ass. Yeah, he was a bit off. Now she's trying to claim, oh, that question and answer was already passed. Oh, you ass.
I've asked her to read PJV2.
Well, she is reading off of an ankle monitor report from the ankle monitor company. To the extent that she reads off of it, that's not really my issue. It's when she starts to interpret the data. She doesn't work for that company. I don't know, for instance, the PGV2, whatever, PJV2, I don't expect to hear her testify or what that means, because she's not the ankle monitor person.
Can you please? Okay, I understand people have already seen this. I haven't. Stop spoiling. Not going to say this once again. Stop spoiling. Many people are here just to listen to my rants about this trial. They haven't either seen what's going on. Please stop spoiling.
Person. The ankle monitor person would have been the person to ask about those things. So I don't get.
What is PJV2? So the next thing that I was going to show her, which was already admitted, is the picture of PJV2, which is a location that's already in evidence.
How does she? Okay, so
What you're going to ask her to do.
Yes. So this is the spreadsheet, Your Honor.
Okay.
On here, which I had her read earlier on the spreadsheet. The column has the name, column D has the date and time, column E and F is longitude and latitude, and column G is a location. So before the objection, I believe she was reading, or she had read at March 14th, 2022 at 10:02 p.m., the location PJV2 plus VR Atlanta, Georgia. That is what my question entailed. And that was
Okay,
the
and
objection.
she read that?
She
Or
read,
is- Okay, she read PJV2 plus VR Atlanta, Georgia?
I believe that. if
Or is that when
objection-
the objection came?
That might be when the objection came.
Okay, and then what?
And I was just gonna have her read the date and time of that location. Then I was gonna show her what has been admitted already as already admitted as 397 BVF.
That plots that location
Correct.
by the ankle monitor company? Or by whom?
We showed the ankle monitor company that picture as it correlated to this location here. So we printed out Google images of these locations, PJB2, 464 Windsor, which is what I just showed her previously.
By the latitude and longitude?
Yes.
Somebody plotted latitude and longitude
I don't,
on a map
No, we
to get
pulled
that
up-
location?
We pulled up the map. We went into Google and we put PJB2 plus VR. We just Googled it.
You Googled it? Another instance of in a break, they Googled something and presented. There's no foundation. Who Googled it? Can they actually interpret this? Oh, for fuck's sake.
And we pulled up the location.
so essentially they want someone who doesn't work for the ankle monitor. And mind you, the ankle monitor company person's already here. They want someone who doesn't work for the ankle monitor company to take something that's on the ankle monitor company's Excel sheet and then compare it to a Google printout that the prosecutors
You're
printed out. And
That is already in evidence?
That's
You're right,
already
it's in evidence. It's not, we're not admitting it through her. It's in evidence. The ankle monitor witness introduced it. He
Okay.
introduced it along with the record
Mhm.
of the picture.
But how is you or her? You can't testify about it because even though you believe you can read from it, you cannot make interpretations because neither of you have the ability, the knowledge, or the competence. Well, you don't have competency for even wipe your own ass, but that's besides the point.
And so
Okay.
at this point, when Mr. Schard has
Okay, and
challenged,
then what? So you'll then say, and here's this other piece of evidence that is a plot of PJV2 plus VR.
is that the location at the light that for the surveillance video that we just observed? Because all of this is in this is all in response to Mr. Schard's cross-examination about what occurred at the light.
Can you put that back up again, please? The thing that was just up. And from this, you are going to have her extrapolate that because at 10:02, his ankle monitor showed him at that location, then what? Because you came up here and were saying this is going to be able to show that the timeline is accurate across all the different devices. How is it going to do
So
that?
the challenge that Mr. Schard made is that the 9:59 phone calls, this started with the phone call at 9:59, which is the wiretap phone call. Mr. Schard asked Investigator Viverito, are you able to know if that is the accurate time? Because of that line of cross-examination, we are now showing Investigator Viverito other admitted evidence that shows a correlation to that 59 time. So when you look at this chart, before we get to the 10:02, which is at PJV2, at 9:59, the
Please
ankle.
put that exhibit back up. Or hand it to me. I'm happy to have a paper copy of it. So now we're talking about 9:59 and not 10:02.
We're showing Mr. Schard started off at 9:59. Then if you can recall, he went through the entirety of the surveillance video at the FedEx. So that's after 9:59. So what we are showing is other evidence that
he does not dispute that he was at the light.
He disputes
at the same time as Mr. Drinks was.
Your Honor, he disputes that Mr. Stillwell is the person who was shooting. He disputes that.
Oh, you absolute tool. You are the one trying to gaslight us into something. Nobody disputes he was there. No one. Not one person disputes Miss Shannon Stillwell was at that light at that time. What is in contention is, was he the shooter? This is just, oh, he was there. We know.
The call at 9:59 was a call to get on FaceTime to shoot Mr. Drinks. We are saying that call, that FaceTime call, is a call where they said we are getting ready to go shoot the ops. That's why they get on FaceTime. So he is challenging all of that, Your Honor. So what we are showing is at 9:59, if you look here on the ankle monitor, he's at 464 Windsor Street. That is the BP gas station. He then a minute
9:59 is accurate.
Here's
and lined up to, I mean, I don't see how you can establish that 9:59, according to the ankle monitor company, is, spot on to the second. 9:59, according to the wiretap.
But we're saying that it's accurate time, Your Honor, because he wants He's at 464 Windsor, which is where, if you look at the BP gas station video footage, that is when all the cars begin to pull off from the surveillance video at the BP gas station.
But there is no cross-reference to the wiretap, which is the point.
But-
That was
but
my
the-
only point,
but
is
that's-
959 on the wiretap. We don't know when it is on the rest of these devices, and this information does not give us, or other surveillance systems.
Agreed.
And
Do
this-
you have him on the video at the BP station talking on the phone and going like this?
We have the wiretap that has him, we believe, the phone plot.
I know you believe it. Do you have evidence to establish it?
Our evidence is
that-
circumstantial evidence that he is at the gas station. Do you mean, do we have direct evidence? No. Your
No,
Honor.
do you have evidence that the 959 that you want is the same 959 on all of the different things that recorded time in video?
That is why we're showing this, Your Honor, because we're trying to show circumstantially that all these times are.
How
together.
are you showing circumstantially that it lines up?
Your Honor, because when we look at the ankle monitor information,
Oh, George Whitaker. Now she's pissed. Shut this down.
he is at the 464 Windsor at 9:59. The call comes in at 9:59. The BP gas station surveillance video has 9:59. So we are showing that all of these things coexist. So the time cannot just be off because all of the time are at approximately 9.
That's if he got the call when he was still at the gas station.
Your Honor,
The fact that they all at some point say 959 doesn't establish anything if you don't have a video that shows him talking on the phone at 959 so that you can go, aha, see, the video lines up with the ankle monitor that says 464 Windsor Street. Otherwise, it's just what you want it to say, but it doesn't actually, even circumstantially, establish that. You can argue it, but you can't have a witness say, yep, this says 959, so that means
but we
that's
didn't
when
ask her to say that. Your Honor, we never asked Investigator
But-
Viverito to
but-
say that. We asked
I
her
know,
what
but
time
you
is she.
were telling me that's what you were
No,
leading up to having her say.
No, it's not, Your Honor. What I said, I would never have her say, is he exactly on the phone at that time? Because he's in a tinted car, so we don't know. What we know is from the wiretap that at 9:59, there's a phone call. That's what we know.
That
I
at
can never-
9:59, according to however the wiretap clock was running.
Correct.
Your
Yes,
Honor,
so
that's
nobody
what-
disputes that.
Your Honor, we've stopped talking about
Ms. Hilton, you
9:59.
came up here and said, I'm asking these questions so that I can establish that the timeline lines up for everything.
Yes, Your Honor, that the timeline lines up. So at
Okay.
this point, I can show that all of these different devices are around approximately the same time.
I don't think anybody disputes even that it's
But-
approximately the same time.
Mr. Schard does. Okay.
You can have her, it's in evidence. You can have her read something, but you cannot have her say, yeah, that means all of these times lined up.
I
Or that
never was
means
gonna have-
9:59 here and 9:59 on the wiretap were the same thing.
We never had her. We were finished with the 9:59, Your Honor. The only thing I had just asked her was about PJV2 when he objected. We were finished with 9:59 about 5 questions ago. So the only thing that Mr. Schard objected to at this time was that she was reading PJV2.
No,
That's
that
what the
she was
objection-
about to interpret.
She was not, and that's the thing. That
Okay,
was
well,
All
great, she's not going to.
bullshit.
Okay, well,
that wasn't the state's intention.
I
Okay,
don't
then I have
know.
no idea why you think any of this is going to establish that all of the times lined up, but
I'm going to object on relevance grounds at this point because I don't know where we're going, but it seems that they were trying to establish something. They said they're done establishing that, and Investigator Viverito is still interpreting ankle monitor data. So I'm going to object to relevance in 403.
Your Honor, she's
403.
as I stated earlier, Mr. Schard has challenged what occurred at the lights.
I
His-
know.
So at this point, we're just showing, based on admitted evidence,
That he was there. That's all. You are only trying to, with another piece of evidence, say he was there. Nobody disputes he was there. You're just trying to get Miss Viverito, Miss Marissa Burrito to interpret.
occurred at the lights, Your Honor. That's all.
Can I ask a question? Why is it improper or not relevant? So if there has been questions and testimony about whether the times for everything sync up, I think it's been Mr. Schart's, his argument the entire time. Well, in the screenshot that was admitted to Detective Hogan, and
Okay, I didn't rule that it wasn't relevant. What we discussed up here at the bench was that it's not within the scope of redirect, which is when Ms. Hilton said, oh, yes, it is, because I'm going to be establishing that all of the times line up.
he, on cross, he disputed that the 9:59 from Wiretap was anywhere close or could be related to the 959 anywhere else.
The only way they can do that is by placing Shannon Stillwell on the phone, on video, at the same time as the wiretap time alleges. And there isn't one.
Was established as being the same 959, and I have heard nothing that, maybe you could tell me how you can establish that.
So at 9:59, when he makes the FaceTime or the call, he is at 464 Windsor Street. Okay, so then you go to your next step.
No, that is, how do we know that he's at 464 Windsor Street?
Says it.
Because some other item of evidence says it, and we don't know that they're all running on the same clock.
That's what we're trying to show you it is, because at 9:59 if everyone would just wait and we'll get to the big ta-da. So at 9:59 on the wiretap thing, it says 464 Windsor Street. On the ankle monitor, on a separate device, at 9:59, Mr. Jackson is at 464 Windsor Street. That correlates. They're in the exact same place at the exact same time. At 10:02, it shows that he's at PJVR2, whatever. That's the intersection of I-20 and the light. And then at 10:02 on the FedEx.
You have already argued this. Jesus
thing, and
Christ.
it says 10:02:17. So it's the exact same thing. It's to show that all the times line up. All this questioning that the times are not accurate, that the times don't sync up. We're proving that they actually do sync up, which is what he challenged Investigator Viverito about this 9:59, and she's just making it up, and all the evidence is being presented as how she wants it to. And now we have physical evidence from different videos that show they actually all do sync up, that they're all running on the same, time width or band, whatever.
I think you can argue that. I don't think that is established. But if you want to have her say, but Ms. Hilton says y'all already left 9:59 anyway. So I'm still at a loss as to where we are. But we'll just get her back in. And
I have a motion before the jury comes out to bring her back in, because unfortunately it's my job to further tax the patients in court.
what's that?
Yeah, I have a motion to strike the testimony of Investigator Viverito as well as any evidence that came under her. And the reason I make this motion, Your Honor, is yesterday it came up that she had not been, that she had been following the case. The court asked me to not
No,
pursue
it
that.
did
I'm not.
Come up that she had been following the case. It came up that she knew that somebody had mentioned her on Twitter.
Okay, and your opinion would have been different if she was following the case? Because
No, if you know that she was following the case, that doesn't exclude her as a witness. You can let the jury know that.
okay, because
You can ask her that.
I can ask her about her following the case?
Sure, and we'll see what she says.
Okay,
And if that's so, then it still doesn't exclude her testimony. It just lets the jury know, well, she may know some of this other stuff from listening to some other witness.
okay, because what I would like to get into, and we may as well bring it up now before the jury is here, is that she got into an altercation out in the hallway with Kayla Bumpus.
Why
with-
is that relevant to the guilt or innocence?
Oh, wow. Oh, wow. She got into a fight with Kayla Bumpus? Oh, good luck.
I'm about to go there, Your Honor.
Okay.
Just let me finish a second. She got into it because she was watching Kayla Bumpus's YouTube feed about this case. And Kayla Bumpus apparently called her.
Okay, you may get into whether she has been tracking this case.
Mhm.
You may not get into whether she got into a dispute with somebody
gets into
about
her-
their posts.
It gets into her bias against these defendants, Your Honor. It goes directly to it.
What are you proposing to ask?
I'm proposing to ask if she told Kayla Bumpus in the hallway that that was the last time she was going to call her a hoe. It goes direct.
I'm sorry, the last time who was going
That
to
Kayla, sorry for the pronouns, that Kayla Bumpus was going to call Investigator Viverito
We need to
a
get
hoe.
into who it was, or just that somebody,
I think
So we now know that not only is she following the Twitter, she's actively going in to people's streams and watch the streams. Kayla Bumpus' stream, where Kayla called her a hoe. Oh, I wish I was there. I would have loved for Detective the Burrito to try to confront me. Oh, I would have loved that. Yeah, Miss Burrito is actively harassing people for exercising their First Amendment right.
we need to get into who it
Fine.
was.
Why?
Because she's married to Mr. Jackson.
Well,
There it is. Told you. She's married to Mr. Jackson. Told you. And there it was. Now that is the absolute confirmation. Thank you. It's out. Boom, it's out.
was she at the time? Is this for real, y'all?
Yeah. Well,
None of this is relevant. Whatever is happening between Ms. Bumpus, Mr. Jackson, has nothing to do with the guilt or innocence.
If she is-
Unfortunately, the bias of a witness, well, fortunately, or I strike that. It is not fortunate or unfortunate, except for the fact that it is dragging this case on even longer. But a witness's bias towards a party may always be shown.
if she isn't this, if she
Don't
isn't,
talk at the same time.
Caleb Bumpus is not a party to this incident. Caleb.
Yes, but if she's married to one of the parties, then that might qualify.
If I
Here.
just finish her, I don't know. I'm not the proponent of this evidence. I'm hearing Mr. Weinstein out, but my silence should not be viewed as acquiescence that I believe this should be admitted. I need to hear what Mr. Weinstein's saying because I may have an objection myself.
what I'm saying is that if there is a relationship between Miss Bumpus and the defendant, then Investigator Viverito.
Oh, and now they backpedal. Now they backpedal. Yeah. Yeah. For me, it's out.
Bias against that.
Against
someone-
being called a bad name?
No, if she isn't an
Here's the thing. All the streams have had a Vera. All the streams have had the Avera going in and trolling us relentlessly. Now, that account is yeeted from me, but not from everybody.
altercation with someone that's in a relationship with a defendant, I think, and especially if it is a threat, because
How is that a threat?
that's the last time you're going to call me a hoe. I mean, I've had clients arrested for less.
You may ask.
Thank you, Your Honor.
No, I'm not finished with my sentence. You may ask if she is following the case and has been following the case in any kind of manner. But it's really only relevant if she.
Well, if she says no, then you can impeach her. If she says yes, then you have it. You can continue. If she says no, that's a prior inconsistent statement. Yeah. Vera Blunt. She's been in my stream on occasions. I usually just time her out, but last time I just yeeted her.
Listened to the testimony of a witness. So you could ask that. But if she's just looking at, and I don't even know if she was looking at, maybe somebody told her. So why don't we get her in here and find all of that out outside the presence of the jury before we go into something that ends up being a bunch of nothing?
Well, that's why I wanted to bring it up when the jury wasn't here, Your Honor.
So can we also bring up before we go into the side searches, the fact that Ms. Bumpus represented Mr. Copeland, I'm about to open up.
Yeah, I mean, I don't think saying who this is before we find out anything. I mean, do we know whether, we don't even know whether she's actually married to him or if she was married to him at the time, or if Miss Viverito knows that, or if it was because of any kind of bias against Mr. Stillwell, or just that she doesn't like being called that name.
Well, and no one would, Your Honor, obviously. But if she is in an altercation with someone in a
What do you
relationship,
mean by altercation?
a verbal altercation,
Okay. I mean,
you know,
a
if there's-
verbal, that's
if
the
they're
last
either-
time you're going to call me that?
excuse me, I'm sorry.
That's the last time you're going to call me that? That's not exactly an altercation. Is that,
Okay.
is that all you got?
That's all I have.
Okay, that's it. I think that this is 403 material.
There we go. One for the stick.
Hoisted on my own petard, Your Honor.
Correct. All right, let's get the witness back in and the jury back in.
Okay, redirect will be fire. Or a recross, sorry. And I'm not saying that Mr. Stillwell is a dangerous, Mr. Yeah, Mr. Shannon Jackson is dangerous, but I mean, he was stabbed in jail during this trial. He has been involved in interesting events. And now an investigator goes up to his alleged wife and says, "That's the last time you called me a hoe." That's not a person who is scared of these people, and yet that is the reason why they claim she shouldn't be on video. Yes, a 304 is a hoe, while 403.
F.
Yeah, it's a cop making the threat. That is how unhinged this Miss Vivorito is. She can't handle being questioned, so she went off in the hallway.
And looking at 397 VVF, do you see that same PJV2 plus VR location that you saw on the spreadsheet?
I do.
Okay. And are you able to tell where that intersection is?
I am.
Where is that?
At Windsor, it looks like just north of Rawson or at Rawson.
Okay, so they got this in.
Gun that was on the table at 2830 Waters Road.
I do.
And he asked you about 3 types of guns: Springfield, 6 Hour, and Smith & Wessons.
Yes.
Right. First, let me ask you, do you know if a Springfield makes a 40 caliber weapon?
They do.
Do you know if a 6 Hour makes a 40 caliber weapon?
They do.
And do you know if a Smith &
Did you just Google that? Ho?
Wesson makes a 40 caliber weapon?
They do.
Permission to approach, Your Honor?
You may.
I'm going to show you what's been marked as Exhibit 531 VV, 532 VV, and 533 VV for demonstrative purposes only. Tell me if you recognize those types of weapons: a 531, 532, and 533 VV.
One is a Springfield XD firearm. One's a 6 Hour P229, and one's a Smith & Wesson.
And looking at those,
So that was what they were discussing in the break between. Yeah. Remember, she is
3 weapons,
not allowed to discuss this with the prosecution.
are they able to illustrate what you were talking about, the distinction between the Glock 27 as well as these other types of weapons?
Yes.
Your Honor, this time the state would like to admit 531 VV, 532 VV, and 533 VV for demonstrative purposes.
Admitted.
Okay, I just checked Twitter. I need to catch up here. So
Permission to publish?
let's go directly to Recross.
Thank you, Your Honor. May it please the court. Investigator Vivorito, good afternoon.
Afternoon.
So you were just asked about LPR readers, and I think the context is figuring out the car that did the U-turn and the car that sped up behind Mr. Stillwell.
Okay.
And you said you need a license plate and that you can't see the license plate from that video.
Or if you have it, sometimes a make and model search might work, but at night, in my experience, it's not very accurate.
Well, are you aware that it was in fact a make and model search that night that revealed the license plate of the white Audi and the white Ford Fusion?
No.
Okay. That Detective Ender, I believe her name is, did? Okay. So the bottom line is LPR search by make and model, it's never going to work if you don't try, is it?
No, but if you're saying she did it for those two, it probably should have captured whatever other car.
Okay, I agree. All
Yeah,
right,
but-
so what's the license plate of the car that sped up behind Mr. Stillwell?
Well, I was going to continue. Like over the summer, I've been working in investigation quite extensively, looking for a very particular 2 cars in the city. I probably have searched every LPR in the city by make and model. And at night, you may put white Nissan, you may put white this, white that, and I'm getting back white Tesla, when I look at the license plate and pull up the results, they're not correct.
Okay, I appreciate that anecdotal story about what you've been doing this summer, but the fact is, that night, make and model was used to reveal the license plate of the Ford Fusion and the white Audi.
Right, my anecdote,
And it was nighttime on March 14th, correct?
right, but depending on what LPRs those cars had hit, that location on Windsor right there, I don't know if there's one right there that would have caught it clear enough.
Okay, well, what LPRs did the car that sped up behind Mr. Stillwell that has not been tested for gunshot residue? What LPRs did that hit?
You'd have to ask Detective Hogan.
Okay, wait. You keep saying ask Detective Hogan. One minute you're on the side of Windsor Street trying to find homeless people as part of this case,
Correct.
and the next minute you don't know anything about the case and just ask Detective Hogan.
That's not what I said.
Okay, well, I want to know, do you know if any LPRs were run on the make and model of any cars besides the white Audi, the Ford Fusion, and the red Versa? Do you know if any other LPRs were run or even attempted to be run?
First, I wasn't in charge of running the LPRs for the case,
Okay.
and if they were running it by make and model, that maybe they saw, if you have a make and model, it's much easier than just say, not having one that you're looking for.
You talked about the phone conversation between Mr. Stillwell and Mr. Garlington about he never told Mr. Garlington, I don't know why I'm being arrested or something to that effect, or I don't
Correct.
understand. Okay, when people are arrested, you've arrested people before, right?
Correct?
Okay, and you typically tell them what the charges are. You give them that courtesy.
Yes, of course.
You tell them what you're arresting them for.
Of course.
Okay, they don't have to agree with you, but you do inform them of it.
Correct.
Okay, so are you saying that Mr. Garlington is the first person that Mr. Stillwell would have talked to after being arrested on that jail call or that phone conversation? Is that what you're saying?
No, he'd been in custody for a minute at that point.
Okay, and you would agree that there's probably been significant ability for the people that arrested him, other people involved with the case, to inform him what his charges are and generally what he's accused of.
I don't think that's what Ms. Hilton meant. That's not how I took the question from me.
We pulled out this mapping information for the call on March 15th at 2 a.m.
Correct.
And it showed that, remember that radius? And it was
Correct.
Mechanicsville.
Correct.
Mechanicsville is in fact in the city of Atlanta, correct?
Correct.
It's in the city.
Correct.
And finally, just one other thing I want to ask you about. This night, can you do me a huge favor? I think it's 471 TV. Could you publish? Did I get the number right? Oh. Okay. This is 471 VV, and that is a picture of Mr. Nichols, correct?
Correct.
And on it says, on the picture on the right says, what you saying, I run with cold-blooded killers, bloody killers.
Correct.
Okay, now, I'm not an Instagram person.
Okay.
Those words, are those words that Mr. Nichols typed into this photo?
No, I stated that yesterday.
Okay, well, we're gonna go through the whole process.
Okay.
So these words are when you pick a song such as Young Boy Never Broke Again, Villain, and someone clicks on the post, the music plays, correct?
Yes.
Okay, and as the music plays, lyrics come up.
Correct. You select a portion of the song that you would like to play.
Well, that's not entirely true. Instagram suggests a portion.
It's like between a 10 and 30-second portion.
Yeah, and
You
Instagram
can,
suggests.
you can agree with it or you can modify it.
Right, but Instagram suggests.
Correct.
Okay, so if I'm posting something and I want Young Boy Never Broke Again, Villain, I'm going to post, I'm going to say that's the song I want, and Instagram makes a suggestion.
Correct.
Okay, and now I want to go to the video. Ms. Knight, can you help me out with the VVA? Thank you, Ms. Knight. 471 VVA. And Ms. Knight's about to publish it. What I would like to do, and I know we've seen it already, but if you would indulge me. tell me when the screenshot that you took and provided in discovery for 471 VV, tell me when that comes up.
Well, no, I turned over.
On this post where it had this by Mr. Investigator Viverito, when you saw this story by Mr. Nichols, you had to scour this story to find the spot on this post where it had those lyrics, didn't you?
Well, no, I turned over and discovered the video in its entirety because I felt all of it was pretty.
Oh, that's not his question. That is not his question is because you presented a screenshot. That is what he's asking for. And now I turned it over. That's not a question.
Damaging and consistent with the case. But it's my understanding that we had to condense the social media. So that was the screenshot that was turned over in lieu of the video.
I'm going to ask that question again. To get that screenshot, you had to parse this to a millisecond to get those words up on the screen.
Or I just took a screenshot and it happened to be that one and we kept it.
Oh, it just happened to be that one.
There are other things that probably would have been better to keep
Okay.
that weren't kept.
So, so you just happened to screenshot. Now, you would agree that in this video, there's Mr. Nichols and these lyrics are being shown on the screen as music is being played.
Yes.
And you would agree that many of the lyrics, as the song is being played, are up on the screen and easy to read.
Correct.
Okay. And right before the lyrics become easy to read, there is a split second, a millisecond, that has those lyrics in that picture. 471 VV, isn't that correct?
Correct.
You don't even know if those lyrics were the ones. First of all, you don't know if it was just suggested by Instagram or actually chosen by Mr. Nichols, right?
The song was chosen by Mr.
Yeah,
Nichols.
of course, the song. I'm
Okay.
talking about the lyrics. You don't know if it was Instagram choosing these lyrics because these are the most popular ones in the song, and they make a suggestion.
No, but based on the rest of the videos on the post, the theme is murder, bullets, guns,
Okay.
things like that. It fit.
So again, and you don't even know when it's on for that millisecond. Just supposing, hypothetically, if Mr. Nichols did choose the lyrics, you don't even know if that was Instagram just had the last lyrics up and then was getting to the lyrics he chose, which are shown clearly, or if it's something that Instagram just chose. You don't know.
I don't, but he can preview the post before it posts to his account.
Okay. So you have absolutely no evidence that Mr. Nichols intentionally chose those lyrics.
Which is why I included the video in its entirety with the other posts about murder and shooting.
And in preparation of this case, you scoured this video and paused it at that exact millisecond when it had those lyrics. didn't
Did
you?
not. I took a screenshot.
Okay, took a screenshot. I'm sorry. At that exact millisecond where it had those lyrics that are in
I-
471 video.
I probably took several trying to catch all the lyrics, and that was probably when we had to condense evidence.
You probably. Where's that? Where are those? Did you file it in that non-existing report? Again, she's making crap up as she goes along because she's not used to being questioned like this. So she's up there lying.
That's when it was chosen.
How many different screenshots did you take?
I have no idea.
Well,
We're
can
talking
you
about.
just tell me from your report?
I can't. You can look at my folder that was served to discovery and tell me.
All right, thank you.
You're welcome.
Ms. Weinstein, anything? Okay.
Oh, please. Oh, please.
Good afternoon, Investigator Viverito.
Good afternoon.
So you mentioned that Mr. Kendrick's phone was seized at the time that he was arrested on May 9th, 2022, correct?
It was.
And his phone was extracted.
It was.
Did you review that extraction?
I did.
And if you reviewed that extraction, did you see that he had been spending several months in LA and had only returned to Atlanta within a day or two of the day he was arrested?
I did.
Did you also see other location data within that phone?
Absolutely.
Okay. And in that location data, again, he'd been spending the bulk of his time in California, correct?
Correct.
All right. Did you look through all the photographs on that phone?
I looked through a good bit of them, yes.
The two photographs that were shown in court this afternoon, are those the only two photographs of interest that you believe were in the phone?
No, there was probably a few.
Okay. Did you find any evidence on that phone that Mr. Kendrick was in possession of any firearms?
No.
Okay. Let's briefly return to the Richard Mill watch.
Yes, sure.
I understand the eye roll. During the seizure that day, and I'm looking at a property report.
Sure.
During the seizure that day, you, and when I say you, I mean APD, can I say under your supervision? Is that accurate?
I didn't work for APD at that time, so I
Well,
couldn't.
Okay, then let's just say APD. Y'all see, APD seized, APD seized a necklace and a pendant from a bedroom, correct?
I guess I'd have to look at the report. I don't have it in front of me.
Okay, well, you were involved in this. They seized a blue box of jewelry, correct?
Correct, in a red box.
And a red box of jewelry. They seized jewelry that was on Martinez Arnold.
I believe so.
They seized a Chevy Corvette,
Yes.
a Dodge Durango,
Yes.
a Mercedes-Benz AMG,
Yes.
a Mercedes-Benz GLS class,
Yes.
a Porsche 911,
Yes.
a Jeep Grand Cherokee,
Yes.
a pink Lamborghini,
Yes.
another Mercedes-Benz aluminum silver,
Yes.
about jewelry that was located in a Mercedes AMG.
Yes.
And they even seized a ring found on Jeffrey Williams' hand, correct?
I'd have to see which one was on his hand. I didn't have any contact with Mr. Williams when he was arrested.
Okay. So despite seizing all of that, you left behind the Richard Mill watch, pink with a white ceramic case.
Again, Mr. Weinstein, as it's being inventoried, the jewelry is being looked at. I use photographed. The jewelry is being put on the thing. If you watch the video, and it's placed on the shelf, and nobody messes with it again.
So is that a yes?
Yes.
Okay, thank you. I have no further questions.
Thank you.
All right. Thank you, Detective. You are
Thank you, Your Honor.
excused. Do you have any more witnesses?
I know, but before we do, we just need to, can we have about 5 minutes, Your Honor? I just want to confirm that we have in evidence.
To make sure that everything's in evidence? Sure. We'll take a short break.
Okay. And magic of recap.
Prosecutors, do you understand that? Do you understand that? All right. And do either of you need any more time to talk with your lawyers about your decision whether to testify? All right. Mr. Kendrick, do you personally want to testify or not? Okay. Mr. Stillwell, do you personally want to testify or not? All right. I find that each of these defendants has made a decision whether or not to testify with an understanding of his rights. All right. All right, we need to do anything else before we get the jury out, and I'll ask if you rest. And then have
Here
you
we
made a
go.
decision about whether y'all going to present evidence? Okay, you want to let me know, or you want to be dramatic about it? Okay, all right.
The state will rest, and both Doug and Max say they will not present evidence. There will not be a defense case in chief. I am a bit disappointed, I must say. But regarding to the charges, I do believe that the drinks murder, that's so gone. I cannot, for the love of me, see that sticking. The Donovan Thomas murder, no. Again, but I'm clearly biased. Don't listen to me about that one. And all the other things, we we are 9 days from a full year of this trial. 9 days. And I assume this will, once the jury gets in, the state will rest, yada, yada, yada. And then my assumption is that tomorrow will be, they have to work through the jury instructions more. Then you have the curative instructions that are still pending from Judge Glanville. That has to be addressed. So that I assume that will take a full day tomorrow. So jury instructions, curative instructions, and closing arguments. My prediction is Thursday. And then we will be on verdict watch.
All right, then I'll get them out. We'll close the evidence. I'll let them go for today and tomorrow, have them come back on Thursday. And tomorrow, I mean, we can start the charge conference. And, oh, forgot something. There'll probably be a motion, I suspect. Okay, all right, forgot about that.
Motion for
Okay,
directed
so
verdict.
I guess technically you need to rest before that motion. So I'm going to have to bring them in, then excuse them again. Okay. Yes.
I understand that we're trying to keep things moving. I'm going to ask if Your Honor would consider giving us the afternoon and evening to look at the directed verdict motion. I know that you've suggested we need to be doing that, but there's only 24 hours in a day, and I think it would probably be more fruitful if all of us had an opportunity to review kind of what's come in, and so we can sit down and have an educated discussion.
Sure, that's fine.
All right,
So
thank you.
tomorrow we'll gather together. You'll present whatever motions you have,
Thank you, Your Honor.
whatever response there is. I'll have to consider all of that. But I would also like to do the rest of the charge conference, the RICO part of the charge conference.
Can we have a further discussion with that once we excuse?
Yep, sure. Okay. What are you, do you need?
I was thinking procedurally, what happened? We rest, then we have, we bring.
We rest. I let them go for the day. Or I think.
Your rest.
All right, thank you. Okay, ladies and gentlemen, considering the hour, I think that I'm going to let y'all go for the day. And then actually tomorrow, we will all have matters to take up outside of your presence. That's been kind of a common theme in this trial, and it happens in every trial, I promise. So y'all will have the day off tomorrow, and we'll see you back Thursday at 9 a.m. And just let me remind you, all of the instructions that have been applicable to you for the entirety of this trial remain applicable right now. Don't try to find out any kind of information about this case from any source outside the confines of this courtroom. Don't talk to anybody about this case. Don't let anybody talk to you about this case or anybody involved in it. Don't try to do any research about the case. Don't ask anybody hypothetical questions about the case. And we'll see y'all on Thursday. Thank you. Okay, so what else did we want to discuss?
When we were, Your Honor, when we were talking about the RICO jury instructions, I guess what I'm trying to figure out, I understand that we have certain jury instructions, preliminary, we both submitted preliminary jury instructions. And I know that we have certain ones on that document that we're all sharing.
Mhm.
I'm just trying to make sure, are there any other proposed instructions from the state that I need to be aware of to prepare for argument? Because I don't want it to be
Good
sprung at the last
question.
minute.
I mean, I haven't gotten any. Are there going to be any more forthcoming? I've been trying to put some together from various things that I've culled from different RICO cases. And that was pretty rough when I sent it to y'all yesterday. I've worked on it a little bit more today. So I'll send y'all an updated draft, which Ms. Percival, let me send that to you right now. So what this is now, it will look somewhat familiar, but it's in a little bit more polished form. So the first 4 pages are what I've put together. And then the last page and a half probably is lifted, some of the language lifted from the APS, RICO, not APS Atlanta Police, APS Atlanta Public Schools cheating trial. I have looked at some other trials too and tried to pull some language from that. But if there's something else, I haven't gotten it yet. Mr. Floyd, are you going to be providing us with any suggested jury instructions on RICO and/or a possible verdict form with regard to RICO, which would be really nice?
Those are separate but related questions, Your Honor. So to answer the first one, we haven't sent anybody any additional ones. We've looked at yours. They've been kind of evolving. But I don't have very much complaint about them. They're largely drawn from APS, and I wrote those. So I'm not, it's only just a matter of whether there's anything in between.
Those aren't actually drawn from APS. I didn't look at the APS stuff until this afternoon, but okay, you can take credit for it.
Well, okay. And I thought that's what you said. I'll tell you that they're not drawn from APS. They're drawn.
So this is the person from the district attorney's office that will go through the RICO charge and stuff like that. He will not testify in front of the jury at all. The state have rested, and we also know that the defense will rest without putting up a case in chief. They will go to closing arguments probably on Thursday, maybe Friday.
From cases that used a version of the APS charges.
Okay.
There might be an intermediate generation, but they.
Anyway, I hear you saying you think they're pretty good.
You heard me say, I think they're pretty good.
Okay.
And I mean, I can't at this stage, because we're just starting this process.
Sure.
I can't foreclose that depending on what you decide to do with one charge, we might suggest that another needs to be supplemented and we add something.
Sure.
But I think.
You don't have any whole scale additions that you think need.
No.
We'll just hash through it. Okay.
I do not, and I think there's one issue that has to be resolved. I mean, I only have 2 charges submitted by Mr. Kendrick.
Yeah.
I don't have any charges submitted by Mr. Stillwell. On RICO.
They're working together on it.
We're working together. Okay, that's what I'm just making sure I'm accounting for everybody here. I understood they were from the defense. They had the name Kendrick on them, so that's why I made that specification. Thank you. But I'm gonna surprise you. We disagree with them. I'll explain why. One is a short explanation. One is a longer explanation. You have statute of limitations. And then
Oh yeah, I already told him he's totally wrong on half of that.
Okay,
You missed that part. but-
Okay. All right. It's the opposite. The rule is the opposite of that.
All right. Well, we'll get into the nitty gritty tomorrow if that's okay with everybody.
Sure. And the other one, which is how you instruct the jury about overt acts and what conclusions they need to reach, that feeds into the jury form. And I've done a bit of research and I have some things to say about that.
Well, if you have anything for me to consider sort of in the interim, because you probably are not going to be, I mean, you might be working on the directed verdict motion and response, but if you're not, and if you have something that I could be considering in the interim, go ahead and send it to Ms. Percifield. Because yeah, I mean, it's a lot more straightforward when you're alleging RICO and not a RICO conspiracy. And so I definitely want to get right what it is that the jury has to find.
Understood. Yeah.
So, yeah.
Yeah. So I mean, I can tell you that what the state submitted is based significantly on APS, which was also a RICO conspiracy case.
Mhm.
It was also based significantly on the jury charges that were submitted in a federal Georgia RICO case based on sex trafficking this year.
Okay.
And also on a case that was tried last year in Brunswick that was a Georgia RICO conspiracy.
All right.
So it's sort of the evolution of that. And I'll address what you want me to address, however you want me to do.
Okay. All right, so if you do have anything more in writing, go ahead and send that now. And that includes a potential verdict form, just send it to Ms. Persifield. She can send it out. I mean, I think we've got a list of all of the attorneys, so.
I don't have anything set to send right
Okay,
now. But
that's
if
fine.
it's tonight or first thing in the morning, our view is the verdict form can be very simple.
Interesting.
We would want probably a more detailed.
Tell me more.
Okay, why don't I get into that then, Your Honor? So the question I think that has come up is whether the jury should be asked to decide which acts of racketeering activity the members of the conspiracy agreed would be committed. And there's two approaches to that. One approach, which is usually what defendants suggest, is that there's going to be a very long list of every one of them, and they're going to be asked somehow, did the conspirators, which would really mean any of the conspirators, any two of them, agree this crime would be committed? Because the ultimate objective has to be a substantive violation of the statute. That's the Supreme Court, U.S. Supreme Court said that in Salinas, and I think you've recognized that in things you've said and pleadings that have come along. The other approach is to say, instruct them that they have to agree that the conspiracy contemplated certain types of acts of racketeering activity, and they have to decide whether the conspirators agreed that any of those types would be committed without going to specific ones. So, and usually when I've addressed this issue or something like it, the argument from my opponents is, well, why wouldn't we want to know everything? And the answer is, you get a case like this where you have almost 200 overt acts, about half of them are also racketeering activity. And that is an opportunity for a lot of confusion, and it takes a lot out of the jury. It's a big ask for them, and jurors.
No, we've already asked so much of them.
I suggest we ask not that much more, but that's just me. But the point is that is just not normally how it is done. And this starts out with, and I know we submitted a brief on this earlier, a bench brief, but it starts out with a basic understanding of what conspiracy is. And the crime in conspiracy is the agreement. The crime is not the commission of acts of racketeering activity, because none have to be committed.
Right, it's
for a
the
conspiracy
agreement plus
violation.
one overt act.
Exactly. And the function of the overt act is important to understand too, because the overt act doesn't have to be a crime. And the reason is,
what we are listening to now is the DA's interpretation of the Georgia RICO Act, which, if you listen to him, how can this be so broad and vague? And it is because the politicians who voted this crap through wanted it this vague and broad. That they can use overt acts to circumvent double jeopardy. They can use overt act for things that isn't even a crime. It's absolutely ridiculous, but that is the reality of Georgia RICO.
is the function of the overt act, which is to show that the conspiracy is in operation.
Right.
And I realize I may be telling you a couple of things that you are very familiar with, but I will be very brief. Common law, no requirement for overt acts at all. There's no constitutional requirement. Federal RICO doesn't require overt acts. The Georgia General Assembly decided to track 1648, which is the general conspiracy statute in 2015 that was added. I'm actually kind of familiar with how that happened by coincidence. And so that's it. We have an overt act requirement. But all that overt act does is show that.
Jessica asked, why would the defense choose not to put on a case? Do you think that would affect how the jury views the case? Why would they do that? Because if they put up a case in chief, the prosecution can do a rebuttal case. That is why they probably don't want to risk the prosecution to go another 3 months just because they put up a week of defense case in chief. Do I think that would affect how the jury views the case? I don't know. I wish I knew. I really, really wish I knew. I hope not. I hope that they don't see it as negative. I hope that now you can't win. I heard it so many times. You can't win your case in closing arguments, but you can lose it. So I predict that the prosecution, which they have done this entire time, gaslight the jurors. And if they have somewhat functioning brains, they will see it. And then the defense will put up their closing arguments. And then sadly, the prosecution gets the last word. So, yeah, hopefully, even though they might be, say, half of the jurists just want to convict somebody because they have been there for 11 months. The jury needs to be aware that it's all the prosecution's fault, not the defense. And maybe that is also reason to why they don't put up a defense case in chief. Folks, we are not dragging this on. They were. We didn't even think we needed a case in chief. They dragged it on. That is what I can say at the moment. But one thing that I am so sad I can't see is Mr. Bruce Harvey's opening statements. Bruce Harvey saved his opening statement until after the state's case in chief. Oh Lord, I want to hear that so bad. I want to hear that so bad. Mr. Steele, we heard somewhat of his closing arguments in the plea agreement hearing. But Bruce Harvey's would have been absolutely epic.
The conspiracy doesn't exist solely in the minds of conspirators. It's actually moved into the real world. And there's actually there's kind of a fairness issue in that, which isn't required, but many legislatures decide to do it because it gives someone who, I'll just draw the example, there's folks are having a few beers and there's a lot of talk about what ought to be done. And everybody says, yeah, that's great.
Yeah,
Nobody does anything. The next morning, someone sobers up.
Charge
and says,
somebody with the crime.
hell no. So
Yeah.
that's how it functions. So this question has not come up under Georgia RICO. This question has come up numerous times under federal RICO.
This question being what?
Does the jury have to decide which acts of racketeering activity the conspirators agreed to commit, or is it sufficient for the jury to decide the types? Okay. And the answer is uniform. Every federal court that has addressed this question has said it is type, it is not specific. And I can give you.
I think that makes sense because what is required is they're agreeing to do bad things through a pattern of interrelated racketeering activity.
Yes.
So.
Yeah. And so what we get to, and I mean, just to kind of illustrate it in a case like this, suppose you have members of a gang and they are discussing what they want to do versus their ops. And they say, we hate these guys and we want to kill them. Everybody agrees. Yeah. I mean, wherever they are, we're going to hunt them down. We're going to kill them. If we can get them all, we'll get them all. We'll get as many as we can. Right? Have they agreed to kill a specific individual? You don't know the first person they're going to encounter. You don't know which of the members of the conspiracy will encounter that person first. If they are successful in encountering them, you don't know whether the encounter will be fatal to that individual, whether they'll be wounded, or whether they'll just be assaulted because somebody shot at them and missed. But all of those are acts of violence. All of those are within the scope of the enterprise. Mm-hmm. And in this case, you have all of those things actually happening in real life. They're not hypothetical. A terrorism analogy would be a group of people who.
I hope I get the time to do a mock closing argument. I have done that on a few of the trials I have covered. Not many, because I rarely have the time to actually sit down and think about what would I say. Because most of the time it is stuff that definitely wouldn't be allowed for me to say in a court. But yeah, if I find the time.
Agree to plant bombs. And they say, we need to destroy, I'll put it in Al-Qaeda type references. We're going to destroy the symbols of the great Satan's arrogance. Yes, what are those? His monuments, his hotels, his whatever, okay? We must do this, yes. How far will we go? As many as we can do. They've agreed to make bombs, plant bombs, destroy things, hurt people. We don't know exactly which bomb will get planted, exactly where it'll actually go off, whether hundreds of people will be injured or nobody will be injured. But they have agreed to engage in this course of activity. That is the violation. It's manifest. In federal law, all they would have to have is that conversation. Georgia law, all they would have to do is have that conversation plus an email, a phone call, or in some cases, as it tends to be, many, many other things.
Mhm.
But that's all it is. And that's why, just for the record, I'll give you a few examples. United States v. Applins, APPLINS, 637 F. 3rd, 59 at 8081. It's a Second Circuit 2011 case held. The jury was not required to answer special interrogatories as to which specific predicate acts each defendant would commit. U.S. versus Gutierrez.
What? 637F what? What's
Sorry.
that one?
637 F. 3rd, 59
Okay.
at 8081. United States versus Gutierrez, GUITERREZ, 963 F. 3rd, 320 at 328. District Court was asked to issue special verdict form requiring the jury to identify specific racketeering activities each appellant conspired to commit. It declined, affirmed.
Okay. Is it reversible error to require the special interrogatory?
I could not say that. No, I don't think it's reversible error.
Okay.
I think I believe you have some discretion here.
Okay.
The question is, how is it best exercised under
Okay.
the circumstances? US v. Cornell, spelled like the school, CORNELL, 780 F. 3rd, 616 at 625, 4th Circuit, 2015. Cornell cataloged the cases. It surveyed the federal cases and said I'm quoting, every circuit to have considered this issue has concluded that for a RICO conspiracy charge, the jury need only be unanimous as to the types of racketeering acts that the defendants agreed to commit.
Okay. And that does seem to make sense to me because, again, we're at the conspiracy stage. We're not at the completed racketeering acts stage necessarily. So, okay.
Yeah.
All right.
I won't belabor the point then.
What else? How about overt acts? I mean, those need to, if there's going to be one needs to be found, at least one needs to be found. That would need to be specified, right? And found unanimously, right?
At least they have to be unanimous that an overt act occurred. Yes.
Do they have to agree on one, or can they pick 12 euros can pick 12 different? That's the difference, because if they can pick 12 different, then these guys are shot because somebody will find something. But if they have to agree, all 12 of them, that's a whole other story.
They generally, and I'm looking for, I apologize, I have the language with me. It'll take me 1 second. I have an example, and if I can't find it in 20 seconds, I will send it to you.
Okay.
But the instruction was, you must unanimously find that an overt act was committed, and you must be unanimous as to which one. It was not.
Yes! Unanimous that an overt act was committed, and unanimous in which one. That is that's good. I hope.
Not, you have to go top to bottom. And I think that is more efficient and just less likely to cause confusion. The overt act,
I would like
something
that
the
slide.
statute requires, but it doesn't require a great deal of effort. Here, the question was, and I'll show you the case. It was not a RICO case. Unfortunately, lots of cases talk about what the court did, but don't tell you exactly what it said. They don't give you the exact instruction. A case called United States versus Boyle, B-O-Y-L-E, 96 F. 3rd, 1444. It is out of the Fifth Circuit. It was I just want to be clear, it was not a RICO, it was a conspiracy.
Mhm.
The question that was asked was, do you agree unanimously on at least one specific overt act which was committed in furtherance of the conspiracy to commit each of the offenses you checked in question 1, because there was more than one conspiracy.
Yeah, I'm not sure how much we can say that's on all fours though, considering, like you said, it's a conspiracy case and not a RICO case, which I know RICO's not a conspiracy, but we've got a specific overt act requirement in our statute. Do you know of any Georgia case law or case law from a sister state with a similar RICO statute that answers this question?
Well, let me tell, I'll take a shot at that in a second, but let me back up, because the case I was talking about, I should have said this up front, it was conspiracy to commit obstruction of justice.
Okay.
The federal obstruction statutes don't have their own embedded conspiracy provisions.
Mhm.
So that's a general 18 USC 371 conspiracy, which is almost identical to 1648. So that was under a conspiracy statute that had an overt act requirement, just like ours does.
Okay.
And if you were to match 1648 against 18 USC 371, basically the same statute. I think 1648 is drawn from 371.
Okay.
As far as other states addressing this, I have not found anything.
Okay, and so would your suggestion as to how the court ensures that they find one within the statute of limitations just be to include that in the instruction, not only you must unanimously find one and it must be unanimous as to which one it is, you must unanimously find one within whatever that date range is?
They have to find one within 5 years
Yeah,
of the
no, I know.
indictment. That's the test.
But I mean, would you just say like, you must unanimously find one within this date range?
Yes, I mean, you could, well, the instruction that I saw, that's the other one I was going to talk about. And you suggested that you'd already settled that. I didn't hear exactly how it was settled.
Oh,
But the
I
test,
was- yeah, the other one about like, I can't remember exactly what it said because I've already deleted it from my version, but that anything that wasn't an overt act within that statute didn't even get included, and that's not true. It can be 500 of those as long as one of them is within the statute. They can find however many others they want to outside of the statute.
yeah, and they can go back to the beginning of time
Yeah.
as well. This question was answered in a ruling by
Which
Judge
question
Glanville.
now?
The statute of limitations question.
Yeah, I don't have any question about the statute of limitations
Okay.
question.
All right.
I know that proposition was incorrect, and
Okay.
I understand what the law is.
All right. And then, okay, so I may have been missing the exact question you asked me.
So
I'm
the
sorry.
question I asked is if I am not having them find, overt acts 1 through 190, do you find this or not?
Right.
Then is the way that I ensure myself that they found an overt act that is within the required 5 years prior to the indictment to just tell them, you need to unanimously find at least one overt act within the date range, and your decision about which one has to be unanimous?
Yes, I think that takes care of it. It actually answers both questions. Those were the only two
Okay.
charges I really had much to say about, and I think that would take care of it neatly.
Okay. All right. Well, again, we'll get into the nitty gritty tomorrow.
Okay. All right.
Okay.
For what it's worth in Georgia, the closest that I know of this issue coming up was the Dorsey trial. And in that, Judge Becker had initially said she wanted the jury to fill out this form. That was a substantive RICO. And so she would have been listing predicate acts, not overt acts. But this is kind of the same idea, basically. I don't know exactly why. And initially I wasn't successful in changing her mind, but she wanted to do it after they decided guilt or innocence and then bring the jury back. Jury went 3+ days and they came back and
Well, there are these
were a mess.
federal statutes, or not statutes, I'm sorry, but there's federal case law that seems to suggest that they need to find guilt, and then, and only then, do they need to say what predicate acts they found, which I find to be odd, but
that's mostly, I think, out of the Second Circuit,
Yeah.
and nobody else
Third
has
Circuit,
decided they like it. I mean, you can
that
find
may have been
many
why,
different
but
ways of
anyway,
handling it,
yeah.
especially if you go back.
very odd. Doesn't help the jury at all.
Well, no, and asking the jury to do that if they've been deliberating for a very long time and coming back in and saying, and now you have another homework
I mean,
assignment.
what I want to do is give the jury a logical and correct roadmap as to how do you consider this?
Right.
What are you supposed to think about? What are you supposed to find? If you don't find it, then what happens? I want to give them instructions that actually help them deliberate.
Yeah. And it's actually, there are federal opinions that say sort of offhandedly a RICO conspiracy case is a lot easier than the substantive one. I'm not sure everyone agrees with that, but I don't think it's a lot more complicated. It's really, do you have an agreement? Would the agreement have violated the statute if it was consummated? And was there an overt act? And then as to each individual, were they part of that conspiracy or not? And if it's
All right, let me ask you this.
the nuts and bolts.
So there has to be a, determination from the jury, whether it's a violation of subsection A or subsection B, that, they conspired to either participate in the enterprise or acquire money through a pattern of racketeering activity, and that somebody committed an overt act to further just the criminal objectives of the conspiracy as alleged in the indictment, or to further the specific pattern of racketeering activity that had been agreed upon.
No, it is not. There's nothing, first, to kind of walk it through, there's nothing in the case law that says it would have to be as specific as the second. And so if I'm just conspiring in an enterprise, if I'm just saying, I hear you guys are the best robbery crew in town, I want to be part of it. And they say, okay, but you have to ante up $1,000, or we have to use your car, pick anything you want. Give me your cell phone, lend me $100 till payday, any of that. As long as it ties to that enterprise, that's sufficient. And that's why the overt act itself doesn't have to be a crime. And part of what happens here is if we pile on additional requirements that aren't in the statute.
Okay, so it's just then to further the criminal objectives of the conspiracy.
Yeah.
And it's the criminal objectives of the conspiracy as alleged in the indictment, right?
Yes. So
And
if
it's
I-
not the non-criminal objectives of the conspiracy, is it?
If I wrote a haiku that didn't talk about other gangs or violence or anything else, I don't think that would do it. I agree. But the point is, that overt act doesn't get mutated into a full-fledged attempt or conspiracy of its own.
Oh, yeah, I
because
know.
otherwise the
I mean,
statute
it
would
can
say
be,
that.
we're going to kidnap whomever,
Yeah.
and then we're going to kidnap their daughter or whatever. If I go by rope, that's not illegal, but that's an overt act in furtherance of our conspiracy to do bad things.
You drive by the house and you say, yeah, they're home.
Yeah.
Okay. It's
Okay.
not illegal to drive by the house. It's not illegal to look in the window. But if
Okay.
it's part of that conspiracy, yeah.
Yeah, but the objectives of the conspiracy, I mean, the objectives, so in the indictment, there are these objectives of the enterprise. Why?
The World's End says, so RICO has a very basic act required to be enough to convict you of a thought crime. Yeah, and I said this on a number of occasions. The Georgia RICO Act and the statute allows this affiliation with a criminal enterprise to be spoken and unspoken. That's how vague and broad the Georgia RICO Act is. As long as the prosecution alleges and the jury agrees, they can do it without any shred of evidence, just as long as the jury believes there was an unspoken agreement.
So listed out, some of which
5, I think.
are criminal and some of which would not be criminal.
They have, some have non-criminal aspects to them, yes.
Some are entirely non-criminal.
Right.
And so an overt act to further one of those things would not equate to a crime, assuming all of the other elements are there,
I understand what you're saying.
right?
I think that's correct.
Legally correct? Okay.
It says, the statute says an overt act to effect the object of the conspiracy. It speaks in the singular, it doesn't preclude the
Right.
plural.
And that has to be a criminal object, right?
We're talking about, well, the object is ultimately to violate a substantive provision. I'm not trying to mince words, I'm thinking along with you.
Yeah,
But if you're forming an enterprise, remember that an enterprise can be legal.
yeah.
And so if I form an enterprise as part of this, like different from this case, but an example, I form a corporation,
Mhm.
but I'm forming the corporation as part of a securities fraud scheme or a money laundering scheme or something like that.
Mhm.
That can be an overt act in furtherance of the objectives of the conspiracy. It is not itself illegal. I think we all agree the overt act itself doesn't have to be illegal.
Right,
The statute says to effect the object of the conspiracy.
right. And when it says to affect the object of the conspiracy, implied in there, but necessary, is it has to be a criminal object of the conspiracy, because it wouldn't be a conspiracy if it weren't an agreement to do something criminal.
You wouldn't have, we wouldn't be charging a conspiracy to comply with the law. That's correct.
Okay.
Yeah.
All right.
Let's see here. Where was that? So RICO hasn't even been litigated in Georgia before? It has. It has been up, the statute, the Georgia Act itself has been up to the Georgia Supreme Court. Have any of the previous cases gone beyond appeals court up to Supreme Court? I'm not too sure. But what we do know is that the Georgia RICO Act and none of the RICO trials has ever been handled outside of Georgia. Never.
Anybody need any further exposition before we get more detailed tomorrow?
No, I just want the opportunity to respond tomorrow.
Oh, absolutely. And if you want, I mean, it's only 4:20, so if you want to respond to anything right now, go ahead.
420?
But y'all wanted the afternoon to work on the directed verdict, so.
Right. And I'm going to reiterate my humble request of the state in an effort to get to the bottom of the directed verdict stuff and arguments. I know you're busy. Could someone please send over email copies of the exhibits that you have admitted? Because I think they were giving us, for most of the trial anyways, PowerPoints of the upcoming exhibits. And I think that would cut to the chase about a lot of these directed verdict. Because my memory is not perfect going back 8-9 months.
I believe Ms. Knight has started, and I thought she sent the link. I'm confirming. Are there
Okay.
certain acts that you want, because of the amount of media in some of them, and they're taking a little longer? Are there certain acts, and we can talk offline.
Yeah,
Are there certain acts that we can start with first, and then get
Okay.
the other?
The evidence admitted. That shouldn't be a hard question.
And I assume you'll have, if you find it, whoever that law is that you, we're talking about on the downtown.
Yes. Yes, Your Honor, I will forward the case.
All right. And then y'all have specifically a list of evidence that exists and is admitted in this trial to support every one of these counts, right? Because I'm assuming, I mean, I don't know what they're going to move for directed verdict on, but you'll have the answer as to whether there is evidence to support it. Okay.
Yeah, but if
All right. By tomorrow.
for the sake of argument, say by the end of tomorrow, they missed out on some. Or say for the sake of argument, they lie and send over pieces that they claim has been admitted, but that has only been a demonstrative. I don't put anything beyond the evilness of this prosecution. Nothing.
When we take this up in the morning, like, I don't want you to say to me, oh, now that I've heard what the directed verdict is on, let me have the next 4 hours to get my response together. Because we talked about this a week and a half ago, that we were getting to this point and y'all needed to be ready with whatever y'all were going to say as a defense and whatever you were going to respond to as the state. Okay.
Thank
All
you.
right.
Judge
See y'all
Whittaker.
at, we want to say 9? Okay. See y'all at 9.
Thank you, Your Honor.
All right, 9 a.m. tomorrow. Tomorrow, if they show anything, I will recap it. If they, I don't think they will. I don't think they will. Yes, the state said we rest our case in front of the jury. They have to do that. And then now tomorrow they will work on the directed verdict and stuff like that. Then they will file the motion to the judge about what acts do they want directed verdicts on, which ones will she approve, if any. Then when every part of that is done, then the defense, then she will call the jury back. Then the defense will say, she will ask the defense, do you wish to put forward any evidence? They will say no. Okay. Then she will send the jury home again or out, and then it's time for jury instructions. The probative instructions. No, what's the word I'm looking for? The other instructions, the curative instructions that Glanville pushed forward. Those also have to be addressed. All of them has to be said to the jury. All of them. They actually just told the jury they have the day off. So this will happen on Thursday. The defense will rest in front of the jury. They will send the jury back to the jury room. Then it is... so Thursday will be jury instructions and curative instructions. That might take all day. Because I don't think Judge Whittaker wants the prosecution's closing arguments on separate day from the defense. So Thursday and Friday might be the closing arguments and curative instructions and jury instructions. But, I mean, there will be a lot of it. There will be a lot of it. Okay. Wow. Oh yeah, she definitely needs to put a time limit for closing arguments. My suggestion is give them 2 hours each in total. If prosecution takes 1 hour and 45 minutes, then the defense take their 2 hours, then the prosecution should only have 15 minutes to their rebuttal closing argument. Oh, Ocean Beat says it's 2 hours. Okay, 2 hours each. All right. So Thursday, probably Friday. From Friday, we will be at Verdict Watch. What will I do? I will cover some more about... I will try to get more information about the 12 hours. Remember, folks, there are 12 more people in jail for 2.5 years waiting for this trial to end so theirs can start. So, yeah. Now, if there are acquittals, then the next 12 will have good cause for plea deals. But I don't know. Ocean Beach says Doug wants him and Max to each get 2. Yeah, I mean, they should, but then the prosecution might also get the same if they have to address both defendants separately. So, but we are we are days away from this being handed over to the jury. And then we don't know how long they will take to reach a verdict. I mean, the O.J. Simpson, they only took 4 hours. In the recent Richard Allen, it took 4 days. So, Ocean Beach. Did I see a question from you? I think she made some comment today about the instruction Glanville did. Definitely take a day. Oh, darn it, I forgot. There was a whole discussion in the beginning of today. that is currently a bit lost. Let's see if I can find it. No, not there. Let's see if... Let's see. I absolutely forgot about that. Hold on while I check something. I have to go back to Miss Sylvia's. Okay, so this is from this morning. Yes, Ocean Beach. We did see the drama that happened between Doug Kayla and Detective Burrito. I did see that. Okay, but this is from this morning.
Okay, and so I'm woefully ignorant about Instagram, but does a human being have to select what gets posted, or is it Instagram doing it?
So he posts a picture, and then say if he wants that particular song, he can add the song, and then you have options when you add the song. You can either add the song with words, you can add the song without words. That is his choice, his or her choice, to add whatever content to put on the picture that they post.
Okay, and so at that time, it's not like it just pulls something.
Okay, Ocean Beach. He wants to know if the overt act is one committed by each one of them as individuals or by anyone in gang. I believe it is. They only have to agree on one overt act, regardless of what overt act that is. That is how my interpretation is, at least.
That you posted, 3 years ago and says, "Oh, would you like to look at this today?" Okay. All right. So if y'all
Again,
are
thank you
resolved to handle it the
to
way Mr.
Infamous
Schardt,
Lie Channel for
suggested.
having our backs with everything, because I don't find this the morning, because something happened with the streams today that a bunch of things are lost.
Yes, we'll play the entirety of the video in regard.
Okay.
And just we want to make the record clear, we would have played it regardless, but it was objected to and to be conciliatory and not waste the court time and everybody else's time.
They're still not using
I
the mic, y'all.
understand.
Yeah. The 4 other defendants, their pleas cannot be used against these guys. It's only for themselves, because they have separate charges.
Mr.
not
Schardt
using the mic.
understands too. He just didn't understand that that's where the screenshot came from to begin with.
Well, no, first the question was.
Or not.
Still not using the mic, y'all.
Okay. Okay, so back to the charges. I think we were on around page 18, bottom of 18, with parties to a crime.
They're going over the charges now.
And
They're
I
page-
stated I was going to give it without limiting it to particular crimes. I just want to make sure that we don't have
I'm
subsection
gonna put my
D.
headphone on so I can tell
at
y'all
all.
ahead of time so I don't hear double.
Yeah, you can hear Miss Sylvia in the background.
I'm on parties to crime on the page, for me, it's page 18, 19.
Okay, so they just went over the charges.
1.42.10.
Oh, I get to use a little.
Let's see what Mr. Schard is saying.
Convicted of a different crime or degree of crime is not amenable to justice or has been acquitted. It's like. All right, so with regard to.
Okay, that's really, really. Oh, Catnot Williams. Hello, Catnot Williams and the Slat Gang. Yeah. Welcome. As you might see, back on this morning because I didn't cover this morning. I went directly to the the burritos testimony. Hello, folks. Hello, folks. Good to see you here. Good to see you here. And since most of that is gone from Law and Crime and everybody else, I'm using infamous Sylvia's channel for this stream. Hello, folks. Hello. Good to have you all here. Hit the thumbs up. Oh, I have so many words about this, but I have. If you, welcome. Now, if you want to see my favorite parts that I cut out from this, I made 3 videos. Meanwhile, so you can go watch them. I have words. I have so many words.
Giving this as to the RICO count, I'm not sure it's an accurate statement of the law for what RICO is, because if you're found guilty, or you can be found guilty of conspiracy to violate RICO, even if you don't know exactly what your co-conspirators might do in furtherance of the RICO conspiracy.
But you do have to intentionally join in. On
Yeah,
the
but we're
conspiracy.
going to give specific separate charges.
Yeah, and as I said earlier, for you who missed it, Georgia RICO Act is so broad and so vague that the understanding that you're doing something as an affiliate or associate, the statute allows that common understanding to be both spoken and unspoken. So it could be enough, depending on what instructions Judge Whitaker chooses. It could be enough that the prosecution alleges and the jury believes it, because the agreement can be unspoken.
About, you have to, about what you have to know to be found guilty of RICO, but it's not, this is not exactly true for RICO.
Not for the individual acts, each individual act.
Right.
I agree with that.
The state agrees with lawyer.
But well,
So it certainly applies to the murder counts,
boop,
I would think.
and the guns and the drugs as well, I believe.
And the drugs, the guns, it's really like if they're found guilty of, like for instance, with Mr. Kendrick, if he's found guilty of the drugs and the machine gun, then he's also guilty of possession of a firearm by a convicted felon. But if he's not found guilty of either of those things, they can't be found guilty of possession of a firearm by a convicted felon.
Right, that would be an inconsistent verdict for sure if that happened. But
What,
let me see.
for Mr. Kendrick, it's
all the weaponry. It's
all of the firearms that were in
People who are professional, who's
Yeah.
supposed to know
Mr.
the law
Williams'
are having difficulty with understanding it. Could you imagine the
house.
jurors?
But is he charged separately with possession of those guns, or it's just that? Okay, so, okay, so, all right, then I guess if he's found guilty of possessing them, then he's found guilty of possessing them as a convicted felon.
So I'm trying to understand where the court has come out on whether that knowledge instruction applies to the gun and drug charges against Mr. Kendrick from what's at Williams' home.
I mean, there's the whole constructive possession.
Right, there is,
Law.
I understand that, and there's an instruction, I think there's an instruction on that.
There should be.
Um,
If there's not, we need to put one in.
I believe there is. But there's an intentionality in the constructive
Yeah.
possession as well.
Why don't we put a pin in this one and come back to it? So I don't think it can apply to RICO. I do think it applies to murder. Gangs? I don't
Well,
think it could apply to gangs either.
the gang charge against Mr. Kendrick, make sure I'm saying this correctly. With this 57, it's count 57.
Mhm.
It's based on the
Possession
it's
of,
Oh, I remember this from another stream or discussion. The prosecution forgot something in one of the charges. We need to hear that.
Based on
The
the drugs
guns
and the
and the
guns,
drugs.
yes. Everything comes back, everything is founded on the drugs and the guns, or based upon
Okay.
that.
Yeah, now I remember. The thing they forgot is they did have in the RICO and number 52 and 53, they have this possession of a weapon in commission of a crime, but they forgot to specify what crime was committed. And I don't know what happened with that. If they actually came to a conclusion, or if it's will be brought in the directed verdict from the defense. Because if you don't have a specific crime that happened when you were in possession of the weapon then it's fundamentally flawed. Now, I do believe that the prosecution wanted the judge to allow them to add in that language. But I don't know what happened.
So, right. I mean, the same for Mr. Stillwell. It's gang activity if he's found guilty of these crimes that would constitute gang predicates.
Yes, Chloe Albert's revenge. It's like being arrested for resisting arrest, and that's it. It doesn't fly. I agree.
Okay, so we'll just come back to that after we look at the kind of constructive possession charges. Okay. But it'll at least say, at the least murder. All right, and so part of this knowledge charge includes a parenthetical that, if you weren't knowingly and intentionally committing, participating, or helping in the commission of, or were not a conspirator in, then it would be your duty to acquit the defendant. So the state's certainly alleging that everybody is a conspirator in everything if they are in the RICO conspiracy.
I think the court asked the question, we need to define it here.
Yeah,
I don't think we need to define it.
I think as long as we define it somewhere. Okay. All right, and then mere presence, everybody agrees. Mere association, everybody agrees. Multiple ways of committing a crime. It was requested by the state. Is there any opposition?
Well, we were talking about this, on a call on Sunday.
Chard is in
As
the
I always
session, standing
understood
up to
this
talk
charge,
about the
it was
opposition on
like
this one.
for aggravated assault, like 2 different.
Yeah, if you're wondering if wait, we hear Sylvia. Yeah, I'm using her stream because the other the Law and Crime and Fox Atlanta and stuff, something happened, and up to the first break is gone from their streams. So I'm using hers at the so we can actually, so everybody needs to give a huge thank you to infamous Sylvia, because without her this morning is covered by many, but specifically the final minutes of Mr. Schardt's cross-examination, without Miss Sylvia, that coverage could have been gone forever. So she, no matter how you feel about her, without her, that would have been gone, because every other camera went down. The court pool and the pool feed and everything, but infamous Sylvia's camera still working.
I don't
He's not
know.
using the mic, y'all.
We have it here in RICO because we've got RICO subsection A conspiracy and RICO subsection B conspiracy.
They go Rico. They talking about Rico.
I think that's the only place we have it. And so I would think this should come, within the explanation of RICO. Does everybody agree that's the only place it is here? Okay. So we'll give this charge, but it'll be within the RICO. And let's just skip over RICO for now. So we'll have to come back to that. All right. Attempt
Which page is that, Your Honor?
I'm page 24, 2.01.11. So y'all had mentioned at some point needing to give some sort of a charge on every charge, or, you know, a definition for every charge that is an overt act, but also a crime. Y'all still thinking that? Because I guess that's where attempt would fall.
I don't see how else the jury makes the determinations of whether the overt or predicate acts were committed.
All
unless
right,
they
well,
have
I don't think
definitions.
anybody has submitted what those charges should be. So y'all need to get those put together like today. All right, so attempt will go wherever attempt goes in the explanation of the various overt acts.
Trendsetter, are you saying you can't hear me? You can't hear me? Can you hear me now?
Okay, down to 2.0210 conspiracy, and then conspiracy additional instructions. Everybody agrees on those. Conduct and presence of the party. Everybody agrees. Okay, criminal gang activity. I have now made some suggestions. Y'all can see where things are rephrased. I don't think we have on 2.0225, we don't have any allegation that anybody is employed by the alleged gang, right? It's just associated with, so I've stricken through employed by. Everybody okay with that?
Yes.
All right. And then instead of, everybody okay with commits a crime that constitutes criminal gang activity instead of the mumbo jumbo that is the pattern?
Yeah, I agree with the Mooka plain English there.
Okay.
Is that the highlighted portion?
So
Okay, guys, I'm about to stay in the courtroom and come back and tell you what I see
instead of
in there,
participates
okay?
in criminal gang activity through the commission of any criminal offense in the state of Georgia or any other state of the United States that constitutes criminal gang activity under OCGA 1615.3, just say commits a crime that constitutes criminal gang activity, since we're going to define that in a minute anyway. All right, and then next thing we do is criminal gang activity means the commission, attempted commission, conspiracy to commit, and then there are also possibilities for solicitation, coercion, or intimidation of another to commit. Do we have that solicitation, coercion, or intimidation alleged in this case? Okay, so I'm striking that. And then are y'all all right with the way that it's proposed there to just do kind of bullet points of to prove a violation of subsection A is alleged in 50 and 57?
Yes, Your Honor.
All right, and then element 4 would be a nexus between that crime and the gang. I'm not sure, most people might know what nexus means, but it's not like a word everybody uses. So I would kind of think it would be more helpful to the jury to include a little bit more than that. So what I did some research and found in 2 cases, Dixon and Rooks, where nexus was explained to be a connection.
Yeah, nexus is more or less, there needs to be an actual connection between the act and the person. You can't just say, well, my neighbor, for instance, if my neighbor was home when I wasn't, and therefore he could have committed the burglary. No, you need more of a connection, a nexus, so to speak. My neighbor has been bugging me about my collection of whiskeys for months. And just as I went out of town and he saw it, and now when I come back, all my whiskeys are gone. That is a connection enough to draw an inference.
Between the crime committed and the gang, which we could say that way, or a nexus, a connection. We could also add that the crime was committed to further the interest of the gang. Now, Mr. Weinstein, I noticed that you had objected to the pattern on that, which, okay, I'm sorry.
I was taking
Mr.
notes of
Schardt,
both of us. Yeah.
the pattern says a nexus between the crime committed and the gang, that the crime was committed to further the interest of the gang, meaning proof that the crime committed was the sort of crime that the gang does. Are you just objecting to that last clause, or also that the crime was committed to further the interest of the gang?
I'm objecting to the last clause.
I couldn't find it anywhere in the case law that that's what it
Okay.
meant. So I agree with you. That should not be pattern.
So we're going to strike was the sort of crime that
Well,
the gang does, Your Honor?
Yeah. So the choice at this point is a nexus between that crime and the gang. I could say a nexus that is a connection between that crime and the gang, or
Well, in that case, a really good argument for the defense is the prosecution claims everybody did this in furtherance of the gang. How come everybody's broke Everybody is in jail. Everybody is in prison. And Young Thug is wealthy as fuck. And they didn't even pull his bank statements. They didn't check his economics at all. How can you say? Yeah.
I could just say, or a nexus that is a connection between the crime and the gang. In other words, that the crime was committed, or that the crime was committed to further the interest of the gang. I mean, like basically any of those, any combination of those. What is the preference of the parties?
Can we write that?
It's in front of you. It's on the bottom of page 29. If you have the electronic copy up that Ms. Persfield sent y'all
The language,
yesterday
the
morning.
language you have now is a nexus, comma, that is a connection, comma, between the crime committed and the gang, i.e. that the crime was committed to further the interest of the gang.
Yeah, that's just some language I pulled from Dixon and Rooks explaining what nexus meant. So I'm just saying we could use any of that and it would be.
That language is acceptable to
Okay,
Mr.
so
Kendrick.
you want me to just say it all?
Just exactly like it's written is fine
Okay,
with Mr.
so I'll
Kendrick.
just bullet point or whatever, element 5 will now be that. All right,
Yes, Your Honor.
Yes.
okay, you got it, Laura. Okay. All right, definition of participate. I'm kind of thinking, unless somebody on the jury says, what does it mean by participate? That they know what it means by participate. Okay. All right, and then criminals, definition of criminal street gang.
I hope to all that is holy that the jury will take a very high bar to participating. A very high bar. It's not enough to wear colors. It's not even enough to have a tattoo of ESPN, Miss Burrito. It needs to be actual involvement in the crime or in the overt act.
Are y'all okay with the strike throughs? And I can say it all, but
Have you all pushed the thumbs up? If you haven't, please do so.
okay.
I've covered this damn trial forever. I do deserve a thumbs up, I believe. I covered this trial when nobody else cared. I had 200 views on an 8-hour stream.
So
And I'm still here, and I'm
I would-
still going.
can you see it on his?
Your Honor, could you tell me the page again?
Page 30, bottom of page 30, definition of criminal street gang.
I think.
Okay, well, so the
Okay.
criminal street gang means this is the pattern, organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal activity. And I'm suggesting that the same concept is conveyed by saying criminal street gang means any group of 3 or more persons associated together, which is engaged in criminal activity, criminal gang activity.
Okay. It's just formatted different on my page,
Okay,
but it's the
sorry.
same thing. No, 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 it's okay, Your Honor. I'm fine with that change.
Can I just make one?
Yeah.
Which engages in criminal gang activity, which is
Uh,
defined for you. Because I don't want the jury.
Criminal
to
gang
take a-
activity as defined, have I already defined it by then? Yes.
In 25.
Sure, as defined,
to Take a layman's view of what.
as I just defined. Can you stick that in there? All right.
Or maybe as defined in 225 to be more specific. But
No, because
they
they're not
don't-
going to have those numbers
Oh,
when they
okay,
get the
that's right.
instructions. They won't have the headings. They'll just have the.
Keeping it real with Dom K, says Nick Starro, you're the man, brother. I appreciate you covering this trial from start to finish. Thank you so much. And I'm not done. Little Rod, we need to get him to appeal his conviction. We have 12 more defendants, folks, who are rotting in jail and have been there for 2.5 years without bond, waiting for this trial to end. We have these guys. So during breaks and in jury, while we are on verdict watch, I will try to find out as much as possible about these 12 guys who are still in jail after 2.5 years waiting for this trial to end. We're not done yet. This is not over with this trial.
law.
you.
And then, we'll continue with the existence of the gang maybe established by. And then
Jessica, will you cover the other trials too? If those are streamed, I will cover them. Will it? If it might be recap, daily, bi-daily, weekly, I don't know, but I will cover them. I told you guys a year and a half ago, gavel to gavel. That means all of them. I'm not done yet. This isn't over with this trial.
the pattern suggests as charged in this case, criminal gang activity is, and then I'm supposed to list the crimes in the indictment that would constitute criminal gang activity, although I would only do the ones that they're alleged. So it would be whatever's set forth in, I guess, 57, 50, 51, and 57, right?
Yes.
So as charged in this case, criminal gang activity, I think it's charged in this case, blank, 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 constitute criminal gang activity.
And then those are going to be, you can say they're defined further down. I think you're getting into
So
those
that would be
definitions.
murder. And 57. So it would be murder, and then everything listed in count 57, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, and possession of a firearm during the commission of a felony.
As will be defined for you.
So question here, do you want me to say murder charged in counts whatever, or just murder?
No.
Okay. All right. So then that brings us to 2.1010, malice murder. Y'all say you agree, no changes. We've got some parentheticals, rather it's the unlawful intent to kill, and then you're supposed to only put the ones that apply. And the choices are without justification, without excuse, without mitigation. Is there any argument that any of those things has been established, even potentially in the evidence?
No.
Okay, so it would just end with the unlawful intent to kill, period. All right, premeditation.
Keeping it real with John Kay. You should cover the illegal immigrant trial in Georgia, trial by bench. That guy is a monster. I've heard so little about it, and I don't have time. I simply don't have the time for it. And it's already on day 3 or 4. I wish I could, but I don't have the time. If I only cared about the algorithm, definitely. But I can't. I don't have the time for it. I need to see this one through, the other 12 guys. Now, the other 12 guys, I saw that. How long do you think before the next trial in this case? That could be months. I simply don't know. But since it's Judge Whittaker, it might run faster. Because those 12 were in there because of George Glanville. Now regarding bond, if, say, for with the plea deals, and say Jack Gotti and Shannon gets acquitted, that's a difference in circumstances that might grant these guys bond. Might. At least Judge Whittaker is all about get on with it.
Y'all are in agreement, motive agreement. Possession of firearm during the commission of a felony.
Avoid politics in the chat, please. Avoid politics.
Y'all said you're going to tailor it. Let's just tailor it now. Had a firearm on his person or within arm's reach, right?
Yes, Your Honor, we charged with both of them.
While, there aren't any attempts, right, on the firearm things while committing the felonies of a crime against or involving another person, or a crime involving some of the drug stuff, right? None of the rest of them apply?
Right.
Okay. And then the drug stuff, as I so aptly put it, would be possession with intent to distribute.
Yes.
I guess the easiest thing to do would be just list those again. Possession of marijuana with intent to distribute, possession of marijuana or codeine with intent to distribute, or possession of cocaine. All right.
Why do they clump together marijuana and codeine? It's two extremely different things. Is it because who cares about marijuana, but codeine sounds worse? Gwendolyn, do I think it would be better if they are tried separately, unlike in this case? Well, they are severed from this case. Then it's up to the prosecution to decide if they want to try them together or separately. Will it be better for them to be tried separately? I don't know. I don't know anything about their cases.
I'm sorry, could you give me that list again, Your Honor, that you just
So
read
do
off?
y'all want me to say, while committing, just get to the heart of the matter, which is if you find he did these things, then that would be possession of firearm during this type of felony. And then do I need to say, so my question is, do I say while committing a felony, which is a crime involving or against another person, murder is a felony, which I will define, or which I've defined for you, or do I just say while committing the felonies of murder or possession of these drugs?
I think the latter, you're right.
Yeah, it is
Yes, I
cleaner.
think so too.
Simpler.
Everybody agrees?
Yeah, I agree with Ms.
Okay. So yes, it would just say, number 3, while committing the felonies of murder, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, or possession of cocaine. And that's it. And then for purpose of this offense, a firearm includes any handgun. Do we have rifle, shotgun, taser, or stun? I know we don't have the rest of them. Do we have rifle involved at all? Do we know?
No, Your Honor.
Okay, so for purpose of this offense, a firearm includes any handgun, period. All right, we don't need, excuse me, 2.42.00.
Your Honor, we do. Yes, we do, Your Honor.
We need it tailored to 133, right?
No, unfortunately, no, Your Honor. When we, in looking at the indictment, Your Honor, it looks like your count for the 2 counts, count 63 and count 52.
Oh, this is the one.
Charge 133.
Yeah.
Is missing an element.
Oh, this is the one. Missing an element. Oh, this is the one. Please, Judge, throw that crap out.
It's missing the indictment is missing an element?
Yes, Your Honor. That was going to be subject to motion. And so we believe that the language as charged is a 131 charge and
So
not a 132.
what's it missing?
It's missing the crime that they committed while being in possession of the handgun.
So I don't think y'all get a do-over on that right now.
But we believe that the evidence
Oh, yeah, I agree. There are 196 overt acts. I don't know how many is remaining with these 2 guys, and a lot of charges. If you forget this and you rested your case in chief, then fuck off.
evidence has the
I think it
131.
probably has potentially, but you charged 133. So if you get a do-over to do 106 or whatever it is, then you need to give me law that establishes that.
Okay, we'll get you law.
So either it's going to be, in my view, 133 or nothing, unless y'all have law to change my mind. But assuming it's 133, I think it's,
The do-over she's talking about here is if convicted and on appeal they get a new trial, then they might try it. Then they could change the language. But if they are acquitted, no.
possessed a firearm after having been convicted of a felony involving the use or possession of a firearm. And then I normally would have put blank as a felony involving the use or possession of a firearm, but we'll just hold off on that one until you come up with whatever law you're going to provide. Okay, possession of a machine gun. And I'm going to write this the same way the rest of them are written for whatever this offense is, and then here are the elements. Y'all drop the language of the statute in. I'll just use those elements to do the kind of bullet point thing, okay? So it would say something like the state must prove that the defendant possessed, or it's just possessed, a machine gun during the commission of those crimes. Okay. Tell Laura, just write me a note to rewrite it like the other ones are. Okay, 2.70.10. Y'all agree? So it's for its possession, right, of marijuana or, no, it's possession of cocaine, right? Y'all help me out here.
The possession charge is cocaine and 60.
Okay,
Um,
so it's possession of cocaine. The state must prove that defendant possessed or had under his control cocaine, which is a controlled substance, right?
Correct.
All right, then moving to 2.70.14. For possession with intent to distribute marijuana, the state must prove the defendant possessed with intent to distribute any amount of marijuana. And because it's a separate count, I would then do for possession with intent to distribute a controlled substance. It would say to distribute codeine, which is a controlled substance.
Yes.
Hey, Ryan, can we, I'm sorry, I was typing, can we go back to possession of machine gun?
Yes.
If you did not say, I apologize if you did, do we need to define machine gun? It would be 1611-121.
Let me see what 1611.121 says. Does it give me a definition of?
Yes, it does, Your Honor.
Well, that's very helpful.
Diesel efficient. We know they sold cocaine. How do you get off on that one? Depends on who. If somebody took a plea deal admitting to it, then it's on them. The plea deals are only towards them, and those aren't in this trial. Same with the others, the testifiers. If they pleaded guilty to selling cocaine, it's on them. It has to be proof beyond a reasonable doubt that either Jack Gotti or Shannon Stillwell sold cocaine.
And obviously, I'll let y'all look at it again after we put it together. Okay, so Laura, we can just go and lift that definition from that statute. It's in there. It's 1611.121. It's part of element 1. Yeah. And then definition of marijuana. Everybody's good with that. Did we have testimony that whatever was found was marijuana?
I don't believe y'all introduced any of the lab reports, did you?
There's no lab test, that's correct.
They never submitted lab reports that tested positive for marijuana. And now you're arrested. You can't bring it up again. Oh, wow. Oh, way. Oh, wow. Oh, wow.
Okay, well, anyway. All right, and then there is 2.76.10, actual and constructive sole and joint possession. Seems that everyone agrees. So we've got parentheticals.
Your Honor,
Mm-hmm.
I apologize for not, the GBI analyst who testified about all the pills, she also talked about she tested the marijuana.
Okay.
Yeah, but did you submit that in
State
evidence?
must prove that defendant possessed the
Just because you tested it, but is it in
marijuana
evidence?
controlled substance or gun, right? Or gun at issue in this case.
I'm sorry, could you get that list again, Your Honor?
I mean, I would think it would be the marijuana. I can just say codeine, cocaine, and guns, firearms, because it's a machine gun too. Guns.
Yeah, firearm. There's a half a dozen roughly, so.
Here's a theory. If the jury decides to convict on one RICO charge and nothing else, it's a minimum of 5 years and a maximum of 20. And looking at how everybody else have been sentenced, is it impossible for me to believe that Judge Whitaker will commission it to time served? They've been in jail 2.5 years. You're saying?
Okay, on equal access. Oh, I think it would be the same list of things. Do you want me to read both parentheticals, possess and put those items?
Yeah, no
I mean, I'm
fingerprints or
fine with just
DNA.
possess, Your Honor, but
Now, Thug pleaded guilty of the guns. So how can they still charge the others with the guns? I don't know.
All right, well, since it's your client that's facing those charges, although not with the guns. Just possess and not put the items where they were found. That's an interesting one.
I just don't believe there's been any evidence introduced of
We're just going to go with possess.
putting.
Okay, let's see here. No, RICO holds a sentence of like 15 to 20. Yeah, that's the max is 20. Let's read here. Georgia's Racketeer Influenced and Corrupt Organizations statute, which has a penalty of 5 to 20 years in prison. So minimum 5 years and maximum 20.
Or possessing, but that's neither here nor
Okay,
there.
if moving down to 276.30, if you find that the defendant owned or leased the, where would,
What's the second
Mr.
paragraph?
Kendricks is all the stuff that was found in Mr. Williams' residence, right?
Correct.
That's what he's charged with.
Yeah.
Mr. Stillwell is charged with what? The stuff that was found in the studio?
Okay, hold on. I'm gonna tell y'all
Yes,
what I found
no?
out in a minute.
Okay. Sylvia. Yes, and I have permission from Sylvia to use her stream. I really want to see what she found out.
I'm gonna let y'all listen to this first.
What did I say? Is it the reverse of that?
Yeah, he got charged.
Isn't he charged with possession of that possession of a firearm is if he committed murder with a firearm.
Right.
Okay.
Mr. Williams, the thing that seems a little bit confusing about 276.30 is it seems to be written from the point of view that one of the defendants is the owner of the residence. I don't know.
It may not even be applicable.
Well,
I think it would be. I'll let Mr.
No. I think it would be applicable, but I think it would need to be altered somewhat because it's Mr. Williams that.
Well, I know, but that's better for Mr. Kendrick. If you find Mr. Kendrick owned the residence, well, he didn't. We all know that. Right? So then that part is not, I can read it, or I can just not read that because it's not applicable.
Yeah, okay, now I see what you're saying. Your
We
Honor.
could just say,
Yeah, I read it. So it probably isn't.
I just wasn't sure if instead of saying that the defendant owned an individual.
if you find that an individual owned or leased the residence
Yeah.
where the all of that
Drugs,
stuff
guns.
was found, then you may conclude that that individual possessed everything found there. However, if you find that others had access to the residence, then that individual, then the owner's ownership of the residence is not by itself enough to prove possession. Frankly, the whole thing's just not even applicable here.
Okay. You make.
Okay,
don't object
so
to it.
we
We
won't
can
get that
remove
one at all. All right, affirmative defenses. The note is defense believes this must remain. So I need some.
Let's see here. Diesel efficient. I believe you only get time off if you behave while incarcerated. The judge can't say, I sentence you to 5 years, but because you did 2.5, you get another 2.5 for good behavior. No, this is what happened with Young Thug. The minimum was 5 years. And she took that, not time served, but commissioned it as time served. 2.5 years. And then probation. So she has the discretion. If they get convicted of one act of RICO, or one overt act, 5 years, and it's then up to the judge for sentencing.
Evidence
Go back.
to
Mr. Stillwell keeps trying to trip me. So,
He has no proof of that.
Your Honor, I am taking a stance that, well, again, if there's a directed verdict or if there's some issue with the gun charge, then that solves this problem. This relates solely to the gun charge. We have heard testimony from the gang investigators as well as Investigator Thorpe. Woody's allowed to have a gun. Woody's allowed to have a gun to protect himself. People are shooting at Woody. It's okay if he has a gun. And my stance is that we've heard testimony that people are repeatedly trying to murder Mr. Stillwell.
Oh,
Mr.
this is
Stillwell
good.
is charged with possession of the
I listened to this one. His argument is amazingly good here.
FN 5.7, and he's charged with that. And our stance is, while it falls under F for justification, which is in all other instances based on similar reason and justice as those enumerated in
And
his
can you
charge.
give me a second to find where that's his count, what, 52?
52 and 64.
Yes, I am playing this in
he's
1.5
not.
speed because I
52
need to
and
get to
64?
bed. It's 12:30
52,
where I am.
54. That one doesn't chart. That just is the murder. 64.
It really applies. If he's convicted of 52, or whichever the first gun charge is that's associated with the murder, then that clearly wouldn't be fall under instances of reason and justice. But for 64, when it's a standalone gun, we have laws in place under the jury charge 30110 for justification. And my argument is that the jury charge F is applicable under 30110. Unfortunately, what's complicated is to understand F, you need to.
Hang on just a second. So count 52 charges that on March 14th, he possessed a gun, and that was the drinks murder, right?
Yes.
Count
but if they can't
64
prove the
charges
murder,
he
they
possessed a
can't prove
on
the gun.
17th of March,
Yes. And that was on Meadowlark Drive. The
when
gun
he
that
was arrested,
right. The gun that the state is saying was thrown out the car.
which you
Registered to Miss Alexander.
But that gun
Okay.
couldn't be
And my
concluded
argument
in the murder
is
weapon.
if the jury finds that Mr. Stillwell was in fact carrying that gun around,
Mhm.
and either he or Mr. Nichols discarded it out the window,
yeah, that gun.
30110 F would apply. And the reason it would apply to him specifically is because we have heard testimony about repeated attempts on his life. Now, the dilemma, if Your Honor were to agree with me about F, the issue is that F is a reference to A through E.
Mhm.
So we would have to give them all A through E, but just
Well,
make sure that they understood that I was arguing F.
well, it would only be A. It wouldn't be any of the other ones.
Yeah, you're right, Your Honor. I'm sorry. You're right. It would just be.
Okay, but here's the thing with the law is that if he had been possessing a gun despite being a convicted felon and somebody came up to his window and held up a gun to his temple and said, dance or I'll shoot you, and he shot them instead, then he might be justified not only in shooting them, but in possessing the gun that would otherwise be illegal for him to possess. He couldn't be charged with that. Well, he could be charged. He couldn't be convicted of that. But here, he didn't do anything that was justified conduct. You know what I'm saying? Because it's a specific reference to 16(3), 21, 23, 24, 25, and 26, which is using a firearm in defense of self, home, others.
My understanding of I think it's a Johnson case. It's the one that the Hogues argued and was the first one that dealt with the situation that you laid out with possessing a gun and then using it in self-defense. Even though you're not. My understanding of that case is that you would have a justification argument for the act, the murder, the shooting, whatever it is, but you could still, unless you grab the gun in a sudden emergency,
Right.
you could still be charged with the gun. But the difference that here, from my perspective, is the person in your scenario is just someone who's carrying a gun because they want to carry a gun and they're not supposed to carry a gun. Then something unexpected happens and they use the gun.
Okay,
My
well,
scenario-
he knows somebody's after him.
Right,
Do
that's
you
the
have any
difference.
case law to support your
There's no
argument?
case law I've been able to find.
Making law, huh?
Yes, making law. Someone has to make it.
That's true.
But F exists for a reason.
I don't think there's any law that says that, especially if Johnson is a case that says, if you're a convicted felon, unless you grab a gun in an emergency situation, you're not excused. Your toting it around on your body doesn't excuse you.
For the gun possession. And that is in
Oh,
fact what Johnson says to
Okay,
my understanding.
well, unfortunately, potentially, unfortunately, there is not in the law any exception that says even a convicted felon who knows they have legitimate threats to their life, can go to some government office and say, I've got legitimate threats. Let me carry this gun. That's
Well-
just not what the law is.
Of course, I'm going with the court, and I respect the court. I would argue that that's what F is. That's why F is there.
Hmm.
Because it says in all instances based on similar reason and justice.
Hmm.
And to me, this is similar to 16, 3, 21, 23, 24 self-defense.
I mean, I like your argument. It's a
Thank
good legal argument. It's clever. State want to be heard?
That's just frankly not the law. I mean, the law allows us to, we could charge him with possession of a firearm during the commission of a felony or by a convicted felon 3 different times, knowing that he had it before, and knowing that he had it after he left with a gun, but he could be found immune from possessing the gun during the alleged whatever act he was justified in protecting himself with. But you can't just carry a gun around as a convicted felon and not be held accountable for it unless you are found to be justified in using the gun at the time in which you fired it.
All right, I am not going to give that charge. If you want to perfect the record any further, you can go ahead and do that. But I think it's pretty clear what your argument is.
Yes, Your Honor.
All right, so we will not be given 3.01.10.
In that case, and just for the record, I'm not acquiescing. I'm maintaining my argument, but just in all candor to the court, then we probably don't need 3.00.00.
Okay, or 3.10.10.
Correct.
All right. And we clearly don't need 3.10.11 because it doesn't even exist anymore.
I don't think we need any of these.
All right. I
Justifications.
don't either because they all are like basically if they're so no 1.2 and no 1.3. All right, then venue. Should be indicted and tried in the county in which the crime was committed. I'm going to strike the except as otherwise provided. We don't have that, do we? And then venue for RICO, y'all are both in agreement that the one that's listed is fine.
Yes, Your Honor.
Okay.
Diesel effect. How can he get off on the gun charges if we know he was carrying it and admitted to carrying it? It's up to the jury. You never know what the jury will say. In my opinion, can he beat it that while because he admitted to it? That's far-fetched. And even if he did, how was that in furtherance of the gang? So that separate charge, yeah, he might be convicted of. But for Jack Gotti, he shouldn't be affected. He should not be affected, but he can be affected.
Okay. Venue for conspiracy to commit a crime. Other than RICO, nobody's charged with conspiracy to commit a crime as like a separate offense, are they?
No.
So do we need this charge? Venue for conspiracy to commit a crime?
We would not seem to.
I don't think so either. Okay. All right, I need verdict forms or suggested verdict forms for 1.60.12, multiple defendants all, and it says adjust. Do we want that at all? What is anyone proposing on that?
I don't want it at all. Because I believe that is, I think that's covered in the next,
I mean, I'm going to tell them determine guilt or innocence of each defendant separately.
I don't believe that this is necessary.
Okay.
I'm sorry, which part is that?
1.60.12. Do we need that? That's way too high here. It's, the defense is no longer requesting it if they ever did. Is the state still requesting that?
You said 1.60.12.
Yeah, right. Given that we're given the charge below about assessing the evidence against each defendant that the state requested.
Yeah, we don't need 1.6.
All right. All right, assessing the evidence. It appears the state requested it. The defense is fine with it. And I assume the state still wants it, given that you requested it. Okay. Court has no interest, no sympathy. sentencing, responsibility for, state questions why I don't want to give that. Because if I'm telling the jury, don't concern yourselves with punishment, then why am I telling the jury anything about punishment? It's like, don't think about an elephant.
Because
It also seems to suggest that there's likely to be
I think because human nature, people will think we don't instruct them that they're not charged with what happens after the guilt innocent phase. And I think that's why this jury charge is important, because they may, in my experience, sometimes think about sentencing and think about what happens after this point, and am I responsible for that? So I believe letting
So if
them
they ask us that, then we'll say, don't concern yourselves with that.
I think innately, especially with a count like murder, where people know what the penalty is. That's typically what the request.
People think they know what the penalty is.
Right, but I guess because the people think they may know what the sentencing range is and what the penalty is, which is a life sentence. A lot of times that can come into how they view the evidence and things of that nature, and how it can be a factor in their decision making. Which is why we request it.
To me, that's covered in sympathy. They're not supposed to have sympathy towards.
Okay, well, I don't ever give it, and I'm not giving it here. If they're not supposed to think about it, then I'm not raising that for them to then think about. All right, and nobody has any issue with deliberations or unanimous verdict. There's a note, state will be adding additional charge on consciousness of guilt flight. Do y'all have that ready?
It's not permissible.
Okay, well, we'll need to get that.
We're not.
Oh, you're not going to do it. Okay.
It can be argued, but yeah.
Okay.
Of course not to the charge on it. Defense requested.
All right, so jumping back up to wherever knowledge was. I don't know where it was. I think it might have been before the RICO charges.
Page 19.
Yeah, page 14310 on 19.
Okay, thank you. All right, so it seems that the knowledge that would be necessary for the drugs and the guns is explained within those kind of possession charges. Do y'all agree? Or what do y'all think?
Okay, we seem to be final stretch of today's stream. Now is the time. If you want to do some monetary support of this channel, I would not disagree with it at all. You can do it via PayPal, Super Chat, or gift membership.
I understand that you.
Or if you don't have the means, just hit the thumbs up and subscribe if you haven't, and check my videos where there are some ads. That way I get some ad revenue. Okay, thank you.
Applies to.
The murder, the drugs, and the guns. Did I leave anything out? No, I left out the RICO.
And the gang, which.
Well, the gang is.
It wouldn't even make sense for the gang.
No, so the murder, the drugs, and the
Okay,
guns.
so knowledge on the part of the defendant that the crime of murder, I mean, I think it might be appropriate here to say murder in count, whatever, murder in count, whatever, possession of whatever it was, drugs in count, whatever. Do y'all think? Was being committed, and that the defendant knowingly and intentionally participated must be proved by the state beyond a reasonable doubt. If you find that they had no evidence that the above listed crimes were being committed, or that the defendant did not knowingly and intentionally participate or help in the commission of the alleged offense, I don't think we need conspirator there, because conspirator gets covered in the RICO.
Yeah, we don't need that.
Okay. On the other hand, should you find beyond a reasonable doubt that the defendant had knowledge that the crime of, list them again, and that the defendant knowingly helped or participated, then you would be authorized to convict the defendant of that count. I'm going to add that.
Yes.
Okay.
Thank you.
All right. Anything else we said we were coming back to? Obviously RICO, but anything else?
I sent a proposed charge to Ms. Birchfield and counsel as it relates to count 51, Mr. Subsection B.
Thank you, Jessica. Gifting 5 memberships. Bringing up the total to 14 of the stream. Thank you so much, Jessica. Thank you so much. Now you who have been gifted have access to all my members-only content. All the members-only perks. Thank you so much, Jessica. That is so nice of you.
And I sent a proposed charge as it relates to that count. It's not covered by the pattern.
That being gang?
So the pattern covers 1615-4A. It doesn't cover B.
Isn't that in our gang? It's, if you look at what's there.
I'm sorry.
I did, where is it? Yeah, there's, to prove a violation of subsection A of the Gang Act as alleged in counts 50 and 57, statement
Jaco.
show, blah. To prove a violation of subsection B of the Gang Act as alleged in count 51, the state must show it's all of those plus in order to, there's an additional element number 4 in order to maintain or increase his status or position in the gang.
I'm sorry, Judge.
This covers that, right? Okay, that's okay. All right, anything else?
Could I have 5 minutes before you bring the jury out, Your Honor?
Yes, I
Thank
mean,
you.
we've got, oh, right. We told them 10. Do we know whether they're all here? They're not all here anymore. So yes, you can have until they get here.
Thank you.
All right, folks. And the rest I have covered from the beginning of this. Now, this is a commentary channel. I could probably have done this in much less time, but I comment and I have so many words. I have had so many words today. And I do have the 3 highlight videos that I pulled out from this stream. They are on my channel. If you want to really want to see me go all haywire, then just check those videos out. But what a day. The state rested their case. The defense, at least now, said to the judge they will not put up a case in chief, which means no rebuttal from the prosecution. They can't, and this might be another reason why they won't put up a case in chief. That would make them try to salvage what they did under Judge Glanville. And the defense wants those appellate issues still here in this trial. So that might be another tactics. And also, one of the things that I now can tell you guys is they want the guys home for Christmas. They want the guys home for Christmas. And now, would it have been better to hand this over in December to the jury? Yeah, maybe, but yeah. Still, have the guys home for, because folks, being home for Christmas is embedded in us. No matter what your line of work is, if you're in the service, being home for Christmas is important. Every father, every man with a family wants to be home for Christmas. Every partner, every woman or partner or otherwise wants their man home for Christmas. That's embedded in us. That is one of the reasons. I do believe they will bring that in somehow. Getting close to Thanksgiving might not have the same effect because we don't have Thanksgiving here, but I heard a lot about Thanksgiving and the disasters that are around Thanksgiving. But still, yeah. I mean, songs. I'll be home for Christmas. Daddy, come home for Christmas. All the songs, all the Christmas movies. Everything boils down to be home for Christmas. So that is, yeah. So that might also be one of the reasons why they won't drag this out. Because if they put up even a week of defense case in chief, that will give the prosecution the ability to spend 3 more months on rebuttal. Now they won't. They have no way of taking away the damage that was done during Judge Glanville. All right. I don't know if they will stream something tomorrow. I don't think so, but you never know. If they will, I will do a recap. Thursday is the important thing. Listening to jury instructions, the curative instructions. Jesus Christ. And maybe the beginning, or maybe even the all of the closing arguments. Don't know. And then we will be on verdict watch. But until tomorrow, I need to go to bed. It's almost 1 a.m. here. And me and Mr. Jingles bid you give you a thank you for today. Thank you for allowing me to do this. Thank you for being here day after day. Thank you for allowing me to try to translate and make this somewhat understandable, and with a lot of snark and a bit of humor, get us through this. Thank you for allowing me to do that. Mr. Jingles, our head honcho for the Mr. Jingles Viking Thugs, say until next stream or video, and I'll see you tomorrow. Have a nice day, folks, and remember, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Okay? Bye-bye. No! I forgot. I'm so sorry. Thank you to the Naughty Brunette for gifting a membership. Thank you to L. Allen for Mods Appreciation Thursday, $5 super chat. Thank you to Brooklyn for gifted a membership. Thank you to No Weapon for Me Dies Me for gifted a membership. Thank you to John Schön for gifting 5 memberships. Thank you to Patrick for being a new member. Thank you to Liz Bird for your £2. And thank you to Jessica for gifting 5 memberships. Thank you. You guys make this worth it. All of you. Give me the thumbs up, subscribing, and some monetary support along the way. Thank you, guys. All right, now I'm done. See you tomorrow. Or, yeah, see you in the next stream or video. All right. Bye-bye.